How are you? Good to see you. Oh, well, thank you. I realize I'm like exactly here, a little more than here. Our first conference. Very good to see you. How are you? Fortunately, we have progress still sort of in the same place we were then. You know, I'm based in Manila, although I'm here for the 4 hour flight. Yeah. Well, I'm there for Are you from the original? Well, I'm from Boston. Buildings are very much like oh yeah, the drummer gets old and you're with her. Oh yeah. I like Fort Decent actually. I told you not somewhere else. All right, oh, good morning. I allow him. Yeah, I'm happy that I got things. Oh, yeah.
Oh, yeah. Nice to see you. Yeah, how are you?
Doing okay, doing okay.
Did I give you my card? Not yet. Very nice. Yeah, and congratulations. I understand you recently came back into your role. Oh, wow, wow. Okay, well, you must be at the from the fire hose stage, you know, but thank you for making time. Yeah. Yeah. Maybe get some water. I'm sure we'll be talking about it.
Some water. Yeah. Oh, yeah. Yeah. I know. And if we want that coffee break.
Good morning, everyone. If I could ask that you please take your seat so that we can begin. Okay, very good morning to all of you, and thank you very much for joining us here in Tokyo at the Asian Development Bank Institute. We're gathered here today today and tomorrow for the second Alternative Dispute Resolution Policy Dialogue hosted by the ADB Institute and the Office of the General Counsel for the Asian Development Bank. So this year, the theme will focus on institutionalizing mediation and strengthening investor-state dispute settlement management systems. So before we begin, I'd like to go over some housekeeping announcements for our in-person participants. So again, we ask that you please be mindful and be sure to be punctual and in your attendance and remain in the session until the end. If you have to take any calls, we ask that you please go to the room next door to take those. We encourage you to engage actively and respectfully in all of the discussions. And please wait until the end of the session to ask your questions. You're welcome to use the information from the discussions, but please do not disseminate them publicly or reveal who made any particular comments. There's no eating and drinking allowed in this room other than bottled water or bottled beverages. So please consume all your drinks and refreshments in the break room next door. For restrooms, they are in the hallway, just if you exit at the back of the room. And if you need a prayer room, please see one of my colleagues from ADBI. For our online participants, so this is, I would like to remind you that this is a hybrid event. So we have about 110 participants registered online, as well as some speakers who will be joining us virtually. So for those of you online, again, while you're free to use the information from the discussions, please do not disseminate this publicly or reveal who made any particular comments. And if you have any questions, please type them in the Q&A box on Zoom. So by joining this event, you agree to this disclaimer that it may be photographed, streamlined, or video recorded. By attending and accepting connection or continuing participation in the event, participants thereby consent to the possible use of their name, likeness, voice, spoken or written comments, papers, presentations in whatever form in all media publications, video sharing websites, recordings, disseminations, or other external affairs purposes for the Institute without compensation or permission. And so quickly go through the agenda for today. So the first day will focus on institutionalizing alternative dispute resolution in the context of ISDS. The first session will focus on institutionalization of ADR and ratification of the Singapore Convention on Mediation. We'll have lunch and then 3 sessions, one on practical measures to promote the use of mediation, mediation in state-to-state disputes, and finally, prevention of investor-state disputes. And at the end of the day, we'll have an informal discussion session or country sharing on ISDS best practices. You are welcome to join. It is an optional part of today's agenda. So without further ado, I'd like to introduce, we will have 3 distinguished guests to deliver our welcome remarks this morning. The first one is Dean Bambang Brodjonegoro. Unfortunately, Dean Bambang traveled to Washington, D.C. for the IMF World Bank Spring meetings, and he's on his way back as we speak. So he will be joining us in person tomorrow. So this morning, we will be playing his recorded remarks. So Dean Bambang is an Indonesian national, and he is the Dean and CEO of the ADBI. Before joining ADBI in April 2025, he was the special advisor to the President of Indonesia for Economic Affairs and National Development. Prior to that, he served the government of Indonesia in several senior leadership roles, including the Minister of Finance, Minister of National Development and Planning, and the Minister of Research and Technology. So, can I ask my colleagues to please play his remarks?
Very good morning. Ohayo gozaimasu. Distinguished speakers and participants, on behalf of the Asian Development Bank Institute, it is my great pleasure to welcome you to the Tokyo for the second policy dialogue on institutionalizing mediation and strengthening ISDS management system. We are honored to co-organize this event with the Asian Development Bank, bringing together senior government officials from 16 countries, as well as experts, practitioners, academics from across Asia and Pacific. I would also like to extend a special welcome to Mr. Thomas Clark, General Counsel of ADB, Mr. Jose Ma R. Palaganas, Executive Director of the Office for Alternative Dispute Resolution of the Philippines, Ms. Anna Joubin-Bret, Secretary of UNCITRAL, Ms. Martina Polasek, Secretary General of ICSID, and Ms. Claudia Solomon, President of ICC, International Court of Arbitration. Your leadership and continued engagement are instrumental in advancing dispute resolution frameworks in our region. As we gather today, it is important to reflect on the strong foundation established during the inaugural policy dialogue last February. At that time, we recognized the growing importance of ADR as a practical tool to support economic development and regional cooperation and integration. As cross-border trade and foreign direct investment continue to expand, the ability to resolve dispute in a timely, cost-effective, and predictable manner has become increasingly critical. In this context, ADR plays an important role in strengthening investor confidence and creating a more stable and conducive investment environment. Building on that foundation, this second dialogue marks a shift from awareness to institutionalization. Over the next 2 days, Our discussion will focus on both mediation and investor-state dispute settlements, or ISDS, with a view to strengthening legal frameworks and enhancing the institutional capacity of governments to manage disputes more effectively. On the first day, we will revisit the progress made since our first dialogue, particularly in relation to the Singapore Convention, and discuss practical steps to further institutionalize mediation, including legal and institutional frameworks, capacity building, and efforts to promote the use of mediation. On the second day, we will turn our focus to ISDS. As investment disputes become more complex, there is a growing need for governments to develop more structured, coordinated, and sustainable system for ISDS management system. This discussion will provide timely responses to these challenges and strengthen the capacity of governments to prevent, manage, and resolve investor-state dispute. Lastly, a key milestone of this dialogue is the introduction of the Asia-Pacific ADR Joint Network. This initiative will serve as a platform for continued collaboration and knowledge sharing, supporting the broader adoption of ADR practices across the region. As we emphasized last year, ADR is not a one-size-fits-all solution. Its effectiveness depends on how well it is adapted to each country's legal and institutional context. In this regard, the exchange of experiences and practical insights among participants will be essential. The expertise gathered here is truly remarkable, and I'm confident that our discussion will help identify practical pathways to strengthen dispute resolution systems across Asia and the Pacific. I wish you all productive and engaging dialogue, and I hope that you will learn from one another. Thank you very much.
Next, I would like to introduce Mr. Thomas Clark. He's the General Counsel of the Asian Development Bank, which is the co-host of this event. Mr. Clark has over 30 years of experience in legal and government affairs practice spanning the financial services, energy, and infrastructure sectors, as well as Americas, Asian Pacific, and European regions. Most recently, before joining ADB, Mr. Clark was Managing Director and co-head of the Americas for the Global Public Policy Group of BlackRock. As General Counsel of ADB, Mr. Clark is responsible for driving legal strategy and engagement on regulatory policy and reforms to support ADB's mission of achieving a sustainable, prosperous, inclusive, and resilient Asian Pacific region. So the floor is yours, Mr. Clark.
Thank you very much for that kind introduction. Distinguished delegates, colleagues, and I will say friends, because we are really involved, I think, as friends in this important endeavor. It is a great honor to welcome all of you to the second Alternative Dispute Resolution Policy Dialogue, which has been co-organized by the Asian Development Bank Institute and the Asian Development Bank's Office of General Counsel Law and Policy Reform Program. And I'm really delighted to see, both here in the room and virtually, such a strong and diverse community gathered here today: government officials, judges, ADR practitioners, international institutions and development partners, both in Tokyo and virtually. Let me begin by expressing my deep appreciation to Dean Bambang Brodjonegoro, Deputy Dean Byung-Sik Jung, and the outstanding team, our wonderful partners at the ADB Institute. Their incredible efforts have made it possible for this important and timely dialogue. This builds on, of course, the strong momentum from our first ADR policy dialogue held, I can't believe it, in February last year. 14 months have flown by, and I would be a little bit scared by that, except that so much progress, so much momentum has happened and has been building. And it reflects our shared commitment to strengthening dispute resolution frameworks and capacity across the Asian Pacific. I also would like to thank and congratulate Attorney Jose Palaganas, who was just recently appointed as the Executive Director of the Office of Alternative Dispute Resolution of the Department of Justice of the Philippines, for joining us in Tokyo. As I was saying to you before, I know when you're in a new job, you're drinking from the fire hose of so many new things and challenges, and to take time out during this very, very busy period of transition and join us here, I think bespeaks your commitment to what we're doing here. So thank you very much indeed. Now, we are at a pivotal moment. Across the region and globally, we're witnessing heightened geopolitical tensions, growing economic fragmentation, and increasing complexity in cross-border trade and investment. Yet for Asia and the Pacific, cross-border commerce, direct investment, and regional integration remain central drivers of development. All of this development depends fundamentally on trust. Trust of many kinds. Trust that contractual commitments will be honored. Trust that disputes will be resolved impartially, efficiently, fairly. I guess these days I should also add peacefully. Trust is important, and trust that outcomes, whether arbitral awards or mediated settlements, will be enforced across borders. When dispute resolution mechanisms are slow or uncertain or overly adversarial, the costs are immediate and tangible. Delayed infrastructure projects, rising transaction costs, investor hesitation, lost economic opportunities, burdens, unfortunately, that fall most heavily on developing economies, those who can least afford those burdens. Your presence here today reflects a shared understanding that effective dispute resolution is not peripheral to development. It's not some nice to have. It is foundational to development. You know, I get asked, why do we at the Asian Development Bank Office of General Counsel, spend time focusing on not just, legal review of contract for financing or loans? Why do we focus on law and policy reform and things like promoting arbitration? Because it isn't peripheral to development. It is critical to our development mission. In fact, I think that when you think about policymakers and public institutions, they need credible frameworks for ADR, not just abstract legal constructs, not just words on the page, but things that actually work. They underpin market confidence, influence investment decisions, and most importantly, shape long-term growth trajectories in developing countries. So for ADB developing members, alternative dispute resolution has indeed become a strategic tool in strengthening the investment climate. Effective ADR reduces risk. It supports the bankability of infrastructure and public-private partnership projects, and it enables governments to manage investor-state disputes in a manner that's both legally sound and financially and fiscally responsible. In doing so, it directly supports key policy objectives that are central to the broader mission of ADB: mobilizing private capital, facilitating cross-border trade and investment, and sustaining development outcomes. So at ADB, we view ADR not merely as an alternative to litigation, although it of course can be that, but as a practical policy instrument. When used well, ADR actually preserves commercial relationships and prevents disputes from escalating into broader economic or even political and diplomatic challenges, and it reinforces regulatory stability. Importantly, it can also expand access to justice and strengthen the rule of law in ways that are responsive to development realities. Now, the second ADR policy dialogue takes place against a backdrop of increasing legal fragmentation. Divergent national approaches to dispute resolution, if left undressed, risk undermining all that we've done to build investor confidence. It can destabilize cross-border transactions. And in this context, I would argue that the coherent and consistent application of international standards, including UNCITRAL instruments, is not just desirable, it is essential. It safeguards legal certainty and supports regional economic integration, ensuring cross-border trade and investment can continue to flow despite the escalating political and economic uncertainty that we see. Now, ADBI and ADB Law and Policy Reform Program's Alternative Dispute Resolution Program is designed precisely to address these challenges. Together, we are not just staying at the level of the legal theory, but we are practically equipping government officials, legal practitioners, judges, and other stakeholders with practical tools to navigate commercial, investor-state, and state-to-state disputes. This includes examining the interaction between domestic frameworks and international instruments, such as the New York Convention and the Singapore Convention on Mediation, and how countries and institutions actually translate these standards into predictable, enforceable outcomes. I mean, I'm getting a little bit of deja vu here because I'm sure I remember standing at this podium when we were last here a year ago and talking about, the game plan for, are we going to just pass the convention? No, that's necessary, but not sufficient. We need to move to actually implementing it into law, and even beyond that, into actually socializing it with the lawyers, with the business people, so that it doesn't just become a wonderful treaty in the books or even laws on the books, doesn't even become something that's a thing you can use, but something that you do use because it becomes socialized with the very, businesses, with the capital that's waiting to be invested. If it isn't doing that, it's not living up to its potential. Now, allow me to briefly share how ADB is contributing to this agenda. We recognize that sound legal systems and effective dispute resolution mechanisms are indispensable to private sector development. And through our technical assistance and capacity building programs, we support ADB developing members in strengthening their ADR ecosystems, aligning national laws and international standards, building institutional capacity, and training those government officials, judges, entrepreneurs, and users. Why does this matter? Because it isn't just a legal theory, it's a development issue. And when investors and businesses have confidence that disputes can be resolved efficiently and settlements and awards will be enforced, they're more willing to invest, more willing to innovate and create jobs. A particularly important focus for ADB is strengthening capacity around international investment agreements and investor-state dispute settlement. As you know, over recent decades, the region has seen a sharp increase in IAAs aimed at promoting investment and regional integration. And indeed, regional economic integration is a major priority of President Kanda at ADB. At the same time, ISDS has become more complex, costly, and politically sensitive, particularly as governments pursue legitimate regulatory objectives linked to the Sustainable Development Goals. Now, to support this developing members countries in these situations and helping them navigate this evolving landscape, our Law and Policy Reform Program launched a multi-regional technical assistance in 2023. And this program supports officials involved in negotiating and implementing these international investment agreements and managing investor-state disputes. And I think this is something that ties in very closely to the joint network that Dean Bambang mentioned in his very eloquent welcoming remarks as well. This is all about how do we keep the momentum moving forward. So let me briefly turn to mediation in the Singapore Convention. Mediation brings a distinctive and increasingly valuable dimension to the dispute resolution toolbox. In many ADB members, mediation is deeply rooted in local legal traditions and social norms. Businesses increasingly recognize its advantages: speed, flexibility, cost effectiveness, and the ability to preserve relationships in commercial disputes and increasingly in investment contexts generally. The Singapore Convention significantly strengthens the whole value proposition of mediation by providing confidence and cross-border settlement agreements can be enforced internationally. Mediation also plays an important role in early dispute management, particularly in the investment context. It encourages earlier engagement, better coordination among government stakeholders, and timely resolution. Now, the uptake of the Singapore Convention among ADB's developing members has been very encouraging, as has engagement by their trading partners. But as I said, ratification is only the first step. Effective implementation, including domestic enabling legislation, and as importantly, institutional capacity to use it, is essential. And ultimately, sustained use of mediation will depend on confidence from the international business community and the practical effectiveness of national frameworks. This underscores exactly the importance of why we're here. Continued collaboration among governments, among the development partners, and the international ADR community. All of this is absolutely vital to strengthen the legal regimes and build capacity. Let me close by just looking ahead at the nature of disputes in the 21st century. It is a rapidly evolving environment. Digitalization, complex supply chains, climate-related regulation, shifting investment patterns, and we see that in the news. All dispute resolution systems that are agile, transparent, and fair are demanded by this complex and evolving situation. So the discussions over the next few days on institutionalizing mediation, on strengthening ISDS management, on implementing UNCITRAL instruments, and on leveraging innovation and responding dynamically to the rapidly evolving environment, all of these are going to be critical, and they will reflect, to the extent that we do it, a shared vision for a more resilient and a more inclusive dispute resolution ecosystem. ADB stands ready to continue working with all of you to advance this vision. Let us support governments, let us empower ADR practitioners, and let us ensure that alternative dispute resolution remains a cornerstone of sustainable development in the Asia-Pacific region. With that, I wish all of you a productive and engaging dialogue and look forward to our discussions over these coming days. Thank you all very much.
Thank you very much, Mr. Clark, for those remarks. I think we're all inspired and motivated to be here now, and the important work of that ADB is doing for ADR and to promote ADR and mediation. So next, I'd like to welcome Attorney Jose Palaganas, the Executive Director for the Office of Alternative Dispute Resolution in the Department of Justice of the Philippines. Attorney Palaganas is a legal and public sector professional. In his role as the executive director, he leads the development and implementation of policies and programs that promote mediation, arbitration, and other alternative dispute mechanisms to improve access to justice and decongest the courts. So please, Attorney Palaganas.
Again, good morning to all. So to the officials of the ADB and ADBI, distinguished representatives from partner institutions, including the United Nations Commission on International Trade and the International Center for Settlement of Investment Disputes, esteemed colleagues from government agencies across Asia and the Pacific, fellow practitioners and experts in alternative dispute resolution, and valued participants. Again, mabuhay and a pleasant day to all. It is with great pride and honor that the Office for Alternative Dispute Resolution, an attached agency of the Department of Justice in the Philippines, joined this policy dialogue as organized by the ADB in collaboration with ADBI under the ADB-ADBI Alternative Dispute Resolution Program. As the Philippines serves as chair for ASEAN, which acknowledges its pivotal role in advancing regional cooperation and creating an enabling environment for sustainable development, including alternative dispute resolution. This role underscores our collective dedication to enhancing systems that foster trust, stability, and predictability across borders, especially with a more interconnected economic environment. In Asia and the Pacific, the increasing intricacy of cross-border trade and investment highlights the growing significance for alternative dispute resolution, especially mediation. ADR provides a practical, efficient, and amicable method for resolving disputes without engaging in lengthy and adversarial litigation. More importantly, mediation safeguards commercial relationships, lowers transaction costs, and grants parties greater control over the outcomes. In a region where investment flows continues to expand, these advantages are not only beneficial, they are essential. In the Philippines, we have consistently translated this commitment into concrete capacity building efforts. Since 2020, when the Office for Alternative Dispute Resolution became an independent agency, we have trained more than 2,300 individuals in mediation and accredited more than 300 mediators across the nation. These figures demonstrate our continued commitment to establishing a robust and accessible mediation ecosystem capable of meeting the growing demand for ADR across varied sectors, including complex commercial and investment disputes. In this regard, the Philippines fully supports the wider adoption and effective implementation of the Singapore Convention on Mediation. The convention marks a major advancement in international dispute resolution by strengthening enforceability of mediated settlement agreements across borders. We strongly encourage greater regional participation in the convention in order to further enhance confidence in mediation and ensure consistency in cross-border dispute resolution practices. Its wider adoption in the region will further bolster confidence in mediation, promote greater reliance on alternative dispute resolution mechanisms, and help a more predictable and secure investment environment. This is closely linked to the role of ADR in facilitating trade and investment across Asia and the Pacific. Efficient dispute resolution systems serve not only as a legal infrastructure, but also as economic enablers. They mitigate risks, bolster investor confidence, and facilitate smooth cross-border transactions. In turn, they enhance regional economic integration and bolster our shared goal of inclusive and sustainable growth. In ASEAN, ADR plays a vital role in advancing cooperation and ensuring that our regional frameworks remain responsive to evolving economic realities. They mitigate risks, bolster confidence, and facilitate smoother cross-border transactions. As ASEAN chair, the Philippines continues to support initiatives aimed at promoting harmonization, capacity building, and institutional strengthening of ADR. ASEAN will continue to advance collaborative mechanisms, policy alignment, and knowledge sharing platforms to foster a more coherent and enabling environment for ADR across member states. We acknowledge that a stable and predictable dispute resolution environment is essential for deepening regional integration and strengthening ASEAN's competitiveness as a unified investment destination. We also recognize the need to bolster investor-state dispute resettlement management systems, focusing on prevention, early engagement, and coordinated government responses. These elements are essential for managing disputes strategically and consistently. While considering both legal obligations and public policy considerations, in this context, we look forward to the continued development of the ADR Joint Network as a platform for collaboration, knowledge sharing, and capacity building across jurisdictions. We envision the ADR Joint Network as a key mechanism for promoting coordinated regional efforts, developing common standards, and strengthening institutional linkages among participating economies. The Philippines is fully committed to actively participating in and supporting this network, and we anticipate that it will play a central role in promoting the systematic and sustained development of ADR across the ASEAN region. With the goal of promoting the systematic development of ADR in the region, we view this as a chance to coordinate efforts, disseminate best practices, and enhance institutional connections between ASEAN member states and our wider regional partners. As ASEAN chair, the Philippines reaffirms its commitment to advancing regional cooperation in ADR through sustained dialogue, technical collaboration, and policy innovation. We believe that by collaborating, we can construct a more coherent and effective ADR ecosystem, one that promotes economic resilience, instills investor confidence, and adheres to the principles of fairness, efficiency, and mutual respect. As I end, we extend our gratitude to ADB and ADBI and our partner institutions for organizing this timely and meaningful dialogue. We look forward to translating today's discussions into concrete actions, one that will further strengthen ADR systems across Asia and the Pacific. Through ADR, we can resolve disputes while simultaneously building trust, strengthening partnerships, and enabling development. Once again, thank you and have a good day.
Thank you very much, Attorney Palaganas. Okay, so now we will take a quick group photo. The quicker we can do it, then the more time we will have for coffee. So the front row here, I'll ask you to scoot back a little. You can stay seated though. And then we'll have one row standing behind this front row, and then 2 rows on the stage. Okay, because we need to try and fit. I think we have about 80 people here.
Thank you.
Yeah.
Okay, because I sent you a presentation and I forgot to attach the report of the whole research.
Okay.
So I wanted to add a slide. Should
Okay.
I send you my email?
Yes. Yes, sure. Thank you. Okay, so you can grab a quick coffee in the room next door. About 5 minutes. And remember, please, no coffee back in this room, only in the room next door.
Wait, let's get out. This? Oh, okay.
Okay, thank you very much for coming back on time. I know it was a quick break, but we have a very packed schedule today. Lots of engaging discussions awaiting us. So today's keynote speech will be delivered by Ms. Anna Joubin-Bret. She is the Secretary of the United Nations Commission on International Trade, UNCITRAL. She also serves as Director of the International Trade Law Division in the Office of Legal Affairs of the United Nations, which functions as the substantive secretariat for UNCITRAL. So unfortunately, Secretary Joubin-Bret is not able to join us live due to the time difference, but she will be joining us tomorrow for a fireside chat. So for today, we will play her recorded remarks.
A very warm welcome from Vienna. It's a privilege, distinguished ministers, colleagues from governments and international organizations, esteemed practitioners, scholars and friends, to welcome you to this second ADR policy dialogue here in Tokyo. I regret very much not being able to join you in person, especially as the discussion over the next 3 days is not only very timely, but essential for the future of economic cooperation and dispute management across Asia, the Pacific, and beyond. Nonetheless, you are in the very good and able hands of my colleague Jason. Today, on day one, we will focus on foundational principles, how to institutionalize mediation, how to strengthen ISDS management systems, how to build a more coherent, predictable, and cooperative regional approach to dispute resolution. And we will also discuss two instruments developed by UNCITRAL, namely the Singapore Convention on Mediation and the Toolkit on Prevention and Mitigation of International Investment Disputes. This dialogue format is not an academic exercise. It's a practical response to a rapidly changing landscape of cross-border investment, trade, and regulatory transformation. It also reflects the recognition that the tools we have relied on in the past are no longer sufficient on their own. The region is one of the world's most dynamic hubs for investment and trade. In this environment, disputes are inevitable. What matters is how they are managed and solved. Traditional arbitration remains indispensable. That's no longer the only or even always the best tool. The rising number of investor-state disputes, the cost and the duration of arbitration, and the political sensitivities of certain cases have pushed governments and investors alike to look for more flexible, interest-based mechanisms. And this is where mediation comes in. And this is why today's conversation is so important. On the Singapore Convention, let me give you a few pointers. The Singapore Convention is expected to do for mediation what the New York Convention has done for arbitration. It already has 21 state parties that have ratified the convention. It has been signed by further 41 states, indicating their readiness and support to ratify it. Its core principles are very simple. Mediated settlement agreements can be enforced across borders with predictability and full confidence. This is transformative. It elevates mediation from a voluntary contract to an enforceable, internationally recognized process. Yet, as the agenda notes, many economies in Asia have not yet ratified or operationalized the convention. And the reasons for that vary. Gaps in domestic legislation, limited institutional capacity, uncertainty among policymakers, or simply the need for more awareness among legal communities and the business community, of course. But the opportunity remains huge. Ratifying the convention is not just a legal step. It's a strategic signal to investors, to trading partners, and to the global business community that a country is committed to modern, efficient, and cooperative dispute resolution. Again, ratification is not enough. Institutionalization is required. It means that national laws must be aligned with the convention. Trained mediators must be developed or trained to inspire trust. Interagency cooperation is also required so that governments can use mediation confidently, and awareness among businesses and counsel that mediation is a viable first step and not a last resort is also important. These are the building blocks of a sustainable mediation ecosystem, and today's session 1 will explore them in depth. Despite its progress, mediation remains underutilized in practice. The barriers are not only legal, they are cultural, institutional, and sometimes even psychological. External counsel may be incentivized toward litigation or arbitration. Businesses may perceive mediation as a sign of weakness of their position. Judicial systems may not yet fully embrace mediated outcomes, and in some countries, there's simply a lack of visible and credible mediators. These are real challenges, but they're not unsurmountable. Countries that have successfully mainstreamed mediation did so through a combination of strong government leadership, clear procedural frameworks, integration with courts and arbitration centers, and sustained investment in mediators' training and professionalization. Session 2 today will examine these practical measures. The goal is not to promote mediation in theory or just as a tool, but to make it work in a real-world setting. Let me turn now to an area that deserves far more attention: state-to-state mediation. While mediation has gained traction in commercial and investor-state context, the use between states remains limited. However, one of the most difficult aspects is the information about what is going on and where a mediation is actually taking place. And yet, the need has never been greater. States today face disputes that are increasingly complex. They are overlapping treaty commitments, cross-border trade frictions, environmental and climate-related obligations, regulatory transitions that affect foreign investors and trading partners. Traditional dispute resolution methods remain essential, but they are not always the most suitable, especially for long-term cooperation, political relationships, and policy flexibility that are oftentimes at stake. And this is where state-to-state mediation can be transformative. The establishment of an international organization for mediation, also known as IOMED, in 2025 marks a historical step. The first institutional platform dedicated to mediating disputes between states, in addition to investor-state and commercial disputes. Its mandate is still being developed, and its operational boundaries are, of course, still to be tested. But its creation reflects the growing recognition that states need flexible, interest-based mechanisms to manage disputes before they escalate. The regional practice in this regard is also moving. The upgraded ASEAN Trade in Goods Agreement, the ATIGA, proposes incorporating consultation and mediation-based procedures into ASEAN's state-to-state dispute settlement framework. This is a significant step, one that could position ASEAN as a global leader in intergovernmental mediation. Session 3 today will explore these developments, and I encourage all participants to consider how regional experiences can come as a complement to global initiatives and how both can be strengthened through interinstitutional cooperation. Another theme of today's agenda is dispute prevention. The best dispute, as we all say, is the one that never becomes a claim. This is why Working Group 3 has worked steadily on developing and adopting a toolkit on prevention and mitigation of international investment dispute, which sets out good practices, examples of strategies and measures that have been adopted by states to prevent and mitigate investment disputes involving foreign investors, such as the use of early engagement with investors, an early dialogue, an open door for investors to present their grievances before they become an actual legal dispute, transparent and predictable government actions, interministerial coordination before and when a claim arises, and early warning systems that identify the regulatory risks before they escalate. Various models are, as outlined in the toolkit, have proven effective in several countries. And these are not theoretical concepts, but practical tools that governments can adopt and adapt to their reality. Session 4 will highlight these mechanisms and offer insights from countries that have implemented them successfully. Let me conclude by highlighting why today's dialogue matters. The work we're doing here, and I said that earlier in my introductory presentation, the work we're doing here is not abstract. It has real consequences. Every unresolved dispute carries costs: financial, political, reputational, and human, societal. Every escalation into arbitration consumes resources that many developing countries can ill afford. Every missed opportunity for early engagement erodes trust between investors and states. By strengthening mediation, whether commercial, investor-state, or state-to-state, we're not simply improving dispute resolution, we're enhancing the stability of investment environments, investment climates, supporting regional integration, and enabling governments to pursue policy objectives with greater confidence. The diversity of the participants in this forum, government representatives, international organizations, academics, practitioners, mediators, reflect the collaborative spirit required to advance ADR in the region. Together, through shared learning and coordinated action, we can build systems that are more resilient, more accessible, and more aligned with the needs of our economies. With that, I wish you very fruitful deliberations, rich and controversial discussions, and I send you our best greetings from the UNCITRAL Secretariat.
So thank you very much again to UNCITRAL and Secretary Joubin-Bret for these remarks. It really helped to set the scene for the next couple of days and especially today's 4 sessions. So highlighting how imperative mediation is in driving regional cooperation, integration, and also trade. So from signing to ratifying and implementing mediation, the next session, session 1, which will be moderated by ADBI's Deputy Dean Jung, it will focus on institutionalization of ADR and ratification of the Singapore Convention. So Deputy Dean Jung specializes in international development, international trade and investment, and international finance and international tax. And he's really the driver of ADR from ADBI, and I'm sure you'll see his passion for this topic over the next few days. Deputy Dean Jung previously served in several senior roles in the Republic of Korea, including Director General for International Tax at the Ministry of Economy and Finance, and Deputy Director General for the International Finance Bureau as co-chair of the G20 International Finance Architecture Working Group. So, Deputy Dean Jung, hand over the floor to you.
Okay, thank you, Derek. Good morning, everyone. Good morning. Okay, welcome to Tokyo. Welcome to ADBI. I'm very pleased to see someone visit 2 times last year and this time, and also someone newcomers. This session is institutionalization of mediation, especially as Thomas as a keynote speaker, and also Anna, welcome remark, and Anna as a keynote speaker, they pointed out what's the institutionalization of mediation. What do you in mind? What's the main elements for the institutionalization of mediation? The first is ratifying Singapore Convention. Indeed, it's a starting point because it's secure enforceability of a mediated settlement. That's first would be first starting point. What else? To preparing domestic legislation, domestic laws to state how to appoint a mediator, what kind of process they have to follow, and what's the computationality and what cost. Those things should be stipulated by the domestic law. That's the second thing. But that domestic law should be in alignment with international standard. So-called UNCITRAL mediation rules could be international standard. Therefore, it would be better for country to align their domestic law in alignment with the international standard. That's the second thing. What else? We have some ADR center like mediation center or arbitration center. That is also a very important element. What else? Capacity of the practitioners. They should know the value of mediation. Even judge should know the value of the mediation. Those things should go together. That's the major elements, but they should go together. That's the main picture of our whole discussion of the 2 days, our discussions. But this session, we are going to focus on ratifying Singapore Convention. For this purpose, I'm going to share this, reveal the secret, how much we have made efforts to reach out really great guys in the world. I've heard that from my colleagues. There are 3 very distinguished figures, legendary figures for ratifying Singapore Convention. They played a critical role to ratify this Singapore Convention. Actually, they are kind of mother who produced this Singapore Convention. The one is Timothy, he's an American guy. Another one is Natalie Morsi Sharma. She was a chair for the negotiation of the Singapore Convention. And another guy, fortunately, we have that person in person, Jae-sung Lee. He's working for UNCITRAL. We reached out individually. And finally, we succeeded in bringing 2 persons. One is from the online, one is from the in-person. You should enjoy the benefit. You should ultimately maximize the opportunity to use them because they are here. So let me first invite through the online, Natalie Morsi Sharma. As I mentioned, she is a chair, but currently she is a senior director, senior state counsel, International Affairs Division, Attorney General's Chambers. She contributed a lot from the first policy dialogue, and also she contributed intellectually to the in-learning course on ADR. Now, even though she is a busy schedule, she secured her time to attend this meeting for a presentation. She will share the significance of the Singapore Convention, the value of the Singapore Convention, why it is important, and also consideration for countries to take into account when it comes to ratifying Singapore Convention. This consideration element. And another one, after post-ratification, what country needed to do in terms of practicality, she will introduce those elements in her presentation. Let's invite the Natalie Sharma for presentation. Natalie, are there?
Hi, good morning. Yes, I'm here, and thank you so much for the kind introduction, Young-sik. I'm
Welcome to Tokyo, even though virtually. Natalie, do you hear us?
Yes, I hear you. Can you hear me well?
Please, you unmute.
No. Can you hear me?
Yeah, now slightly, but
okay.
Raise the volume.
Okay, I think it's maybe I'll speak more loudly. Is this better?
Yeah, good. Please go ahead.
Great. Thank you so much. And thank you for inviting me. I am very sad that I cannot be in Tokyo and to be with some old friends who I know are there in the room. and also with Byung-Sik and others from the ADBI who have done tremendous work on promoting mediation generally, but also the Singapore Convention on Mediation. So it's a pleasure for me to be able to join you, even though I joined virtually. I have some slides, which I'm happy to either share from here or to have it shared where you are in the room, whichever is easier. If you could just let me know how you'd like me to do this from the organizers.
You may do so, like this.
Okay, so I've sent a request to share the slide. Oh, there we go. You've got it from here. Okay, great. So these are, I just wanted to, I was asked to introduce the institutionalization, as part of the institutionalization ratification of the Singapore Convention on Mediation, some key points. And so next slide, please. Importantly, in terms of the significance and value of the Singapore Convention on Mediation, I will be covering a couple of points, including its purpose. We'll then go into the value of international trade, value for international trade and commercial relations, which gets into investor-state dispute settlement. And then finally, considerations for ratification and post-ratification. Next slide, please. Throughout the presentation today, I'll be assuming that you've got some level of familiarity with the Singapore Convention, but if you require any clarification later, there will be a Q&A segment and I'll still be online for that, as well as others in the room who know the convention well, like Jay, I'm sure will be able to answer your questions. So the Singapore Convention, in terms of its core purpose, it promotes it promotes uniformity. It creates a uniform and reliable international framework for the enforcement of mediated settlement agreements that arise from international commercial disputes. And it plays essentially a comparable role for mediation that the New York Convention does for arbitration. And it shifts essentially mediation from a soft dispute resolution option into an enforceable, internationally recognized mechanism, and does this by strengthening the party autonomy philosophy of mediation. Now, instead of needing to be first converted into a contract, court order, or an arbitral award with attendant attention to the detail that each of those require, and for which requirements vary across jurisdictions, what we see with the Singapore Convention is a mediated settlement agreement can be directly enforced and recognized in its own right. And this is particularly crucial in cross-border situations, which are the types of settlement agreements that are within the scope of the Singapore Convention on Mediation. In terms of the value of the Singapore Convention of Mediation in strengthening international treaties and investment agreements, that's the subject of my next slide. The Singapore Convention enhances certainty in cross-border commercial relationships, reduces legal risk, transaction costs for investors and businesses. It encourages efficient dispute avoidance resolution systems, and it also complements what we already have in some of the free trade agreements that we see today that have started to emphasize facilitative approaches. And essentially here, the Singapore Convention provides a bit of that backbone needed to make the commitments in a settlement agreement meaningful. And why does it apply to investor-state contexts? The reference to commercial in the Singapore Convention on Mediation includes agreements that involve government entities. That was part of the negotiating intention. And also you see one of the two reservations in the Singapore Convention are specific to government entities that may be part of that agreement. And this is because of the recognition that in reality, government entities do engage in commercial activities. They do seek to rely on mediation to resolve disputes in such contexts. And so this is why it is relevant in the context of investor-state complementing arbitration and litigation and leading to more meaningful commitments. Now, in the next slide, I've got considerations for ratification and post-ratification implementation. In terms of pre-ratification legal considerations, so what do you need to think about before deciding to ratify a treaty like the Singapore Convention? First, it's important to review how mediated settlement agreements are currently treated within the domestic law. Many jurisdictions might require some kind of alignment, for instance, in their mediation statutes and existing codes of practice, in their civil procedure rules on enforcement. There should also be an assessment of any constitutional limitations that affect treaty incorporation or judicial recognition of international obligations, and consider also the interaction with any existing regional instruments, particularly where enforcement regimes for mediation already exist. And when I included this point in the slide, I had in mind in particular the European Union context because of their mediation directive. As of now, I'm not aware of other regional instruments that would require this particular examination. In the next slide, we talk about the institutional considerations. Here, some of the things to think about that might be important to an effective implementation of the convention: designate or identify a national competent authority, which can be the courts or specialized commercial tribunals, and equip such authority with clear procedures to receive and assess applications under the convention. Strengthen your mediation centers. Consider also accreditation systems to ensure a consistent standard aligned with the expectations of the Singapore Convention. You might want to coordinate your institutions as well as coordinate the types of accreditation that are being issued. And build capacity amongst your judiciary, government, lawyers, trade agencies, and private mediators so that they understand mediation broadly, but also understand the Singapore Convention and its rubric, including things like the grounds for refusal. And in the next slide, some policy considerations. Some things to think about, also not an exhaustive list, but ensure national dispute resolution policies integrate with mediation as part of a comprehensive ADR system, so that mediation is not required to stand alone, and it often does not. You could even think about building mediation arbitration court pathways, which we have seen with some hybrid mechanisms, including in Singapore. Align the Singapore Convention ratification with broader national economic strategies on investment promotion, export development, rule of law commitments. The Singapore Convention sits very nicely within these narratives and within these efforts. And third of all, it's important to ensure that the benefits of mediation and of the convention and enforcement of mediated settlement agreements are well communicated to the relevant communities. And as part of this, it's important to address the concerns of your domestic bar or even notary publics in some situations who may have a particular role or a particular business model, and they would require a little bit of that dialogue to help them see how things can fit within their structures as well. And then very quickly onto the practicalities after ratification, which is on my next slide. The development of government-endorsed mediation protocols for state-owned enterprises is one possibility. You can also consider integrating Singapore Convention compliant clauses into your model contracts or procurement templates and investment agreements. Consider also outreach to foreign investors and business chambers to promote confidence in this new mediation regime. And of course, capacity building continues, a la what I mentioned earlier in the context of my earlier slide. So finally, in conclusion, on my last slide, the Singapore Convention bridges the domestic with the global. Domestic systems with global commerce. Ratification signals commitment to rule of law and efficient dispute settlement and dispute management. And also, effective implementation requires coordinated legal, institutional, and policy action. So please don't forget about those. Now, I was only given about 7 minutes to cover all of this. And I should also qualify that I deliver this completely in my personal and independent capacity, and be looking forward to the dialogue and the time together today. Thank you very much.
Indeed, indeed, she's a legendary person, right? She covered everything, even 7 minutes. The main takeaway from her presentation is the power of the Singapore Convention. Even the mediated settlement could be enforceable if the country ratified the Singapore Convention without going to consent arbitral award or judicial settlement. That's a big benefit. Because this is the significance of Singapore Convention, many countries are now interested in this one. And also, it also promotes investment and trade because, surprisingly, Singapore Convention could be applicable to the dispute between state to state and state investors. We'll discuss that elements further. Probably you might be interested in some curiosity or questions about this enforceability. even to state-to-state dispute and investor-state dispute. Actually, we already prepared that session. You will enjoy the discussion. You can address your question in this session too. Okay, without further ado, let me invite in person the legendary figure, another legendary figure, Jae-sung Lee. He is currently is positioning the Principal Legal Officer, International Trade Law Division Office, Office of Legal Affairs, United Nations, UNCITRAL. We invited him because every event regarding ADR, he appears. You know the value. He is really indispensable person to promote ADR. Actually, UNCITRAL is an international standard setter. He came from that organization. As Anna, rightly mentioned, that UNCITRAL played a critical role to disseminate these international rules, including Singapore Convention and the UNCITRAL mediation model rules. So you will have many questions to raise to him. Please enjoy his presentation. He will touch upon the recent progress of the Singapore Convention, because UNCITRAL has a statistic. Already Anna mentioned how many countries ratified the Singapore Convention so far. He will give you detailed information in this regard. And also how the UNCITRAL has supported countries for their ratification of the Singapore Convention or reform their domestic laws. Another one, UNCITRAL needed some collaboration. So what kind of collaboration UNCITRAL may expect? Another one, if the time is allowed, I would like to ask him in his presentation, what's the view, what's the prospect of a Singapore Convention from the perspective of UNCITRAL? If they have a bright picture, then we can enjoy, we can go further. If they have a gloomy picture, we have to consider. So we'll see. Okay, let me give the floor to the Jae-sung Lee, please.
Thank you, and good morning to everybody. As introduced, my name is Jae-sung Lee. Is it working? Okay. So my name is Jae-sung Lee, and it's a pleasure to be here. UNCITRAL values the coordinations that we have been having with ADBI in these kind of coordination efforts, and I just wanted to thank Byung-sik and the ADBI team for actually hosting us. While he said that I was legendary, I am a legend in the sense that I prepared the initial draft of the Singapore Conventions, but it was the member states that negotiated the Singapore Conventions themselves, so it was the states that were legendary. Now, if you're not persuaded by now on the importance and significance of mediation, I think we have to go home, because everybody said everything good about it. Thomas said something, Anna said something, and Natalie also highlighted the importance of the Singapore Convention. So let me give you a little bit of some things to think about as states implement the Singapore Conventions. These are questions that arose in the negotiation phase, but actually the questions that you have to address when you implement the Singapore Convention. Now, the first thing that you see on the slides, the good thing that we have done in the UNCITRAL context is that there is no need to reinvent the wheel. We have created an entire framework for mediations with legal standards that have been developed by UN member states. So this is a framework where you can rely on UNCITRAL standards for addressing a number of different aspects. They take different forms. Of course, we're talking about the Singapore Conventions. We have the law, we have the mediation rules, and the guidance text that can actually guide your work. Now, if you see, you'll see that as early as 1980, UNCITRAL developed the conciliation rules, which have now been renamed the mediation rules. So it's not something new. It has been there for a long period of time, but there has been a growing interest because of the Singapore Convention, which was the last missing piece. Now, Byung-sik mentioned that the first thing that you should consider is the Singapore Convention, but it was actually the last piece of the mediation framework that UNCITRAL was able to finalize, because there was not so much agreement on how to do cross-border enforcement of settlement agreements. There was a big debate. Even when we started work on the Singapore Convention, there was doubts about whether a convention would work or not. And this is why you'll see on the screen that in 2018, UNCITRAL adopted two texts at the same time. It was a model law on mediation as well as a convention. This was because the states were doubtful whether the Singapore Convention would be a framework that would work, because there was no practice of cross-border recognition and enforcement. And that is why they decided to test the waters with the model law and the convention at that time. And this is why you see two texts that have been adopted at the same time. On the recent status, you will see that the Singapore Convention has attracted a recent, most recently, have attracted attentions from those in the region. And you'll see on the screen that those in blue are those where treaty actions were taken in 2025, and greens are those where treaty actions were taken in 2026. We currently have 22 state parties and we have 41 signatories, meaning that these signatories probably are working on the ratification process of the Singapore Conventions. But it is also possible for those states that are not signatories to actually accede to the conventions by actually just becoming a state party right away. So we're hoping to assist with any states that are in that process, and you will come to us or to me, and then I'll be happy to provide any assistance. Now, I don't want to go into the details about the Singapore Convention. As you see on the screen, it is very simple. There is only 16 articles, with the articles on the right, which are typical provisions, final articles that you find in multilateral conventions. It is the left side that is of more interest to you, and I just want to touch upon some of the key provisions. The first provision is on what is the scope of the Singapore Conventions. It is an international settlement agreement resulting from mediations. And I think one of the questions that you'll get in the implementations of the Singapore Conventions, specifically from the courts and the judges, is what's so different from a settlement agreement from a contract? And this was the question that arose in the context of the negotiations. How do you differentiate a contract from a settlement agreement? Now, of course, there's a distinction between a settlement agreement and an arbitral award in the context of the New York Conventions. But we had to actually address that first questions of how judges would you need to distinguish between a contract, a normal contract, which may have resulted from a negotiation, and a settlement agreement, which resulted from mediations. Now, of course, there's some caveats. It doesn't actually apply to consumer disputes, and it does not apply to settlement agreements which are enforceable as a judgment or as an arbitral award. This was to avoid the duplications of enforcement where parties can go to court as a settlement agreement or as an arbitral award. So these were the scope issues that we had to address. The obligations that the Singapore Convention poses on the states is quite simple. You have to enforce the settlement agreement, and you have to allow a disputing party to invoke a settlement agreement. And this is quite similar to what you have in the New York Convention as in the recognition of a foreign arbitral award. But as you cannot recognize a settlement agreement, we had to use a different word, and that's why you see invoke on the article. Article 4 sets out the basic conditions for state parties to actually submit a settlement agreement to a competent authority or a court. And Article 5 is similar to Article 5 of the New York Conventions by providing some safeguards on grounds for competent authorities to refuse the enforcement of the settlement agreements. It takes into account some of the nature of the mediations, as you see, the incapacity of the parties, issues that arise with the settlement agreements, the obligations therefore not being clear. And of course, the last part is quite similar to the New York Conventions, where the grant of relief is contrary to the public policy, or the subject matter is not subject to mediations in the country of enforcement. Now, another safeguard we have in the Singapore Conventions is the possibility to make reservations. A state that when they becomes a party to when they sign or when they become a party is able to declare that the following two types of settlement agreements are excluded from its scope or subject to different conditions. The first one is when the state or its government agency or person acting on its behalf is a party. Now, this is probably, you probably know in the context of the New York Conventions, there's a reciprocity reservations. And this kind of comes from there in the negotiations process, because there was a tendency that if I were to become a party to the Singapore Conventions, most of the assets that are in that state would be the ones that are enforced, and therefore it is the government agencies that are parties to it that may be subject to the enforcement when the other party is not a party to the Singapore Conventions. So this is kind of arising from that considerations, and a number of states have actually made declarations to this context. The second is actually when the Singapore Convention was not known, it is possible that the disputing parties, when they sign a settlement agreement, are not aware of the Singapore Conventions. Now, all of the events that we're having have made it known that Singapore Convention exists, so everybody kind of knows, but it is actually not the case for disputing parties. So to protect those parties from being subject to an enforcement process, this is the second reservations where the parties to the settlement agreement have agreed to the applications. They have to explicitly agree to the application of the Singapore Conventions in order for it to be subject to the convention. So I think these were kind of safeguards that were put in place in order to accommodate the different concerns that arose in the negotiation process. And this is probably what you'll face when you actually need to implement the Singapore Conventions domestically. Now, the last slide is probably a summary of what I wanted to capture and what Bangshik probably addressed with your addressed. In order to become a party, you need to get the support from the relevant stakeholders, in particularly the beneficiaries, but also the courts or the competent authority that will be enforcing these settlement agreements. Now, there will be some doubts about these questions, like why are we enforcing contracts? Why only in this state? So this is why the convention itself has addressed these issues in the scope of applications, reservations, and in the grounds for refusing settlement agreements. As I mentioned, what's the difference between a contract and a settlement agreement? What's the difference between a foreign arbitral award in the New York Conventions, which uses foreign, because there's a different seat of arbitrations, and international settlement agreements? Of course, do you need to have an implementing legislation at home? That really depends on whether you're a monist country or a dualist country on implementing international obligations, whether you have a legal framework for mediations, whether you have like a model law in place, blah, blah, blah. And then, of course, you first need to get the understanding of the competent authority, especially the judiciary authority, because they will need to also develop rules of procedure in how to execute these kind of settlement agreements. Institutional support is necessary, and we're hoping to cooperate with ADBI and other institutions to get this into place. And then, of course, UNCITRAL provides the technical assistance and capacity building for states to implement the Singapore Conventions and other texts, and we're happy to provide any support in that context. Of course, like for example, if you need a letter from us to persuade your legislators that the importance of Singapore Conventions, just let us know, and then we'll have a letter signed by Anna sent to you so that it is done. Now, last point I wanted to make is, of course, as in the context of the ASEAN context, we're catching up to the development that has happened in UNCITRAL long time ago. But I just wanted to let you know that there is ongoing lawmaking process taking place at UNCITRAL, which would be of interest to you, in the sense that, for example, the Commission is expected to adopt rules or standards relating to electronic awards in the electronic form. This is what the Commission is adopting now. And the Singapore Convention already addresses this. The Singapore Convention addresses settlement agreements in electronic form, but we're actually addressing awards in electronic form in the Commission, and it would be actually quite good if you can participate in this legislative process as well. And then, of course, we'll get to the ISDS context, but we're adopting the Advisory Center for International Investment Disputes, with one of the Advisory Center functions being promoting mediations for ISDS disputes. And all of these is being negotiated in the Commission itself, and it would be very important for the states here in the room to actually be engaged in that norm-making process and not just to catch up. So with that, I think I just wanted to stop there, and I'm happy to answer any questions that you may have about the Singapore Conventions. I kind of know each word on why it was negotiated in that way, so I'm happy to answer the questions that you may have. Thank you.
Thank you very much, Jason. You may hear. Okay, I expected that the other elements, but he really touched upon the main elements of the Singapore Convention. Therefore, I think that his presentation has already addressed your burning questions quickly. Okay, let me now invite the member countries on the stage. We have 11 representative of 11 countries. They we would like to ask them to be on the stage. Let me introduce all the participants as a panelist. If my pronunciation is wrong, please excuse me, apologize me. Let me try. Okay, Gina Park from Korea, Deputy Director, Minister of Justice. David Garibian, Director, Center for Legislation Development Foundation, Minister of Justice, Armenia. Solporon San, Undersecretary of State, Minister of Justice, Cambodia. It's a second visit, right? Please come. Faru Roji, she is Legislation and Institutional Team Leader, Directorate General of Legal Administrative Affairs, Ministry of Law, Indonesia. She will attend online. Bakal Khan, Jujuno Subu, Director, Judicial Representation Center, Kyrgyz Republic. Renalin Bidalon Parias, Director, 3, OADR, Department of Justice, Philippines. Triwat Wangkai, Counselor, Department of International Economic Affairs, Ministry of Foreign Affairs, Thailand. Sukhat Bagirov, Deputy Head, Department of the Protection of Legal Interest of the Republic of Uzbekistan. Deshinam Kulan, Officer, International Arbitration Division, Ministry of Justice and Home Affairs, Mongolia. The Honorable Bambang Kandakashi, Deputy Chief Justice, Papua New Guinea. Last on the list, Genovia Sabia, Korea, Director, Cadastral Service, Ministry of Justice, Timor-Leste. Okay. Finally, yeah, 10 people on the stage and 1 person attended online, and then including Jess only. And also, Natalie is standby to address your questions. Okay, since we have many panelists, but each country is a very precious, important, I would not skip any the panelists. I will give the opportunity, but equally. So for the efficiency of our discussion, I'm going to ask a specific 3 questions. Already we shared the question. They will address three questions in their presentation. First, what's going on in their country? What's the status of their ratifying Singapore Convention? That's the first one. And what kind of challenges do they face in ratifying Singapore Convention? What kind of assistance are required for the moving forward? Those 3 elements needed to be addressed in their presentations, okay? Bear in mind that if I ask one by one until the end of the presentation, I guess 50% of the audience will sleep. So in order to avoid that situation, let me invite a couple of countries. First, they may present their country's cases, and then let me jump in and exchange some questions, okay? Then let's go. Okay, first, Korea. Please allow me, because of pronunciation issue, I'm not going to make another mistake. So please allow me to call the country, because you should be proud. You're representative of your country, okay? Korea, okay? Mongolia, okay? Cambodia? Okay, let's see. The China Park, Korea, and please introduce your current status of Singapore Convention or next plan, please. I think sitting here is better to save the time.
So is the presentation slide on?
Not needed, but if you want a presentation, probably our step, yeah, it's possible. Yeah.
So, good morning. First of all, I would like to express my sincere gratitude to ADBI for organizing such a meaningful event. And it is also a big pleasure to be attending the second event, as well as the first event last year. Well, last year I was not yet in a position to speak in detail about the Korea's implementation bill for the Singapore Convention on Mediation. However, since then, we have finalized the draft bill and is now consulting with relevant government agencies. And we plan on submitting the bill to the National Assembly this year. So I am proud to be able to speak about the bill in a more concrete manner today. And if any of you have happened to hear my presentation on this topic at the Seoul ADR Festival last year, you may find that some parts have changed since then. I hope that you will kindly bear with me and perhaps take it as a sign that our discussion have been evolving in the right direction. I'll focus on the three major issues that we have considered during the drafting process. But before that, I will briefly talk about the scope of the legislation. Okay. So unlike Japan or Singapore, Korea currently does not have a civil mediation act, and some considered this as an opportune moment to enact such a law. Though such law would enhance systemic coherence, it could also prolong the legislative process and provoke objections from various sectors. And since more than 6 years have already passed since Korea have signed the convention in 2019, there was a strong consensus that we need to prioritize the enactment of the implementation legislation first. And that is why we have decided on a phased approach. First, enact a legislation covering only the types of mediation in the convention, and later address the broader Civil Mediation Act to organize Korea's overall mediation system. The first issue that we faced during drafting is the translation of the settlement agreement. Several Korean terms were considered. The first one was 화해계약, a contract of a compromise, which aligns with the Civil Act terminology. However, under the Civil Act, such compromise requires a litigation process for enforcement, which contradicts the Convention's objective of a simplified enforcement. 화해합의, which is a literal translation of the term settlement agreement, may cause confusion due to its similarity with the term arbitration agreement. So it could be misunderstood as an agreement to settle rather than a settlement agreement resulted from mediation. 조정상화해, which mirrors familiar expressions such as 재판상화해, that is settlement in court, captures the procedural element, however, lacks the clarity as a contractual concept. Taking into account the consistency with domestic legal terminology and the need to accurately reflect the convention, we have decided to adopt the term 조정상화해계약, which is settlement contract resulting from mediation. And the second major issue that we considered is how to implement the convention's concept of granting relief. During the drafting process, we were cautious about using the term recognition because the convention itself deliberately uses the broader expression grant relief rather than recognition. Nevertheless, we concluded that a separate procedure was necessary for a court to acknowledge the settlement agreement beyond enforcement. Because the convention contemplates relief broader than enforcement alone, and an enforcement-only model would not fully implement its purpose. In particular, where a settlement agreement contains obligations that are not readily addressed through compulsory enforcement alone, the absence of such a procedure could force the parties to relitigate the existence and effect of the settlement itself, resulting in unnecessary social costs. For that reason, the bill uses the term recognition and allows a party to apply for both recognition and enforcement under Article 4, and the grounds for refusal regulated in Article 5 apply to both recognition and enforcement proceedings. Finally, we have also considered the issue of reservations under the Article 8 of the Convention. While some argued against making any reservation in order to demonstrate full commitment of the convention, there was also concern that settlement agreement not prepared with the convention in mind might not be suitable for enforcement. Therefore, Korea plans, at least in the initial stage, to adopt the reservation under Article 8(1)(b), under which the convention will apply only where the parties have agreed to its application. At the same time, this reservation is not necessarily intended to be permanent, and the possibility of revisiting or removing it in the future remains open as practice accumulates. And that concludes my presentation. Thank you.
Thank you, Gina. She nicely introduced the current status of the Korea's preparedness. It's very good news. Korea is also preparing for ratify Singapore Convention. It's really encouraging news. Thank you so much. And then next, David from Armenia. Yeah, please.
Thank you very much, and thank you for the invitation. This is the second year that we are discussing here the issues regarding the mediation and overall ADR institutionalization, which is very important, I believe, and it helps us to understand the practices of different partner countries to implement it in our home countries and also to develop the arbitration and mediation altogether, which is very important, and as Thomas mentioned in its opening remarks. When I was listening to your remarks, actually, at some point I felt that either me or Deputy Dean have been cheating because I have the same steps for the institutionalization of the mediation as you mentioned yourself. So the first one is the policy priority, which all of us should understand as state representatives. So, for example, in the case of Armenia, we have the development of ADR in the government program. We have it in the judicial and judicial reforms strategy, and also we envisage to have it in our future strategies like the economic development of Armenia strategy, which is like very long-term strategy. And again, it ties with the economic goals like Natalie mentioned in her speech as well. The second one is the legal framework, and here first we need to understand what the legal frameworks need to be. In our case, we now have a legal framework which is very pro-arbitration and pro-mediation. It provides mandatory mediation. Moreover, we try now to extend the cases for mandatory mediation. Now we have it for family cases, we have it for mandatory health insurance cases, and we also envisage to have it for the labor disputes as well in the nearest future. But in our understanding, once the Singapore Convention is ratified in Armenia, we will need to review the legislation, and not only the law on mediation, but also the civil procedure code for the courts as a main body to later enforce the settlement agreements, the international settlement agreements. They need to be prepared, and when it comes to the courts, they need to have their own legislation. Even though the international agreements are mandatory for the Armenia, they are part of our legislations. For the court to properly implement them, we need to have the domestic legislation as well. The first step is the key partner in the field, so the key player who is always there and supports us from the private field, and for us that is the Arbitration and Mediation Center of Armenia, which is also invited to this policy dialogue, and if needed they will add from their side. But having an institution which deals with arbitration and mediation daily and which knows the practice, which can come to the government freely and speak about the problems, the pros and cons, and push us to make things easier, this is very important to have such a partner in the private field. For the people and the capacity, here we need, we have organized 5 trainings over the last 2 years for the mediators. We have 125 newly accredited mediators, and we aim to continue with this initiative to build the community. But again, we need to work with everybody, with lawyers, with judges, and with academy, with everybody. And this is an ongoing trainings that Armenia is nowadays is doing everywhere in our legal field. So at some point, we have the belief that everybody will know about this mediation and its importance in the field. And finally, one thing that you didn't mention, Deputy Dean, but I have for myself, is the delegation of the responsibility. Because if you do everything alone as a government without working with everybody and without delegating the responsibility, everybody should need to feel as the owner if you think about the reform. Otherwise, it would be only something for yourself and it wouldn't wouldn't be understood and it wouldn't work. So what we do, we also delegate the responsibility. We say, for example, Chamber of Mediators, you have to do this. Arbitration Mediation Center of Armenia, you have to do this. Academy, you have to do this, because all of us are responsible for the ADR to develop in our country. Otherwise, we can go our homes because we don't want to work just to make Denmark and go say we have done something. Now talking about the stage where we are with the Singapore Convention, Armenia is one of the first countries who has become the signatory of the Singapore Convention. However, and unfortunately, it has not been yet ratified by the Armenia because we have very serious debates with our parliament. When it comes to the government, there are only 12 people who you need to pursue, and it's very easy. We went to the government, we pushed it and we pursued it, so we signed it. But now we have to somehow pursue 130 people, which is, or at least half of them, but it's kind of difficult. And the actually main opposition that we met when we go to the parliament is that, okay, we understand it's good, we understand your position as a government, and we also understand the pros. But however, they have one question: if it's does much good, then why there is no European country, meaning countries of European Union members, that have ratified it? Of course, after the policy dialogue previous year, and because we learned it from Wimeng from Singapore International Mediation Center and other participants here, we are telling them that it's because European Union is now considering whether to do it as a union or state by state, but still it's not persuasive for our parliament. However, my hope is that we are going to have elections in June, and maybe it would be easier for us to convince the future parliament to ratify the Singapore Convention, but it's on the agenda and it would be in our in the future strategies of the government as well.
Okay, thank you so much. It's very encouraging. Oh, by the way, I'm going to instruct Derek or our staff, please ring the bell. If the 30 minutes is over or 5 minutes over, please show the sign. Otherwise, we cannot make it. Okay. Thank you so much. Especially encouraging the delegating entity to do their work. It's quite good strategy. And also, let me invite one more person, and Sopron, Cambodia. Then after that, let's talk a bit.
Okay. Thank you, Deputy Dean, for this opportunity. And many thanks for ADBI and ADB for the second invitation to this policy dialogue. Like last year, I mentioned about the homework that Cambodia need to improve or to do in terms of mediation. For Cambodia, we have 2 points. First, legislation on mediation, and second, the institution on mediation. For the legislation on mediation, we don't have a law yet on mediation. The mediation institution that have been established was done under the Code of Civil Procedure, and normally they deal with civil mediation. And from last year, I mentioned that we have technical assistant from Ministry of Justice of Korea to draft the concept note on mediation, and Ministry of Justice of Korea has sent us the draft law, and our working group is still working on the draft law suggested by the Korean Ministry of Justice. So we are still working on this concept note on law on mediation. Second, for mediation institution, right now we have 2 institution dealing with mediation. The first is National Authority for Alternative Dispute Resolution, which was created in 2023, so about 3 years ago. And this national authority deal with all mediation cases, including commercial cases. And right now, till the end of 2025, we have received 2,200 cases filed to the national authority. And the the good point of this national authority for ADR is that its decision is deemed to be the decision or the judgment of the court, for instance, that it could be enforced directly to the party without going to the court itself. So for this, we have capacity building limited. So that's why some donors, some donors have helped us with training program to our mediation, to our mediator. And for this occasion as well, I also ask ADB or other friends to help us train our mediators. The second institution is the National Center for Commercial Arbitration, including mediation. This panel has been established 3 years ago in 2023 as well, and it deals only with commercial cases. And right now, this center, this mediation center, have received around 3 or 4 case files to the center, but a decision has not yet deliver. And for Cambodia, we need to discuss, to talk about the draft law on mediation, and we need also to improve our capacity building for our mediator, for the National Authority for ADR, and for the Center for Mediation. And it needs time, and we need your kind of assistance. Thank you.
Thank you so much, Sorfan. Okay, let me invite Korea first. Yeah, we have a small chat. Korea, would you clarify, did you submit your bill from the government side to the Congress for the ratify Singapore Convention?
I think there's a bit of confusion. The implementation bill is a law on Singapore, and for the ratification process, there is a separate process for ratification to be submitted to the National Assembly. We are both preparing the bill for the implementation of the Singapore Convention, and of course the ratification of the Singapore Convention to be submitted to the National Assembly at the second half of this year. We're currently for the bill. The Ministry of Justice has finalized the draft bill, and we are currently consulting with relevant government agencies so that we could, as a government as a whole, can present a united front to the National Assembly on the bill. But for the ratification, that will be submitted at the same time when the bill is presented to the National Assembly.
Okay, then we can assume that in the second half of this year, probably it will happen. It's really encouraging news. Okay, let me ask you the Armenia. You mentioned that your congressman is very stubborn in ratifying Singapore Convention because of the reason of the European is not ratifying Singapore Convention. I'm going to ask Jae-Sung Lee, would you give us some advice to the Armenia congressman?
Well, I can't speak on behalf of the EU member states. The thing is, I think this is a question that most member states actually come about. They're going to ask who are the major economic partners for signatories or parties to the Singapore Convention. But I think that's not probably the real important point. If there is a will in the country, it should be a willingness to actually become a party itself. I know that there is actually discussions in the EU who has the competencies to sign the Singapore Conventions and whether it's going to be state by state or after the EU. Simply, we had a similar situation with the Transparency Convention, but this is probably an internal matter with the EU that should not block Armenia from becoming a party itself.
Okay, Sorfan, you are the second participant. You had some obligation or the accountability to make a progress in your country, but you share the only the domestic law legislation adjustment without any news about moving forward to ratify Singapore Convention. I am disappointed. I'm disappointed a bit. I said, why? What's the matter in your country in moving forward to ratify, even signing the Singapore Convention? Because among 3 countries, you are not signed of the Singapore Convention. What's the matter?
Cambodia does not mind adopting the Convention of Singapore mediation, but if we do that, and in our country we don't have a law and we don't have a capacity building, that's not good enough. It's not strong enough for Cambodia to adopt that international instrument. So just give us some opportunity or some time to develop legislation and capacity building. We the government see the good advantages of being member of the Singapore Convention to develop our economy and attract foreign investment, but we need to do our homework first.
Excellent. Yes, Sopa really did his job. Actually, he impressed me and other experts when he attended the first forest dialogue. So he encouraged many people, please give some support to Cambodia. And actually, the Korea Minister of Justice is helping Cambodia. That kind of collaboration is needed. And also through this discussion, ADB-ADB more is willing to pay attention to Cambodia in terms of capacity building. Thank you for your sharing and your honest, candid expression. Thank you so much. Now let's move on to the second participants. Faru Rosi, are you ready on the online? The Indonesia.
Yeah, sure.
And the Pakana Tujunovu, the Kyrgyz, and Lenny Philippines. I'm going to invite the three participants. Okay, first. Okay, here we go. Faru Rosi, please.
Yes. Can you hear me? Can you hear me, Mr. Jong?
Yes, clearly.
Yeah, thank you, Mr. Jong. I think I'm going to deliver my answer quickly. I would like to provide an update on the current status of Indonesia's ratification of SCM. Indonesia fully recognizes the importance of the convention. However, it has not yet been ratified into national law. The problem is due to the ongoing discussions on whether Indonesia should proceed with ratification or instead undertake reform of its dispute resolution framework, both on and off the court. As mentioned by previous speakers, even if the SCM is ratified here in Indonesia, reforms to other related laws remain necessary. The other issues is in Indonesia, we have the century-old Dutch inherited civil procedural law, which primarily governs court-based dispute resolution and currently discussed in Parliament, and the 25-year-old arbitration and ADR law. Both are essential to transforming Indonesia's dispute resolution landscape, and both are priorities for government of Indonesia at the moment. But the good news is just a few days ago, the Ministry of Law held a meeting with university experts and key practitioners to discuss our plan to revise the existing arbitration and ADR law. The revision is considered necessary, and the SCM is also one of the important drivers encouraging this reform. So several key issues underpinning the need for reform or arbitration and ADR law include the misalignment of international arbitration provisions with global standards. And one of them is, of course, SCM, and the absence of regulation on online dispute resolution, the lack of clarity regarding foreign arbitrators, and the absence of specific mechanism for micro, small, and medium enterprises or MSMEs. So the revision is designed to comprehensively strengthen the arbitration and ADR system in Indonesia by aligning with international arbitration with global standards such as SCM. And hopefully it will also provide clearer rules on foreign arbitrators, establish simplified and lower cost mechanism for MSMEs, and reinforce the final and binding nature of arbitral awards. Lastly, Indonesia remains committed to strengthening its arbitration and ADR framework through comprehensive legal reform and alignment with international standards. While we understand that the process is still underway, we are confident that these efforts will lead to a more modern, efficient, and credible dispute resolution in Indonesia. Thank you very much for this valuable exchange, and we look forward to continued collaboration, Mr. Jong. Thank you.
Thank you so much. Thank you so much. Yeah, really the alignment, reform domestic legal procedure is quite really challenging, very important. We find that several the challenges other panelists already mentioned, that we need to pay attention to domestic alignment, legal procedures alignment is very important. Okay, another next speakers from Kyrgyz, please.
Yes. Hello to everyone. Thank you for inviting. My name is Bakay. I'm from Kyrgyz Republic as a representative. As our colleagues are mentioned, tell everything that depends our problems, issues. Let me clarify just some issues. For instance, our mediation and Singapore Convention, we are created just practically. I just want to tell, we are adopted our law of mediation in 2025 of November, and its work is clear. It's good for understanding to our environmental. People are coming very easy to understanding what is mediation goods is doing, as well as we are seems that it's a good thing for solutions to issues. As our colleague from Armenia is mentioned, we have already have our parliament, which only depends on 19 people, and we are going through and push up to get, how can I say, to get into our Singapore Convention. It takes approximately, we hope, till the end of 2016 or the beginning of 27 years. Because of right now we are working on domestic legislations. We are created mediation centers, and it depends because of our government, our country. It's financially not how can I say, it's not too big, too much. We have not too much earn any financial monies, and to create to do work with the mediation, it's take our getting some investors on something else. We work on that. It's very.
By the way, let me clarify this. Kyrgyzstan Republic has not ratified Singapore Convention. Has not.
We are not ratified, but we are working on domestic legislation, and we are working on create like in Cambodia, like in Armenia.
Okay, I thought that we invited Kyrgyzstan with the information that ratify Singapore Convention recently. So,
we are not ratified yet, but we are going to end till this year or beginning of 2020.
Okay, thank you so much. Yeah, it's clearly the information on the website is not correct. The in-person information is quite correct. Okay, thank you so much.
We are not participants yet.
Yes, yes, yeah.
My answer is clear.
It's clear. Thank you so much. Thank you. And then let's move to the Philippines.
Good morning. Good morning. Thank you, ADBI and ADB, for this opportunity. First, I'd like to address the three guiding questions from the Philippines perspective. The current status of ratification. The Philippines has signed the Singapore Convention on Mediation, reflecting our strong policy commitment to mediation as an effective tool for resolving cross-border commercial disputes. However, ratification remains pending as it requires concurrence of the Senate, consistent with our constitutional processes. But up to now, it is not yet referred to the Senate Foreign Relations Committee, but it's already in the Senate. In the meantime, the Philippines continues to rely on its established domestic framework, particularly the Alternative Dispute Resolution Act of 2004, which already promotes mediation, but does not yet provide the direct enforcement of international mediated settlement agreements as contemplated under the Convention. This underscores a key reality. Ratification is not merely a formal step. It must be accompanied by legal and institutional readiness. Second, legislative and regulatory adjustment needed to align with the Convention. Several legislative regulatory measures are necessary. First, the Philippines must establish a clear enforcement framework for international mediated settlements. This includes enabling courts to recognize and enforce such agreements efficiently with defined grounds for refusal consistent with the Convention. Second, amendments to existing laws and procedural rules will be required. The ADR Act and relevant Supreme Court rules must be expanded to explicitly cover cross-border mediation outcomes. Third, stronger interagency coordination is essential. Alignment among the Department of Justice, the judiciary, trade and investment agencies, and dispute resolution bodies will ensure coherent implementation. Finally, mediation must be integrated into investment and commercial policy framework, including the incorporation of mediation clauses in contracts and agreements involving cross-border transactions. Institutional reforms and capacity measures. Beyond legislation, the Philippines recognizes that institutionalization is critical to making mediation effective in practice. First, the role of the Office for Alternative Dispute Resolution, which is our office, must be strengthened as a central coordination body for mediation policy and implementation. Second, we must invest in mediation infrastructure, including accredited centers capable of handling complex international disputes. Third, capacity building is vital. This includes training mediators, government lawyers, and investment and commercial dispute resolution. Fourth, the Philippines must develop early warning and dispute prevention mechanisms, allowing government agencies to address potential conflicts before they escalate into a formal dispute. Importantly, we must foster a cultural shift, encouraging businesses, legal professionals, and government actors to view mediation not as a secondary option, but as a primary and strategic tool. In closing, the Philippines view the Singapore Convention on Mediation as more than a legal instrument. It is an opportunity to modernize our dispute resolution system, enhance investor confidence, and promote more efficient, collaborative, and sustainable outcomes in cross-border disputes. Moving forward, our focus is clear: to ensure that ratification is supported by meaningful reforms that will allow mediation to thrive in both domestic and international contexts. Thank you, and we look forward to continued collaboration. Thank you so much.
Thank you so much, Philippines. Philippines has uniquely the office of ADR. I don't know whether any country has that kind of the specific ADR agency. Okay, Philippines is quite unique. And also you mentioned that alignment with reform of domestic laws, alignment to international standards. It's really challenging. It's a very important issue. I recognize that many countries are struggling because of that. So I think UNCITRAL and ADB-ADBI needed to pay attention to the element very seriously. Let me invite one more person, Triatu, Thailand, please.
So, hello everyone. Thank you for the opportunity to share Thailand's perspectives on the ADR institutionalization and the Singapore Convention, and also, learn best practices from other countries. I wish I could bring the good news that Thailand will sign and ratify the Singapore Convention soon, but that's, I think, is the aspiration that we hope to get there one day. However, I think I have two promising key messages that I would like to share with you. I think the first one is that from the Thailand's perspective, we have always seen ADR as an integral part of the dispute resolution architect in Thailand, which forms an integral part of the a broader economic and national development strategy, and in which Singapore Convention fits into this big picture as well. So just the assurance that we have always seen the importance of Singapore Convention, especially in light of the Thailand's aspiration to become the OECD member. We also see that Singapore Convention, together with the ADR architecture, will play that important role. And also the second message that I would like to convey is that, there has been much progress, in my personal opinion, towards the commitment of Thailand to join the Singapore Convention, and I will elaborate a little bit more later. On the first point, I think there is a good foundation for the ADR system in Thailand. We have had Dispute Mediation Act in 2019. We have amended the Civil Procedure Code, which has strengthened the mediation system in Thailand, which includes the court supervised mediation. We also have a variety of mediation and ADR institutions in Thailand, to name it Thai Arbitration Institute and Thailand Arbitration Center, and a growing number of sector-specific forums. So I think we have very good foundations there. So we always have seen ratification of Singapore Convention as part of this ADR ecosystem. So that's why it has taken some time, and I think we have carefully moved towards the ratification, because we don't want to just sign or ratify a treaty, but we want to be able to operationalize it. We want to be able to make it work, make it trusted by the stakeholders. On the second point, there has been much progress. I mean, actually, there has been an interagency working group set up many years ago, I think over 5 or 6 years ago, to look at this matter. And I think they have made a significant progress from what I've seen from the archives. So I think there was even a draft implementing legislation on the ratification. So I think we decided to have a specific legislation on the ratification rather than amending the existing laws. And I think we looked at the 2018 UNCITRAL model law as the model. So I think that's a good progress. But however, there are a few policy questions that we had to make a decision on. For instance, the Article 8 reservation, in particular dispute relating to the government agencies. I think this is a very quite a sensitive issue for Thailand, so we have to consider it very carefully. And the second, in terms of the competent authority, I think the working group has decided to designate the Central Intellectual Property and International Trade Court as, I think, a strong candidate for the competent authority, given its experience in the cross-border commercial matter. So I think we are already clear on that point. And the third, I think, like many countries, we have worked very hard on the building capacity for the relevant stakeholders. I think as in the introduction, we want to internalize it. We want to socialize the mediation. So that's why we want to make sure that we have the legislation in place, we have the institution in place, and we have the capacity in place. And I think with all these three elements looking very solid, I think we will achieve the aspiration one day of becoming party to the Singapore Convention, which is also in line with our vision to become an ADR regional hub as well. So thank you very much.
Thank you so much. Okay, let me ask a couple of questions to participants, especially for the Kyrgyzstan and the Philippines. Kyrgyzstan is almost about to ratify Singapore Conventions. Please share us what's your next step. What's your prospect? When are you going to ratify Singapore Convention in terms of a time period? Just your assumption as a government officer.
As I said, we are working now preparing some documents to clarify to our government, not to our government, to our parliament, when they accept, and then we go to sign our ratification. Yeah.
Okay.
It's depend. As I say, our parliament works till the July. That's why maybe it's the end of July we do that, or till the end of this year.
So okay, the possibility of passing by Congress is very high.
Yeah.
Very good. Yeah.
After that, we are going through because of our leadership is going on to create our mediation center and et cetera, et cetera. Yeah.
Sounds good. Okay, Philippines, what's your next step for the ratifying Singapore Convention? You have already signed it, right? What's your prospect?
We already have the draft amendment for the ADR Act of 2004, and this already submitted to the Department of Justice.
So, in terms of ratifying Singapore Convention, do you think it's take a bit more time?
It will take more time because it's not yet referred to the proper committee at the Senate.
Okay. Okay, let me ask another question to potential OECD candidate country, Indonesia and Thailand. You are really is now very the good position to join access to OECD. OECD is really the advanced country. They are really rule setting kind of entity. But in case of these ADRs, already there's a rule, international standard. Therefore, in terms of enhancing the domestic regulation in alignment with the international standard, it could be good for you to consider considering ratifying Singapore Convention in that sense, showing your country's readiness. So in that sense, is there any the challenge for your government side or politician, the Congress side, to consider the ratifying or signing the Singapore Convention? If you have, what kind of challenges are most important, difficult things for your country as a government officer to address in the ratifying Singapore Convention or signing Singapore Convention? First, Thailand first. Thailand and Indonesia. Thailand first.
I understand your question correctly. So what are the challenges for signing of Singapore Convention?
Yes,
light of, I wouldn't necessarily say challenges, but I think there are work to be done. And I think there has been full support, of course, in all branches of the government for the OECD accession. I think there's no question about that. And I think there has been explicit recognition that becoming a party to Singapore Convention will actually facilitate or help in the OECD membership part. I think the work to be done is, of course, to have all those three elements that I have already outlined. And I think, I think the work is ongoing, and I think we will do it. And although it's not a requirement, right, to become an OECD member, to have a Singapore Convention, but as you rightly pointed out, that by aligning our domestic legal framework in line with the international standard, that is one of the positive things towards a membership. So I'm personally positive and hopeful that we will get there in the end. So
excellent. Let me invite Indonesia, please.
Yeah, thank you, Mr. Jung. Yeah, we understand that we have so many homework to join OECD, and that's why we plan to revise the arbitration and ADR law first, because it is going to simplify or attempt to reform the entirety of dispute settlement framework in Indonesia. Because if the government currently has so many priorities in reforming the dispute resolution law in Indonesia, including the civil procedural law and also the arbitration law. So if we try to push the ratification into the frame, we're afraid that it's going to be so many obstacles, so many homeworks for the parliament as well. So at the moment, the government focuses on preparing the draft of the arbitration and ADR first. And for your information, in Indonesia, before the bill can be drafted and discussed between the parliament and the government, the initiator agency must prepare a research paper. And in our research paper, the ACM is mentioned so many times. So this is why I think it's important that even though we are not current, we have not ratified the ACM yet, but in our arbitration and ADR law, it is one of the most important drivers. Thank you, Mr. Jung.
Thank you so much. Actually, Japan is an OECD member country, is already ratified the Singapore Convention, and Korea is also OECD member country, signed, and so now is about to ratify Singapore Convention. It's good news for your consideration, okay? Thank you so much. Let me invite another remaining four panelists, Uzbekistan and Mongolia and Papua New Guinea and Timor-Leste. Let me invite the first Uzbekistan. Please share your case.
Okay. Good day, dear colleagues, dear organizers of this event. First of all, I would say that it's a great honor to be here and participate in large-scale event, and which provides an excellent opportunity to exchange valuable experience on the issues included in the agenda. Let me present brief information on the reforms carried out on Uzbekistan in this field. In recent years, as part of the modernization of Uzbekistan's legal system, particular attention has been paid to developing alternative dispute resolution mechanisms especially the institution of mediation. The legal foundations of the field have been strengthened, a system of training professional mediators has been created, and the range of areas in which mediation is used has been expanded. We had the law on mediation, which adopted in 2018. And since these adoptions, in particular in 2025, more than 81,500 disputes were resolved through mediation, including 7,500 disputes in cases pending before the courts and 74,000 disputes settled at the pre-trial stage. On 2025, amendments and additions were introduced by law to certain legislative acts of the Republic of Uzbekistan aimed at improving the institution of mediation and alternative dispute resolution. The law establishes important reforms that will bring in the field of the mediation in Uzbekistan to a new level. In particular, the range of areas where mediation is used is expanding. For example, notaries are given the authority to act as mediators in all kinds of fields. It's determined that mediators should have higher education and systematically improve their qualification. And the last one, mediator qualification commissions are being established. When developing such kind of projects, we obviously always study the experience of developing countries and our partners. And as you know, the Mediation Tashkent Center has also been established to unite professional mediators organizationally and methodologically. As a result of these reforms, mediation has now become a professional institution. The workload, of course, is decreasing, and mechanisms are being created for investors to resolve disputes quickly and transparently. And what about future plans of Uzbekistan at present? In order to further improve Uzbekistan mediation investments and business environment, we are looking forward to adoption of Singapore Convention, and we created the working group, which contains of representative of our national bodies, and we study experience of developing countries. And then the last discussing with George Lim, Singapore Mediation Center Director, we have discussed about the opportunity to implement such norm of that convention in our legislation, and we have discussion with the George Lim, and we hope that his center help us to create our legislation, but this convention. And second one, we establish of a chamber of mediation, introduction of procedure requiring mandatory mediation before filing any case with the court, and launch of the unified electronic ADR platform, and further development of online mediation. As you understood, we haven't had the adoption of this convention, but we hope that the adoption will be soon.
Thank you so much. Okay, let me invite the next speaker, Mongolia, please.
Hello, everyone. Thank you for having me. My name is Holang, and I'm from Ministry of Justice and Home Affairs of Mongolia. Mediation has been increasingly promoted in Mongolia lately as a more efficient and feasible way to resolve disputes, as arbitration proceedings are often costly and lengthy. However, mediation is a very new thing in Mongolia. We first adopted the law on mediation in only 2012 as part of the judicial reform to reduce the burden on the courts and develop ADR options. By ratifying the Singapore Convention, Mongolia is expected to gain advances such as localizing cross-border mediation practices, therefore attracting investments and improving the business environment. Within the framework of Mongolia's policy to ratification of convention, necessary measures and research are being carried out in accordance with the principles and requirements set forth in law on legislations. For example, compatibility of the convention with the Constitution of Mongolia and Mongolia's international treaties, also assessment of potential impacts on human rights, economy, society, and the environment. Usually these studies take 6 to 12 months to complete. However, it's likely that a considerable amount of time will be required for research related to Singapore Convention on Mediation because Mongolia still challenges with domestic legislation. According to the law on mediation, mediation services may be provided by courts as well as private mediation organizations. However, the law doesn't provide provisions for enforcing settlement agreements concluded through private mediation centers. Instead, it stipulates that parties have the right to apply to the directly court regarding the fulfillment of obligations under the settlement agreement. Since 2014, private mediation centers have been established along with official lists of accredited and qualified mediators. However, currently these organizations aren't operating effectively due to issues related to the enforcement of mediated settlement agreements. Also, we have challenges with the access to mediation service, particularly in rural areas, undeveloped rural areas. Lastly, we need support on raising public awareness and building trust in mediation, as well as well-functioning mediation centers and alignment of domestic framework with the Singapore Convention. In brief, now Mongolia has challenges within the legislation in domestic enforcement of mediated settlement agreement is not clear, and it doesn't provide have to enforce private mediation centers mediated agreement. So we have to work more focus on domestic legislation before ratifying the Singapore Convention. Thank you.
Thank you so much. It's quite reasonable to have a very trusty, reliable domestic procedures before going to ratify Singapore Convention. It's reasonable. Let me invite Honorable Judge Bambang, please share.
That's working now. Thank you, Din, and thank you, ADB, ADBI, for the facilitations and invitations. With your help, we've advanced in many, many ways, come the ADR story. Papua New Guinea's ADR stories goes back to 2000. It was a judiciary who took leadership in promoting the use of mediation because of huge backlog in the courts. Lawyers then tried to help themselves, but no one was actually taking the leadership. So the judiciary filled in the role. Now we have a robust court annex mediation system with over 150 fully accredited mediators, which consist of judges, lawyers, and others. Some lawyers have given up lawyering and now into full-time mediation practice. When the Singapore Convention was being discussed and it was happening in Singapore, we sent delegates, but we made a deliberate choice not to sign up at that point. At that point, we wanted the domestic setup for mediation practice, procedure, code of conduct for mediators, discipline, conduct of parties, conduct of mediators, all to be regulated through a detailed set of rules, which we have now had it replaced second time. 2022 is a second version of the rules based on practice. Now, the question on where we on the Singapore Convention, we have not yet signed yet, not yet ratified. That's the bad news. Good news, we've already taken the steps. We put a government team together, which comprised of the ADR committee. ADR committee comprises of judges, lawyers, academia, other members of the society. So it's a broad-based committee that comes to work together. So that is now in tandem working with a government team, Daniel Roglaparia, who's supposed to be with us, but is been called up to look into a defense force matter that has just come up. He will possibly come online, or he's joined us online. He's also in the team. He's the main person on legislative drafting and advising the government. So together with his help, the current minister has been very helpful, and we've managed to pass the International Arbitration Act and the Domestic Arbitration Act, more modern, conforms with all of the practice and procedure and jurisprudence that you have. Now we're all set, the scene is set. The ADR committee has established a technical working group to commence work on the draft submission that would go to cabinet. The minister is very switched on, ready. You guys work very quickly. We are going to elections next year. You better hurry up. So we have a readiness on the side of the minister to get things going. So by the time we get back, Justice Wood is here. He's a very active member of the ADR committee. We will go to work. We will go to work with the submissions, not only just for ratification, but the legislation that will domesticate and implement the Singapore Convention as well. Hopefully through that time, we will also have a modern appropriate dispute resolution act, as opposed to alternative, that will cater for mediation and all other forms of ADR in Papua New Guinea.
Thank you. Excellent. Thank you so much. Now let's the final speaker, the Genovia, please.
Good morning, everyone. I'm honored and grateful to be invited to participate in this session. What I would like to briefly share in this session is, according to agenda given, the program given, it's about the current status of Timor-Leste's ratification of the Singapore Convention on Mediation, the key legal regulatory adjustments needed to align to our domestic frameworks, and the institutional reforms and capacity building measures required for effective implementation. Timor-Leste became a full member of ASEAN last year in 2025, and is set to host ASEAN in 2029. In this context, aligning with international dispute resolution frameworks is not just a legal reform, it is also an important economic strategy. Signing, ratifying, and implementing the Singapore Convention on Mediation would help strengthen investor confidence by offering a predictable and enforceable alternative to litigation and arbitration. Investment is the priority for Timor-Leste's government to solve economic and social issues. Timor-Leste is not yet signed and ratify the convention. This means the convention is not yet legally effective in our domestic system. However, Timor-Leste has commitments for legal and institutional development as a preparation phase for the ratification of the Singapore Convention on Mediation. To move forward, aligning with the convention will require a mix of legislative reform, procedural adjustment, and institutional capacity building. Even before ratification, these steps are important to ensure that mediated settlement agreements can be enforced as reliably as arbitral awards in cross-border disputes. At the moment, mediation in Timor-Leste is still relatively limited, especially in commercial cases. Some judges, lawyers, and mediators are not yet fully familiar with how the Singapore Convention changes the legal effect and enforceability of mediated outcomes. Mediation is mostly used in non-commercial matters, such as land disputes between individuals or between private parties and the state. This shows there is already a foundation, but mediation has not yet become part of a mainstream commercial dispute resolution. Looking ahead, the key reforms would include judicial training and simplified enforcement procedures, and professionalization and accreditation of mediators. the establishment of mediation institutions, and improvement in administrative and digital infrastructure. Broader awareness raising for legal professional and the public is also essential. Together, these steps would make mediation not only legally recognized, but also practically effective. In conclusion, ratifying, signing the Singapore Convention is the easier step. The real challenges and opportunity for us lies in building the ecosystem that allows mediation to function in practice. If done well, mediation can become not just an alternative dispute resolution tool, but a trusted and effective pathway for resolving cross-border commercial disputes in Timor-Leste. Thank you.
Thank you so much. Thank you so much. Thank you to all the participants. But since Jason is here, let me ask him how the UNCITRAL can help developing country to secure their domestic legislation reform in alignment to their roles into international standards. Actually, that is really challenging from my perspective. What's your approach?
So I think what we're hearing from all of the participants and the speakers is it involves all three departments or branches of the government. I think first we need to persuade the executive branch, which is making the policy for mediations, to be supportive of mediation, and then also to consider becoming a party to the Singapore Convention. Now, in that process, then you need to persuade the judiciary, because the judiciary is the one who's going to be enforcing the settlement agreements. And therefore, in order to do that, then you need to persuade the legislators, as you said, you need to persuade the Congress that you need to become a party and therefore implement this president. So I think it involves all three different parties, and I think the role of UNCITRAL and ADBI is actually to support all three supportive initiatives. We need to, I think we're all in the same page here in this podium, because at least we're on this podium are persuaded on the importance of mediations. But when you go out and you persuade the judges, when you persuade the legislators, I think this is where we have to come into the picture, that these are based on international standards and we're there to support you. Now, there's also this, at the next step, there's the coordination of internal ministries within the ministries themselves. Once you've made that decisions, then you need to persuade your Ministry of Foreign Affairs to deposit your instrument of accession or instrument of ratifications. Now, the Ministry of Foreign Affairs sometimes don't know what mediation is, and therefore it's also difficult. And this is where we come into the picture. And sometimes it's not coordinated, because what we have heard from the treaty office in New York is that Kyrgyzstan actually has submitted its deposit of its instrument of accession. So we have already received a notice from the permanent mission of Kyrgyzstan that you have acceded to the convention. You actually have ratified in accordance with the Ministry of Foreign Affairs. So this is why I think there's also internal considerations with ministries that need to take place, because sometimes people do things without the other people knowing. And this is probably a coordination approach that we need of the three branches of the government and within the ministries, because they need to be aware of what the other ministries are doing. This is probably the only thing that we need to take from her. I know that Natalie is there, so if you want to maybe give her the floor.
Maurice.
Natalie?
Natalie is there?
Yes, thank you for giving
please.
me the floor. I think that actually Jay has completely covered it. And indeed, the idea of coordination between agencies is incredibly important, because the convention, whilst we see it as a dispute resolution tool, its implications are far and wide, and its use also will be utilized by the various different types of ministries that would engage in mediation themselves, for instance, or could be involved in the promotional aspects. So far beyond the ratification process, where, of course, that also by itself can be rather confusing to kind of engage in, and that's where UNCITRAL and others come in. So yes, I would like to just second what Jay has said about the importance of that aspect. Thank you.
Okay, thank you so much. It's really, did you enjoy these discussions? Yeah, indeed. But we realized that what's really they need for their moving forward. I think we needed some kind of a country focusing the outreach to educate, to improve the awareness of this Singapore Convention, the domestic legislation reform. Is per country we may needed to implement that kind of technical assistance. Otherwise, if several countries make a progress, then other countries will follow easily. So targeting specific country and then reach out there and educate the relevant stakeholders at the same time on the same stage. That seems to be very helpful. We may think about it in next time. Thank you so much for your attention. I'm sorry not to give many times for the sharing, but anyway, your contribution quite meaningful. Please, this is not your final stage. You have to talk with the expert, including Chess only. Please utilize your opportunity to talk with them, to get something, and then tighten your network with the expert. Okay, please. Thank you. Thank you so much for your attention. Thank you.
Thank you very much to all the panelists, the moderator, Deputy Ding Jung, and also Jae Sung Lee and Natalie online. Thank you again for joining us. So next, we would like to move on to lunch. I'm sure you're all quite hungry by now. So lunch, we will have 1 hour or just under an hour for lunch. It'll be in the room next door, the A room. For those of you who have informed us of your dietary restrictions, we have your names and your lunch, a separate lunchbox prepared for you. So your names are on them at the reception desk. So those with dietary restrictions. All others are welcome to join us for the regular buffet lunch next door. So thank you. We'll resume at 1 p.m.
Thank you.
Okay, if we could take our seats in the next minute so that we can start with session 2. Okay, welcome back everyone from hope you enjoy the lunch and you feeling refreshed and ready to go for this afternoon. We'd like to continue with session 2, which will be practical measures to promote the use of mediation. This session will be moderated by Mr. Hiroyuki Tezuka. And Tezuka-san heads the international dispute resolution practice of Nishimura and Asahi here in Tokyo. And he also serves as vice president of the Japan Association of Arbitrators and as Chief Director of the Japan International Mediation Center based in Kyoto, JIMC. He specializes in international commercial litigation, arbitration, and mediation, and he has represented many international clients, including multinational manufacturers, banking and security firms, insurance companies, and information media companies, among many others. So, Tezuka-san, I would like to hand over the floor to you for session 2.
Thank you very much. Welcome to Tokyo. And I'm very much honored to serve as a moderator for the second session. That is institutionalization of, the practical measures to promote the use of mediation. And as is written in the agenda, this session will explore the challenges you face in promoting the use of mediation, and also what kind of practical measures you could take in dealing with such challenges. And we have the format starting with a presentation by 2 distinguished speakers, Dr. Anne Ford and Mr. San-Juan Lee, followed by a panel discussion of the distinguished panelists who are the representative of the various mediation centers, as well as a corporate counsel and the representative of the forum of the judiciaries. So without further ado, could I ask Dr. Anna Huas to start with her presentation. Anna is a lecturer at University College London, Faculty of Laws, and the co-associate director of the UCL Center for Dispute Resolution. She is also a mediator, and from 2020 to 2025, she serves as an assistant to Lord Neuberger and Bill Marsh on a series of complex multi-party mediation. And before returning to England in 2014 to undertake her PhD, Anna was a lecturer of law at Singapore Management University. Anna, floor is yours.
Thank you very much. It's a great pleasure to be here and a privilege. If I could have my slides up, please. Thank you. Yes, okay. So the question which this session today explores is one which I set out to research for the research for my book. So the question about why mediation remains underutilized. And though I explored that question in a different context, in the EU cross-border context, I think, as you'll see from the themes that I identify, that those themes have relevance in other contexts. So by way of a little bit of background on the research that I did, there was great hope and anticipation in the EU that the EU Mediation Directive would result in a significant uplift in the use of mediation. That did not happen. So to try to understand why mediation remained, the use of mediation remained stubbornly low, I wanted to try to hear from the users of dispute resolution processes. So I interviewed senior in-house counsel of large multinational corporations which had disputes across the EU. Many had disputes beyond the EU as well. And I asked them why they did, but perhaps more importantly, why they did not use mediation. Because if we want to promote mediation, we need to understand why it's not being used. So in the short amount of time that I have today, I'd like to outline 3 insights that emerged from my research, which I hope will help to prompt some of our discussions. Those themes are tone, trust, and transparency. So the first, tone. Let me zoom out a little as we consider the promotion of mediation. So the backdrop, as I said, to my research was the EU Mediation Directive. And as I looked at that directive and a lot of other related policy documents, I noticed that the tone of the promotion of mediation tended to be, for completely understandable reasons, that mediation, portraying mediation as the quick and cheap way to avoid costly and lengthy litigation. And increasingly, we've seen the same messaging in the arbitration context. So use mediation to avoid costly and lengthy arbitration. And so it seemed to me that the tone that underpins that messaging, the promotional messaging, is that mediation is the easier option compared to litigation and increasingly arbitration. But listening to the disputants in my interviews, it struck me that that messaging, the quick and cheap and easy label, may not resonate particularly well with them, because seeing mediation from the prospective user's perspective suggests that it's not the easy option, that mediation actually asks quite a lot of the users. So let me identify a few reasons why mediation actually asks quite a lot of the prospective users. So the senior in-house counsel I spoke with identified 3 main and interrelated reasons why mediation asks a lot of them. And these insights give us a better understanding of why there remains a reluctance to use mediation. And we need to understand this reluctance if we are to promote mediation in an effective manner. So the first is failure. And for me, I found this an interesting finding. As one of the in-house counsel explained, the business see going to mediation as an admission of failure. They haven't been able to deal with it commercially. So these experienced commercial negotiators think that mediation reflects badly on them. It emphasizes in some way that they failed to resolve their dispute in their own commercial negotiations. So in calling on the help of a mediator to help them with their negotiations, in some ways it highlights what they themselves were unable to achieve. And for those who propose mediation to their colleagues, and this is captured in the second quotation on the slide, they're aware that that proposal might be received as a criticism, as a suggestion, to use the words of one of the interviewees, which is on the slide, that they didn't do a great job in their own unassisted negotiations, and therefore they need the help of a third party. And this concern about the perception of failure arises not only in relation to the initial step of entering into mediation, but also regarding the later stage of reaching an agreement at the mediation. As conveyed in the final quotation on the slide, disputants are concerned that they may fail in the sense that those not present in the mediation might view the outcome reached as a bad deal. It may be easier to send the dispute to court or arbitration and say that the court or the arbitrator got it all wrong. So these insights into concerns about perceptions as to failure suggest that mediation asks parties to put themselves in a position which makes them vulnerable to criticism, and none of us likes to put ourselves in that position. It's far easier to put the blame on the judge or the arbitrator. So the theme of failure is connected to another way in which mediation asks a lot of its prospective users. It asks them to take responsibility for the determination of their dispute. It requires, to borrow the words of the in-house counsel on the slide, that they take accountability, that they take risk. And the in-house counsel went on to explain, went on to associate mediation with an entrepreneurial culture, further recognizing the risk-taking that mediation requires. He explained that when his company's culture was more entrepreneurial, there would be more mediation. And lastly, mediation also asks its users to accept that engaging a third party to assist them in their negotiation may add value to their own unassisted negotiation efforts. And the interviewees I spoke to who had not used mediation identified a strong skepticism about the value that mediation could add to their own negotiation efforts. Those of us who work in mediation know the value that it can bring to unassisted negotiation efforts, but those who hadn't used it were very unsure about the value that it could bring to their unassisted negotiation efforts. In essence, they were saying, why should I bother mediating if I've already negotiated and I'm an experienced negotiator? And that's perfectly understandable. So these insights to me suggest that the messaging which we commonly see in the promotion of mediation, as mediation being quick and cheap, in other words, the easy or easier option, might not resonate particularly well with potential users. For them, rather than being the easier option, it asks a considerable amount of them. And given that mediation asks a considerable amount of its prospective users, they understandably seek reassurance about using mediation. This leads to the second insight from my research, trust. Picking up on the point that Mr. Thomas Clark made when he opened the conference about trust. So I'll frame this in two ways. Firstly, disputants seek reassurance that they can trust in mediation. In other words, that mediation is a trusted dispute resolution process. So the increasing legal framework for mediation, which we see, such as with the Singapore Mediation Convention, that contributes to establishing trust in mediation. But the interviewees also sought more tangible reassurance on mediation. They sought reassurance on how well trusted mediation is by its users. As the quotation on the slide shows, prospective users want to know who is using mediation, which mediators they are using, and to what effect. Should I stop now, or can I?
Just one word for your third point, perhaps.
Okay, I'll just finish off on the trust point then. They want trust in knowing who is using mediation, which mediators they're using, and to what effect. And they also want a neutral, trusted body as well to help them to set up the mediation. I'm just going to rush through the final few points. They want trust in the mediation process itself, but they also want trust in the dispute resolution process of mediation, then trust within their own mediations. They want confidentiality in the mediation process. They want it to be watertight. So there's a bit of a tension there. They want to know who is using mediation, to what effect, and which mediators they're using, but at the same time, they want there to be watertight confidentiality in their own mediation. So we need to think about how we can increase transparency about mediation. That's the third theme, about there being more transparency about who is using mediation and to what effect and which mediators, in order for there to be greater trust within greater trust in mediation as a dispute resolution. So quickly to finish up my presentation, we tend to see an adversarial approach to the promotion of mediation, pitting mediation often against the apparent shortcomings of litigation and arbitration. But might we want to adapt a more mediative approach to the promotion of mediation? The three themes that I identified of tone, trust, and transparency, they're all characteristics and qualities of the mediation process. If we adopt a mediative approach to the promotion of mediation, what other themes might we see? Creativity, collaboration, curiosity. And so I invite, as we have the discussions, to think about what might a mediative approach to the promotion of mediation look like. Thank you very much.
Thank you very much. Next, I will invite Mr. Sung-Hwan Lee, the capacity building specialist at the ADBI. Prior to joining ADBI, he worked at the Korea Credit Guarantee Fund, primarily handling legal matters, including labor law, government contract law, and civil law. So, Mr. Lee, the floor is yours.
Good morning, afternoon. My name is Sung-Hwan Lee. Could you please note my slide?
You have 7 minutes.
Okay. Good afternoon, everyone. My name is Sung-Hwan Lee. I'm a capacity building specialist at the ADBI. Today, I would like to discuss the practical strategy to promote the use of mediation. Specifically, I'm gonna focus on our attention on a critical group of the professional, the external counsel. When a dispute arises, the first point of the contact is lawyer. It's almost always their external counsel. They assess the legal risk and frame available options and effectively guide our decision making. As we are not a legal expert, so we have a little choice but to follow their legal advice. To understand their influence, I would like to introduce a survey. According to the 2022 CIDRA International Dispute Resolution survey, 61% of respondents use mediation because the external counsel have advised them to make use of the mediation. So I believe the active recommendation of the external lawyer is the key catalyst of the wider use of mediation. However, in practice, the mediation is not routinely considered by external counsel. There are so many reasons, but I would like to focus on three main barriers. The first one is professional orientation. The lawyers are predominantly trained in litigation, so they view dispute through an adversarial lens for dispute resolution. So they prioritize the litigation over the mediation for the dispute resolution. The second one is opportunity cost. The mediation may entail the opportunity cost. The legal fee are typically based on the billable hours, as I know. If mediation resolves a case too quickly, the lawyer lose their billable time and overall the profitability. Furthermore, if mediation fails, they face the burden of duplicating their work to prepare for the litigation once again. The third is client perception. This is from my experience. If lawyers suggest the mediation too early, the client may misinterpret their suggestion as a lack of confidence or the weaker commitment to defending our rights. In some cases, this negative perceptions can even lead the client to replace their lawyer. To break down these barriers, we cannot simply wait for the mindset to change. We need a structural and procedural shift. I propose two main levers to encourage the external counsel. The first one is institutionalization and third-party engagement. And second one is financial incentives. We need third-party institutions like a court and arbitral tribunals to actively step in. Tribunals can establish a mandatory mediation window through a procedural order. Also, we can utilize the arbitration and mediation arbitration system, which temporarily oppose the arbitration to allow for a structured mediation phase. And lastly, the tribunal can also use cost allocation to penalize the party who unreasonably refuse to mediate. Why this is important? More broadly, the active tribunal engagement and the institutionalization of mediation give external counsel and the client first-hand experience, so helping them to recognize the benefit of mediation. Ultimately, this serves as a foundation for promoting mediation. However, the institutional cover is not enough, I think. We must also address the financial reality. We need to offset the opportunity cost of the lost billable hours that lawyers face if they settlement so earlier. Well-designed financial incentives are one of the most practical measures to influence behavior and encourage the greater engagement in mediation. From my understanding, we can implement the financial incentive through a two specific and simple model. The first one is performance-based incentive. A bonus is provided to the lawyer if mediation results in a successful settlement that delivers a better outcome for the clients than expected. Suppose a client is involved in $1 million disputes. If they pursue successful litigations, the expected benefit is projected to be 600,000 US dollars. However, the external counsel demonstrate the excellent negotiation skill and secure an early mediate settlement of 800,000 US dollars. In this case, the difference between the benefit from mediation and the expected benefit from litigation is 200,000 US dollars. If the pre-agreed payout rate is 10%, the lawyer would receive 2,200 US dollars. In addition, the base fee. The second one is the cost saving shared incentive. If the mediation significantly reduced the expected time and overall cost of the dispute resolution, a portion of those verified savings is shared with the external counsel who contribute to that outcomes. Imagine the dispute that is projected to take 24 months, which costed 240,000 US dollar in legal fee, it taken all the way to a final court decision. Instead, the external counsel actively recommends and leads a mediation process, successfully resolving the dispute in just 4 months, which cost 40,000 US dollar. As a result, the client saved 20 months of time, which cost 200,000 US dollar. If agree upon the shared rate is 10% of cost savings, the lawyer would receive 20,000 US dollar for incentive. I think that this combination of two kinds of incentive can help offset the opportunity cost and encourage the greater engagement in mediations. From the client's perspective, the mediation experience helps preserve the amicable relationship with their counterparts. Even at the high cost, it can deliver long-term value. In conclusion, if we truly want to promote the wider use of mediation, the strategy must be clear. We need to focus on how to bring the external counsel who effectively gatekeep the dispute process into a mediation process. Thank you very much.
Thank you, Mr. Lee. Could I now invite the panelists to come up to the podium and don't be rushed, and please make your move safely. And while they are moving, I would like to give you a very brief introduction. I had asked them to give me 2 sentences self-introduction, but I think it's now practically impossible to go through those even 2 sentences introduction. But I would like to briefly mention who are representing which organization. George Lim from SIMC Singapore, Professor Newham Park representing KIMC Korea, Mr. Peter Korn representing SCMC Shanghai, Ms. Hizai Jinhua representing AIAC in Malaysia, even though it's a kind of multi-state organization, I know. Mr. Tony Nguyen for VMC Vietnam Mediation Center, and Honorable Justice Robin Knowles of Standing International Forum of Commercial Courts. It's a forum of judiciaries. And then we have Mr. Muhammad Abdul Rafet bin Haji Ibrahim representing the BDAC Brunei. And also we have in-house counsel from POSCO Holdings, Mr. Seung Kim, and also the Japanese trading house Itochu Corporation, Ms. Claire Chino. So I thank panelists to take part in this session 2. And because of the time limitation, I would go straight to pose you some of the example questions. It is in your material question number 2. Why do many corporations still hesitate to use mediation for dispute resolution? And maybe I should start with the candid views from the corporate in-house counsel of such hesitation, if any. So could I first ask Mr. Seung Kim about that?
Hello, thank you for having me here. To be right on the topic, so, well, from in-house legal counsel's perspective, there are several key reasons why mediation is still considered as a secondary option to traditional mechanisms such as litigation and arbitration. I will talk about the main 2 issues today. First is the uncertainty around procedures, especially in relations to the mediator's role in the process. Of course, as an in-house, lawyers need certainties so that they know what to predict and how to react in certain situations. However, mediations sometimes are very much dependent on individual mediators' role and capacity. And I believe this may cause confusion among the parties who want to assess and review the possible outcomes of the case in advance. Second is the efficiency of time and cost. Companies negotiate and try to reach agreement because they can save cost and time. However, for some people who are not familiar with mediation process, mediation may just be adding another layer of negotiation in the intervention of a third party, the mediator. In order to achieve a good outcome, the relevant teams inside the corporation really have to work together. But in some cases, going to mediation will mean more escalation inside the company, eventually making issues harder, not easier, to make any compromises in the negotiation. So the 2 things, in conclusion, the real challenges in the use of mediation comes from how to build certainties in terms of procedures and how to effectively control cost and time. Thank you.
Thank you very much. And may I proceed to ask Chino Sensei, Claire Chino, about your company's or Japanese companies' attitude? And people may feel that the Japanese companies really hate litigation arbitration, so they want to mediation, but the other party don't agree. But what are the reality? What is the reality?
Thank you so much. It's wonderful to be here. I think, as Mr. Kim said, the question really is uncertainty. And when we talk about dispute resolution, I think the bottom line question is mediation really going to resolve disputes? Whereas arbitration or litigation, whether you like it or not, there's finality. But at the end of the day, would mediation actually result in resolution of disputes? I think that is the biggest question that we have. And quite frankly, whether you're thinking about mediation or arbitration or litigation, you're actually thinking about that at the time of drafting the agreement under the dispute resolution provision. And I think, as Sen Wang said, there's quite a bit that external counsel can do. I think oftentimes as in-house counsel, we're not necessarily presented with the option of mediation when the agreement, the dispute resolution provision is drafted. But at the very beginning, I think the parties need to be thinking about mediation as an option. But I think the resistance against mediation comes from the fact that it may not necessarily be finality. There's going to be a lot required of clients, not just in-house counsel, but also of the business people. And again, as Mr. Kim said, what is mediation going to really result in? if you actually face with a mediator who may not necessarily have the expertise that we're looking for. So those are my answers.
Thank you very much. And before turning to Tony from Vietnam, I would like to ask George to comment very briefly about why you have so many mediator cases, even though we are now talking about the hesitation on the part of the users. But I understand that you have been working on hundreds of cases. Why your parties have agreed to the mediation conducted by you? Any brief comment on that?
Hello, good afternoon. Yeah, because I started long ago. All right. I started mediating 28 years ago. It takes a while. But just maybe to share a little bit about Singapore's experience, it was not easy for us too, because mediation was first introduced in Singapore through the courts in the mid-1990s. And for those of you who know about mediation, you look at the interests of the parties, right? And the court's interest at that time, if the case is settled, no backlog, right? So that was the court's interest. And it's very good because if the courts started, I think the lawyers will follow suit if the courts encourage mediation. And that may be so in some of your countries. I think you can apply that. Then we had to train the lawyers, of course. Okay, so it took a couple of years. I'm a founder member of the Singapore Mediation Center. We started in 1997. Okay, and I went to do my training. So we started mediating like part-time. I was a litigator, arbitrator. If you get to do one case in a month or 2 months, you're lucky. But over time, you know, the lawyers were at first, of course, a little cautious, some resistant because mediation was new. But with time, and they saw success stories. And the overall settlement rate for mediation globally is about 70%. That means 3 out of 4 cases can actually be resolved. And when that happened, clients saw that it was a good thing to try. And I know, Anna, you talked about failure and all that. But really, we tell parties, you try it. If you don't succeed, you can still go back to litigation arbitration. Okay, and in fact, in a mediation, a lot of things are clarified. People focus on the cases, things become clearer. So people found it a useful experience. So for me, then my cases started to grow with time. And then 12 years ago, I decided to do this full time. So I do 1 or 2 cases a week now because it's grown over time. And I'm close to 1,000 cases now, okay? Honestly, okay? And every experience is a challenge and is very enriching if you settle for parties because we see the impact on lives, on companies. That's the benefit of mediation.
Thank you. So now I turn to Tony from Vietnam, and I think many people have some impression that in Vietnam, the people may want to have amicable settlement discussions, but we don't see many mediations so far, perhaps. And what is your view?
I think, first of all, I agree almost completely with what was said by Seong Kim and Claire, especially from the enterprise perspective. And that happened exactly the same way in Vietnam. So people always come to us and ask, what is the value of the mediator? We have to pay for some like other third parties for what we already have done it by ourselves, and it was not successful. So there's a very big like ambiguity of what the mediator can do to improve the situation. So it takes, as George already said, it takes a bit of time for raising the awareness in Vietnam. We started in, I think, 2017, so it's about 10 years ago, when our mediation center was established with the support of the IFC. We had a lot of training and everything, just in the same way as any like emerging mediation market. But until now, we still hope to have some like fraction of what George can have done. We have, I think, about 36 cases so far. So it's not a very high number compared to arbitrations in the same like organization. Vietnam Mediation Center is part of the VIAC, and this year VIAC has 530 cases. So we sit in the same office and then look at our neighbor's desk and try to hope to have like 1%, 10% of that figures from our colleagues in arbitration. I just want to highlight very quickly what's the key problem in Vietnam, because we just heard from POSCO, which also have some few cases in Vietnam. Most of the time, the cases in Vietnam are with the state-owned companies or state-owned entities, because the state-owned entities still take a big share in the economy and in the commercial activities. And the problem with this public sector is that there are at least two things that stop them from doing mediation. Firstly is the audit risk. So the public sector always been operating under the supervision and within the spectrum of the auditors. So if we want to pay, we need the auditor to say, yes, we can pay. And if you do a mediation, you can't justify why you are paying. The auditor will come and say, this is a national auditor. Of course, after like Deloitte or KPMG, the national auditor always come and say, you have to justify why you pay this one additional penny. And that will give like all the autonomy or authority of the negotiators become zero. They just can't decide. And it becomes so serious that it comes a lot to SIAC and VIAC as well. When we have arbitration cases, all the cases are actually to acknowledge the amount that the Vietnamese state-owned companies have to pay to their counterparties. They can't take it from a mediated settlement agreement. So it's one big issue. And the second issue is actually the lack of the decision-making autonomy. There are so many involved officers or like silent stakeholders in the negotiation process. So if you negotiate with one private party, you are negotiating with either the contract manager or the legal manager or the director himself. If you negotiate with a state-owned enterprise, you are negotiating with the Ministry of Finance, you are negotiating with the MOJ, and you are actually negotiated with a lot of hidden people. So you can't guarantee that the person before you is the right person who have the full authority to decide. And you know, one of the key principles in mediation is that you need to obtain for the mediator, you need to ensure that the representative who come will have the authority. Otherwise, overnight, his boss will say, well, I don't agree with that. And what's the point of the whole mediation process, right? So that's a two key problems.
Yeah, thank you. You raised two very important points. I hope that we can have time to elaborate on that in the later part of the session. And can I now turn to Mr. Peter Korn, talking about the situation in China. I understand that in China there are huge number of court-related mediation, and I understand that a non-Chinese party may want to be involved in out-of-court private mediation, but what is the situation?
Thank you. Peter Korn from Shanghai Commercial Mediation Center. You've raised an excellent point. Indeed, we've had enormous growth in court-related mediations, commercial mediations. And that's arisen because the courts now have an integrated, multifaceted window where you can choose mediation, arbitration, or litigation. So that's sorted, at least on the domestic front. But we lacked regulations or a law that actually validated international or even domestic commercial mediation cases. And that was an impediment because many enterprises just didn't feel confident about using mediation, even under the auspices of an institution outside of the ambit of the court network. So there were two problems with that. Firstly, the professionalization of the mediation profession, because you can't have mediators that are going to be able to live off mediation and become fully professionalized when the court is taking most of the fee. That was the first problem. And the second problem has almost been resolved because late last year, there were independent commercial mediation regulations passed that will come into effect next week, actually, or the 1st of May. So that will give commercial mediation on a standalone basis outside of the court network the validation and the authority to grow. So we as a mediation institution are really looking forward to that. And that will also enable very conservative enterprises, such as, you know, the state-owned enterprises, the same situation in China, to actually be prepared to take the risk and have a basis for taking the risk or the perceived risk to venture down that path. So we're looking for growth in that respect.
Thank you very much. And then lastly but not the least, could I now turn to Professor Park about the situation in Korea? I think you may have some similar causes and perhaps something unique to Korea as a challenges to the use of mediation in Korea. So as a kind of founder of the Korea's first international cases focused mediation center, do you have any views on the situation of Korea regarding the challenges you see in the use of mediation in an international context?
Yeah, you mentioned uniqueness in Korea. Then I have to say the domestic situation. In a sense, Korea is kind of mediation country, mediation state, because there is civil mediation covered by the court and administrative mediation covered by almost all government bodies, and also even criminal mediation covered by the prosecutor's office. But in terms of the global standard of mediation, then I don't think Korea has not been able to practice in a good way. So that is a big problem for Korean people, Korean governments, Korean businesses to do mediation properly, even in international sense. And for the KIMC, actually, we are purporting to conduct a international mediation, but it is not yet so successful because I think the other international mediation centers are doing very well. But fortunately, our court understands the need to foster the kind of the environment of international commercial mediation. So fortunately, KIMC has been doing some business cases involving one big company as one party, and also at least one representative of the party is from a major law firm in Korea. So as we discussed, found this morning, Korea ratifies the Singapore Convention. I think there will be a very good momentum to, understand properly the usefulness of mediation in Korea.
Thank you very much, and warm welcome to joining the convention as a ratified state.
I hope so. Thank you.
Okay, now we move to another question. What role should governments and courts play in promoting the use of mediation? Maybe the focus could be on the courts. And may I now ask Ms. Heather E. Lee from Malaysia, what initiative has the Malaysian government undertaken to promote mediation? I understand that unlike some other countries, the AIC promoting both arbitration and mediation. So I understand that you have interesting comments on the government's role.
Yes, thank you so much, Mr. Tezuka. In fact, for all our attendees who may not be aware that Mr. Tezuka is also on our board, we have actually launched our inaugural Court of Arbitration this year. So we are very happy to have Mr. Tezuka in our Court of Arbitration, contributing his expertise in the field in our institutional works as well. So moving back to the questions, in fact, before that, let me thank again ADB and ADBI for inviting us. I'm one of the newcomers for this policy dialogue, although it's the second session. I wasn't here last year, but we are very happy here this year. And in fact, if I can share a little bit about Malaysian perspective, because in the earlier session, I think our representative from Malaysian government is not there. So if I can share a little bit about the ratification status of the Singapore Convention in Malaysia. Last month itself, last month, March 2026, the Malaysian Parliament actually passed both the lower house and the upper house actually passed a bill for the international settlement agreements resulting from mediation. So we are looking at this being implemented upon us getting the royal assent very soon. And from there, the Minister of Law actually announced that they will have the ratification of the Singapore Convention. Similar to Korea, we actually have signed the Singapore Convention, and as well as China, we have actually signed the convention years ago, but we have not gotten the ratification done. So now with this progression, I think slightly faster than Korea now, we already get it passed by our parliament. So hopefully from there, we will have more awareness and also promoting the use of mediation. And of course, the government, upon the passing, they have actually announced also some initiative, which the Center AIAC also echoing and also contributing to this initiative of what we call as a pro bono mediation. Because we have heard our panelists here a while ago talking about the issues, the concerns for the users, cost, how much the mediator's fee is gonna cost, all right, and then what's time concern. So from there, actually, we have actually just launched it last week of our pro bono mediation. And positively, I'm very happy to share that after launching, we have a lot of applications coming through, willing to take up as a pro bono mediator. So this is one of the initiatives where we are trying to take away the cost concerns for our potential users of mediation in order to promote and encourage them to come for mediation. On top of that, actually, AIAC is doing another mile extra, is that not only of giving it for free, we also have our guidelines that will be in place that could possibly resolve also the concern just raised by our panelists just now. What will be the procedural guidelines for mediation so that it will eliminate the concerns of how you're going to go through the mediation through an arbitral center. And like Mr. Tezuka just said, AIAC has been here for many years actually. We have been here for close to 50 years now. We were established in 1978, and when we first established, we are not only providing arbitration services, we also provide for mediation services. So over these 50 years, about 50 years, we have seen a rise in arbitration, but not to mediation. Of course, there's a steady rise, but not in terms of numbers, not a lot. All right. So from here, we are echoing the initiative of government, and hopefully we get more cases coming to the center as well. Thank you.
Thank you very much, and another warm welcome to the convention state. Okay, now moving on to the neighbor states, Brunei, and thank you for your participation. And perhaps you could try to focus on the government role.
Firstly, let me begin by giving my thanks to ADBI for inviting Brunei Darussalam to speak at this conference, this dialogue. I think I'll take it from I know that I was introduced as being part of BDAC, but I'm also legal counsel for the Prime Minister's office. I have a foot in each pool. So let me just speak perhaps on the experience of Brunei Darussalam. We have only recently developed our mediation infrastructure or framework in Brunei. By recent, I mean we begin in 2021, perhaps that could be the start of point. With that, we've engaged with Singapore, we've engaged with Malaysia, AIAC, on how to perhaps quicken or hasten the acceptance of mediation in Brunei. So we've formulated a three-pillar strategy. Firstly, we've looked at ensuring that we have a capable mediation workforce or capable mediators, credible mediators. And with this, we've worked with Singapore Mediation Center to have a SMC BDAC accredited mediators. Currently, I believe our number of mediators stands at 61. So there's quite a lot for, just to inform, Brunei has only a population of about 500,000. So quite small, but so 61 to 500,000 is quite a large ratio. Number two, we've worked on the promotion of mediation to both companies, corporation, and on the grassroots level. We've also actually engaged our village leaders, our local village leaders, which surprisingly to us, when we engage the more rural areas, they've informed us, oh no, we do practice mediation on a day-to-day basis. We have a village leader who we go to resolve our issues. So we were actually taken aback by that. So that comes, the reason I say that is because that comes to our challenge later on, which I'll deal with. So thirdly, the third pillar of our strategy is to ensure that we have up-to-date laws, rules when it comes to BDAC specific laws, when it comes to the government as a whole. So when it comes to the rules, we've only recently updated our BDAC rules this year, last year. And with respect to the law, although we feel that mediation should be flexible, the actual process, we recognize that there is value in ensuring there's a level of credibility to mediators. So we hope that with the introduction of a law, that we can inform the public, look, these are the accredited mediators, this is the level of trust that you should have with them. And with that, there should be some sort of benefit to being accredited mediator. So we're currently developing the law, which we hope will pass. So those will be the three pillar strategy that we have. We've tried to accelerate as much as we could. However, I think there are still some challenges that we are facing. Perhaps we can frame that in a better way. There are opportunities that we can address. So I think one of the main issues, there's quite a number, but perhaps I can raise two. Number one, as Dr. Anna stated in her presentation, is the issue of trust. So not only do we have to have trust in the system of mediation or the mechanism of mediation, but that trust has to be on the same level as the existing mechanisms. So in this case, Brunei is a very litigation-heavy, litigation-centric system. And the trust placed upon the court system is quite high, especially amongst the population. Not only do we have to ensure that there's trustworthiness in mediation process, but it has to be the same level as trustworthiness as the litigation process. So I think there comes our challenges. And trust, more than anything, yes, you can explain to somebody how mediation works and so on and so forth. But trust is built, like George said, is built over time. And there's something that perhaps we can't accelerate or rush. If there are any suggestions on how to accelerate that, I would be more than happy to hear. And the second issue is perhaps overinflation of the prospects of winning by counsel. So we don't dictate how counsels work, but there may be counsels who overinflate the prospects of success in litigation, and that might deter potential clients away from mediation. So thank you very much again for giving me the opportunity to speak. Looking forward to hearing perhaps some feedback or discussion on the challenges that I've posed. Thank you very much.
Thank you very much. And then from the government support to judiciary support, so I would like Honorable Justice Robin Knowles to talk about the roles to be played by the judiciaries.
With thanks to everybody for the fact that we're here together and for all we're learning. The question has been framed about promoting the use of mediation and the role of the courts in that. I think if I may reframe it, the courts are firmly in the business worldwide of promoting dispute resolution. And mediation is one of the fully fledged methods of dispute resolution, alongside arbitration, alongside litigation, and alongside conventional negotiation. If we look at it that way, then we avoid the trap of pushing the wrong things at the wrong time to the wrong process. Instead, we're all focused, and this should be in everybody's interests, clients especially, to find the right process at the right time. I think the courts worldwide can really play their part in this, but it's alongside others. It's alongside a frame set by government. It's alongside increased familiarity in the profession. It's alongside some of the learning that can come from success stories. But the tools that are available to the court include the following. First, if a matter reaches the court, then a judge can give an objective view that it's worth considering mediation. If it is, that's worth something to the lawyers. It might help the clients, not with a decision to accept the mediated outcome, but that somebody else from a place of objectivity has said it's the right time to try it. The courts can manage the case, which on the face of it is heading to a litigated outcome. They can manage it in a way that would maximize the chance of mediation being the best method. They can bring some discovery requirement in early. They can require that the issues are framed at an appropriate point. They can take steps at the case management stage to position mediation if it's to be suitable. Within CIFOC, that global forum of commercial courts, the globally agreed case management principles envisage the court doing just that. And of course, the courts have got other parts to play in this. I briefly mentioned these. First, to make clear that if the mediation doesn't work, the courts are there to take the case through to a conclusion. That solid backstop is a good focus for the mediation path. Second, the courts are there to be ready to take those cases which aren't suitable for mediation, which are positively suitable for litigation. which will set a precedent, define the meaning of a generally used contract provision, and achieve other objectives, which may be the objectives that clients are looking for. That's why I said this isn't about trying to push everything at mediation. It's about pushing the right things to the right place at the right time. And of course, the courts are there at the enforcement stage. Could I just take one more minute to touch on that against the invaluable backdrop we had at the session before lunchtime? That was a session that looked at the impressive lineup of countries that are on the path to full-fledged engagement with the Singapore Convention, but they're not there yet. And two reasons were given for that. The first is the process of embracing international convention or treaty of that nature. And the second is building up the infrastructure that goes alongside it. But just think about the role that the courts have already got in this regard. The courts are already there. They are the ones that will support mediation by enforcing the agreement that is reached through mediation. Courts are there to enforce agreements. A mediated agreement isn't any the less an agreement. The court is there to enforce them. A mediated agreement is unlikely to be the agreement to which there is a defense to a claim. And the courts are there to move to enforcement, rapidly, even in this point when we don't yet reach the Singapore Convention. And as for infrastructure, as all of the contributions have brought out, it takes time for mediation to play itself in, to win the trust, to build the numbers that eye-wateringly George takes on. It takes time, but you can start now. 1 good result, 5 good results, 10 good results. You can start now with the court ready to enforce. None of this for a second means that we don't need the Singapore Convention. All of this means that every one of those countries lined up here before lunch could be saying, whilst we're waiting to get to fully fledged Singapore Convention, we can get on with using mediation when it's appropriate. Thank you.
Thank you. And thank you very much.
Can I just share something?
Yes, 3 minutes.
Thank you. Thank you. Quick one. No, so we talk about the role of the courts and government, and our topic is practical measures. So I want to give 3 examples. Maybe you can use it in your country if mediation is still new. So the first one was when we started the mediation in 1997, our Chief Justice at that time, so he knew lawyers were the gatekeepers of disputes, right? So he said, let's do a training course. And he personally invited all the senior partners in the law firms to attend the course. And you get an invitation from the Chief Justice, you better attend. All right. Now, that course was very successful, and we won over a lot of senior lawyers. And you know, if you're a junior lawyer, if your senior partner, your managing partner is trained as a mediator, that opens the doors, right? So that was one practical measure. Think about it, maybe you can use it. Government, Attorney General did something good. They included a clause in all government contracts, public sector contracts, that if there's a dispute, you have to consider mediation. Not that you have to do mediation, but at least the duty to consider. That is something I think governments may be prepared to do, right? Consider. And then the third thing, of course, look, I'm really happy this morning, Yong-Sik, your session, so many government representatives. When we started, governments didn't know anything about mediation, honestly. I mean, I was at UNCITRAL 2014 to 2018. I don't think governments knew much about mediation, but today you all are talking about it. So the convention is a good way, and I think today one of the speakers says it's a strategy. It's a very strong signal, right? If the government signs or ratifies the convention, it's a very strong signal to the community that you are supporting mediation. It becomes a trusted process. Thank you.
Thank you very much. Then turning to the last question, what actionable strategies would you recommend to promote the use of mediation, some practical solution? May I ask Hida to briefly comment, maybe in 2 minutes, about what AIC is doing?
Thank you so much, Mr. Tezuka. So AIC, what we have done is that this year itself as well, a new initiative, food for thought for everybody as well. And I think it's quite an innovative move that we have launched our mediation rules 2026 that incorporated a schedule on concurrent mediation. So I've heard about those that are progressing with litigation or arbitration. They have a concern that if I were to consider mediation in the process, then it's going to delay the process of arbitration in event it's not successful. So this concurrent mediation is now in place under our rules. So for those that wants to try mediation, at the same time doesn't want the arbitration to put at halt abeyance, then they can actually opt for a concurrent mediation proceedings under our rules. So I believe that this is a very first time we are implementing this as well. And I believe in the earlier session I had with you, Mr. Tezuka, I think our discussion also had about concurrent mediation because that took into account the stakeholders' views and feedback when we are revising the rules. So, yes.
Yeah, thank you very much. And then Peter, any words in 2 minutes on the SCMC's initiatives?
Actually, I'm very glad you raised that because we're doing the same thing. Yeah, because the Chinese arbitration law was revised last year to allow ad hoc arbitration for the first time. So we've used that to do concurrent mediation arbitration by, as you said, launching mediation, and then if the parties are concerned about implementation of the mediation agreement, we can use the arbitration in order to adopt the mediation agreement and wrap it in the ad hoc arbitration. So then we can use the New York Convention to do the international implementation. Or if the mediation fails, then just proceed with the ad hoc arbitration. But again, without any delays, as you mentioned. So that's been a very key strategy in overcoming the hesitation about the possibility that it couldn't be implemented internationally.
Thank you very much. And may I ask Chino Sensei about the Japanese users' plan to make the situation better?
Well, I think in many Japanese companies' agreements, I think there's this consensus that arbitration does work. So, rather than litigation, arbitration. And I think the reason why that evolved is because our knowledge base increased. We know much about the ICC or the AAA or all these arbitration institutions. We have a very good view, at least the in-house community has a very good view of how arbitration works. And similarly, if the same thing could be done about mediation, as the justice mentioned, what are some of the good cases for mediation and at what stage? For example, even in a litigation. I think that kind of a knowledge accumulation, knowledge sharing, and our intelligence of mediation, that would definitely help companies be more comfortable in understanding that mediation does work, and it could be a very viable option to resolving disputes.
Thank you very much. And in my experience, most of the most successful mediation in complex cases didn't have a pre-litigation, pre-arbitration mediation clause, but the parties appreciate the effectiveness of the mediation and agreed after the disputes actually started. So I think the awareness building of the effectiveness of such ARP-MED litigation MED might be important. And maybe I should now ask Anna to briefly comment on the practical measures to promote the mediation after listening to the comments from the panelists?
Yeah, picking up on that point, I think more data is really important. And one of the in-house counsel I spoke to said when he was trying to encourage the other side to mediate, he looked around for data that was available, found some from a World Intellectual Property Organization and sent that to the other side saying, look, mediation works. But given the theme that's emerged earlier about this sense that mediation, if they've already done negotiation, why bother mediating? I wonder whether we have data that captures whether they negotiated beforehand and then whether they successfully mediated, because a lot of the data seems to be cost and time savings compared to litigation or arbitration. But do we have that kind of data set? Because I think that's important. If that's the reason they're not mediating. Dispute resolution clauses also, I think, really important to get mediation into the dispute resolution clauses. So commonly you see in the cross-border commercial context, negotiation, then arbitration or litigation. A lot of in-house counsel said in the domestic context, when you're from the same country, it's easy to have ad hoc suggestions. Do you want to mediate? I know it's not in the clause, but do you want to mediate? In the cross-border context, there literally and figuratively is more distance between the parties. So it's important to get mediation into the dispute resolution clause. And then we need data, more data probably to help do that. And finally, leading by example. So in the UK, we have a government pledge. So the government has pledged to use ADR for their disputes, and there's some data about how much money the government has saved from using mediation, other forms of dispute resolution. So leading by example.
Thank you very much. And then I would like to ask Professor Park to briefly comment on what you think you could do practically in Korea to promote mediation.
But actually, I heard Professor Howard mention very briefly about a mediative approach. Then I think one of the things to resolve is the accountability risks suffered by the parties in mediation. So I think there might be some mechanism to resolve that kind of risk. So I like to say there must be 4 steps. One, there must be ex-ante approval frameworks so that participation in mediation and the acceptable range of outcomes are authorized in advance. Second, the decision-making process should be properly documented, including available options, risk assessment, and the rationale for settlement. Third, organizations may introduce internal safe harbor standards under which decisions made in good faith and on a reasonable basis are protected. And finally, the use of a mediator itself plays an important role because it shifts the perception from an individual decision of a party to a structured and facilitated process of mediation. Thank you.
Thank you very much. And talking about Japan's Mediation Center, JIMC, in Kyoto, of which I serve as the head, what we have been doing is to somehow get involved in the Japanese government's efforts to promote arbitration, not only mediation. So this year is the 3rd year of the Japan International Arbitration Week. And we have been successfully tagged in to make the Kyoto Center's event in Kyoto as the last day's event in a more enjoyable venue. So that kind of efforts to promote not only mediation, but also arbitration and mediation, or maybe ARBMET, is what Japan is trying to do. And secondly, I see that in some jurisdictions, there are some competing mediation centers. So that makes the situation a little bit complicated. And Kyoto Center is essentially to provide the best venue for mediation. And we are fine with providing venue for JCAA mediation, ICC, AAA, or AIC, Chinese Mediation Center. So the venue is an important part. So I think that kind of very modest approach, not to compete with any other association, is our approach. Okay, so, please.
Sorry, I thought that if I don't make this 1 minute, I will lose a chance to introduce to you the Vietnam ADR week coming in May. It's between 25th and 29th. And we have exactly the same situation where the two biggest mediation centers in Vietnam, since last year, we started to do like together events. And the events is actually open to not only students, but also professors and teachers, and a lot of lawyers and professional mediators have been invited to join as judges. And each of these events, we got up to like 500 people. So it's a very huge event. That's one of the way that we improve the knowledge and raising the awareness of the mediation users, like lawyers.
Thank you, Honorable Justice.
Please come if you can arrange a time.
Few words.
The reference there to students and those in training is key, because it's there that the mediative approach begins. It's there that our lawyers become problem solvers, and it's there that choices between these forms of dispute resolution become part of the way of thinking. Could I address just a little bit more at the accountability point? The emphasis has been put on accountability for the result of a mediation. But within most corporations and businesses, there are two other types of accountability in play in the big dispute. The accountability for the cost of the process and the accountability for the time that the process can suck out of the business. A dispute that lasts for years and involves key personnel is damaging. But I hope that the more we use mediation, the more we can help all concerned to see those dimensions of accountability. And so the settlement decision takes the alternatives and their lack of attractiveness into account as well. The last point is about the way in which these forms of dispute resolution can interact. There's the true form of integrated dispute resolution that you see from time to time in the very big cases. There's a point of law that might need to be tested on appeal. That goes to litigation. There are then a lot of points of fact across many parties. They need an evaluative decision. That goes to tailored arbitration. Meanwhile, a mediator is looking across the piece to try and take out some of the issues that can be taken out earlier and to wrap things up at the end. That type of example really shows this is about the right form of dispute resolution, and everybody wants that choice to be correctly made.
Thank you. And now I would like to have some few questions from the floor. Up in the end, Professor Hayakawa. But please kindly try to make your question short. We have 5 minutes.
Okay, thank you very much. And I will quickly make a kind of comment. And perhaps, the benefit of mediation, all of us here, agreed with the benefit. The problem is, as Mr. Kim or Ms. Chino pointed out, many business corporations felt, the mediation cannot guarantee the final, the decision. And it might be a wasting of time only just. So that is the point. And I think the one of the solution is add meet up at the very beginning stage. We should include such kind of the provision add meet up. And anyway, the final decision could be guaranteed by the arbitration clause. But inside of the arbitration clause, we could put it the mediation clause, and so that we have a many chance or opportunity to have a mediation in the period in the process of the arbitration, and we could do the reach amicable solution. So I think that hybrid style should be much more emphasized. That is my idea how to think about it.
Thank you very much. Maybe we have already talked about the usefulness of such a hybrid system. Oh, please. Oh, you have microphone on the desk.
Thank you very much for the presentation. Roberto Chante from the World Bank. I would like to see if the panel or someone in the few minutes that are left, we could drill a little more differentiating between mediation in normal commercial disputes among particulars and investor state mediation, because I think the political economy is radically different and we risk mixing apples with oranges. I really would like to hear more about the Vietnam experience. I think that the point that you're making with SOEs is it's true. We have in the World Bank work on that in many countries, but I just would like to see if we can a little begin to be more specialized, especially since we're going to go into the next panels. Thanks.
First of all, I have to say that I'm not here on behalf of any governmental bodies or organizations. I'm here as a VMC representative. So one of the very first and biggest mediation center. But of course, I can give some perspective of the differentiation between the state investors mediation and the normal commercial mediation, which we are conducting at the moment. I think the key difference here is the decision-making process. It's completely different between two commercial private parties, and where one of the parties, the disputing parties, is a government. And the second is, I have heard of this quite in many cases, where the governmental party will need a lot of evidence, which is not particularly right in mediation. In mediation, we don't talk about what we can get from the evidence, who is right and who is wrong. It's not really part of the modern mediation. But in the government's box, everything need to be evidence so that they don't get caught in the later stage. So that's the problem with the governmental parties, and that caused a lot of difficulties in the state investor disputes. I think in Vietnam we are encouraging this a lot. If recently you've seen the Working Group 3 discussion right now, Vietnam also play a very active role in this, and we want to promote this in a lot of events and seminars and explore this. And as I learned, the latest information I got is a task force has been in place for the Vietnamese government to deal with the state investor disputes in general, which mediation form a very important part. But it cannot be anywhere near the commercial mediation that we are doing day by day. There are certain difficulties and differentiation as I shared earlier. Yeah.
Thank you. Frankie, you have any comments?
Thank you. Yeah, I appreciate the differentiation of the discussion, and especially to really keep in mind that certain aspects from a pure commercial mediation with two private entities do not necessarily translate or are well translated into the investor state context. We'll explore this a little bit more tomorrow in the 7 minutes that we have. So I take a moment now. But especially if you drill down, if you really look into the investor state mediation with those experienced, and you have an experienced mediator on the panel who can add examples from practice, but three things are different in the investor state contract. First, at the outset of the mediation, an experienced mediator in investment disputes will engage with the government party and will discuss the authority to negotiate. They will take the time to discuss who needs to sit on the table. In reality, right? There's a formal process and there's an informal process. And if you have a good mediator, that is a discussion at the beginning. The government is not alone. The next piece of it is what we were discussing, what you shared, the example with Vietnam, and the decision-making process is different if you have a public entity involved. And here again, when you have an experienced mediator in investor state context, that discussion is on the table. And there are different mechanisms to avoid that you have an outcome negotiated that then the government needs to justify. What we need to stop thinking about is like the mediation process is one and something else happens then. What happens with a good mediator is that you have this approval process. The acceptance of the solution is going to be built into the mediation. In countries, we have two webinars on this. In some countries, negotiated settlements go to a government accountability office. There is an assessment written, or it goes to an administrative court. So we just need to be more creative in the process design around the solution in order to take note of the political context of the investment disputes as such. And that goes also to the aspect of like, who needs to be involved in the mediation. And if you have a good mediator and an investor state settlement setup, you have a mediation among all the government entities that are involved in the resolution. So these three things are just different when we engage with it, and we can continue to discuss it tomorrow.
Thank you very much. And fortunately, the time is up. And if you have any question, please come to any member of the panelists during the coffee break. But again, thank you very much for your excellent presentation and discussions. Thank you very much.
Thank you very much, Tezuka-san, and to all of our panelists. So we will take about a 15-minute break for coffee in the next room, and we'll resume session 3 at 2:45.
Okay. Did you enjoy? Yes, very much.
Actually, I went to
I just got your email where you sent us where you sent us
This is the session 8 and
no
we'll
this one,
send, closing
this one,
session.
closing session.
Yeah,
Not 8, closing session.
Yeah.
I got the I think I got Byung 6 charts. Yeah, what are we going to talk about? We don't have to I just want to make sure I do my part. Okay. Thank you for your very frank I think no, I think it's good because we've been talking to different Vichy, the thing that I got move on, Japanese are very open, right? They're not litigious in that sense, but there are two problems. One is that once the corporation decides to litigate, you cross the line, and it's hard to then mediate. It's important. Right. And you don't think about that before. And so that's the thing that I got. You follow the process very faithfully. And so once you cross that, it's hard to then say, let's consider mediation, because the Japanese will say, I thought we tried that. So it's time to fight, right? So that's one challenge that we have. And of course, the second challenge is that it's their profitability and efficiency. It's going to be guys say, it's not my job. I'm not paid to do it. I'm not paid to make decisions or be a lawyer's job. So that is a challenge. Can I just introduce one idea to you? Which is something that I've been thinking about. You know, with the advent of AI, and AI is just going to get better. So I don't think that AI is suitable for our decision. Because we never have AI done. Never have AI. But it sorry, I'm just exploring an idea here. But if AI improves, and we see it with SIMC, you see it improving so much that in the near future, I don't know when, AI will be able to start only outcome prediction within a range. I'm not saying that it should be that within a range. And within a range of possibility, within a range of how at that point, and I think we'll get there sooner than that process of new mediation as a way of telling the party, all right, this is AI. We're not, the mediator is not saying this is my decision, but this potentially could be the outcome. And within that framework of the outcome that AI has, we should consider a mediator framework and outcome, but that provides a snake parameter on the path to then dictate, accountability, but my decision is within that, and therefore my accountability is less. Because
이분도 알아. 이분도 법무부 과장이셔. 인턴 하시는데 서울대 나오시고 경영대에서 인턴하는데 ADR 관심 많다고 그래서 꿈나무한테 저 SIMC 소개시 인턴하라고. 이렇게 젊은 애들이 좀 알아야죠. 그래가지고. 근데 과장님이 중요해요. 과장님이 이거 미디에이션 정말 중요하구나. 느끼는 게 중요해요.
하세요. 이걸 좀 하세요. 시각화처리 못할 리가 뭐 있어요, 우리가. 제가 법대 나왔잖아요. 그 협상만 30년 했어요. 이제 FTA, 국제조세, 그다음에 국제금융, 집행 협상하니까 너무 많이 커요, 미디어션이. 그래서 이제 오늘 저치 많이 크다. 나중에 하자.
네네.
Because we're dealing with the whole rate, right? So I'm looking at IP, looking at different. IP is the other way. The other one that I think the AI will be quite good at, right? So it's fascinating. So when we look at this is one area with the aid of AI and mediation where the best goes.
Good session. Interesting. Those lawyers, I'm telling you, they try to take control, they rule the world. They just want to. He's very passionate about that. Beat the lawyers down. Yeah.
They lose that motivation. Never. Right.
Yeah, money will, it's a good incentive. Hi, Derek. Doing really well. Very good moderation. A pro.
Yeah, it's okay. You can share. Who's missing here? Kwong. Okay, so we're Ashwita is online. Lakshmi is online. They're trying to locate her, but I'm sure she'll come on. If not, you can fill the background of it. But I'm sure she'll.
Oh, she sent a message.
Yeah, then you can step in for Lakshmi.
Oh, they're having Zoom link problem.
Having Zoom in problem, and Lakshmi. Get on. They're having, oh, they're both on. Oh, okay, sure. Okay. So maybe that was a while ago.
Oh, okay.
So they're on now? All good? Okay.
Yeah, she sent me at 2:45. They're all in?
Yeah, their cameras are both on.
Can I talk?
Hello.
Hi, Lakshmi, Ashwita, can you hear us? We can see you.
Yes.
Yeah? Okay. Can you say hello so we...
Hello.
Can you see me?
Okay. No, they can't.
Thank you,
You can't see
Ashwita,
me,
for
but
the
can you
tip.
hear me?
No worries.
Can you hear me?
Yes. Yes. I can hear you.
Okay, good.
Yeah, it took some trial and error. The link was definitely
the
not
last person
working.
gets the
You're a
whatever seat
lifesaver.
that's not selected. I don't
I
know
was
why.
struggling. I was struggling as well. Yeah, I'm glad we're in. Struggling and stressed. I know, me too. Thank you.
Yeah, thank you, Frauke. Hi, everyone. We're going to start session 3 soon. Just waiting for a few more people to come in. Thanks. This is a very strange seating assignment. Should I come closer to you guys or just sit here? It's like real like student teacher thing. I haven't sat in one of these types of, what are these things called? These little desks in the classroom. Yeah. Yes. Thank you, Derek.
Okay, welcome back, everyone. Yeah, thank you. It's a short coffee break, but don't worry, we'll have another one after this session as well. So continuing on mediation, we're going to focus in the next session on mediation in state-to-state disputes. So this session 3 will be moderated by Christina Pak, the Assistant General Counsel of Law and Policy Reform at ADB. So Christina specializes in international development, finance, law and policy reform, dispute resolution, and ESG standards, and drives thought leadership on sustainable development issues. In her role as Assistant General Counsel for Law and Policy Reform, she manages the Office of General Counsel's Law and Policy Reform Technical Assistance projects across Asia and Pacific region. She oversees a diverse portfolio in the areas of private sector development, regional cooperation and integration, green transition, and digital transformation and gender equality. So Christina, the floor is yours.
Many thanks. Good afternoon, everyone. All that stuff that Derek said, I don't do it all myself. Of course, we have a big team that does everything. So it's a great pleasure to be here again for the second dialogue and partner with ADB Institute. So to further distinguish this session is, it's on state to state, but state to state trade or economic disputes. Basically, I think Anna from UNCITRAL in her opening speech kind of framed the importance of state-to-state disputes, especially now with a lot of strain in our trading system, obviously due to geopolitical issues, but also what's been going on for a long time is a lot of governments are, struggling with sort of like the smaller types of frictions, trade concerns that like sort of sit below things that could arise to formal disputes, but they've always been there. But what's new, I think, and timely for state-to-state disputes is really what's happening now, and the need to foster greater cooperation between states, so that the development needs and trade and investment can flow. So I think Anna also mentioned, and it's been sort of mentioned throughout through today, is that ADR in some form is not a strange thing in state-to-state disputes. Of course, ADR in one form or other are embedded within, free trade agreements and different regional economic agreements. But I guess the question now is that, why has an ADR taken off as in the commercial context, or even more recently in the investor state context, where, different frameworks are being established. Certainly, with commercial and now in investor state with the ICSID rules, the UNCITRAL rules on investor state. But in state to state, what is happening now? And I think also, this session will also draw out, just listening to all the different lessons learned. What are some of the, good practices that could be drawn out in the different, mediation contexts that could be applicable to state, but then at the same time, what are the peculiarities, the special considerations for state-to-state trade or economic disputes? So we have just like the most excellent panel here, comprised of, real people that are working in the trade policy space, like Kwang from the ASEAN Secretariat. We have, Anna, I mean, she's demonstrated how much research she's been doing on mediation and how we could draw from her experience. And of course, different institutions like UNCITRAL. We also have Ashwata. She's from the Permanent Court of Arbitration that have done a lot of state-to-state disputes, can also share the PCA's experience. And then we have no other than Lakni Hu, who's, basically she's been, she's got such familiarity in the WTO dispute mechanism and so much. So we have a great panel to really, delve deeper into how, I think we could all agree the moment for state-to-state mediation is now, but how it can be institutionalized. So before we start that discussion, I also want to introduce Professor Rajesh Sharma. He's been at it forever, and it's such a pleasure to work with you, Professor Sharma. We thought that, this is an area where it's a sort of an emerging area. So I think to give us all a little bit more information to work from, I'd like to invite Professor Sharma to start the discussion with a presentation. So the floor is yours, Professor Sharma. Thanks.
Thank you very much, Madam Chair. Colleagues, you can see my name is here and alone over there. So I am alone on the list, but certainly I'm not lonely. I have so many panel members here. Okay. The topic which we have been assigned, if my PowerPoint is up, is the state-to-state dispute. And particularly our focus is on the use of ADR and why the ADR has worked or not worked in which context. So that's the point we are going to look at it and we are going to discuss it. So if I continue from there, if you look at the traditional way of resolving dispute by states has been very clear, like, negotiation and diplomacy was the very first choice. There's a state, they always try to look into it. And if you look at in this list, I have deliberately avoided one way of resolving dispute, which we encourage or which always we say, don't use it and it should never be used. However, states still they are using it. The word starts with W, and I don't want to say any more words on that one. So diplomacy and negotiation has been very, very most tried and most used way of doing the diplomatic negotiation or resolving the dispute between a state to a state. But there are other possibilities and other avenues are also there. For example, use of good offices. Good offices, we can use it for helping the parties to come and negotiate or resume the negotiation and try to resolve the dispute. We have also tried mediation, or we have seen mediation and conciliation, meaning using a third party to intervene, whether it's a third country or somebody else. We have used it in the in the resolution. We have also seen the use of arbitration or a panel process in resolving those disputes. And the Permanent Court of Arbitration, coming from the old historical time, has been helping the countries to resolve the dispute. And within the United Nations regime, we have International Court of Justice. Whenever there is a violation of treaty, the case can also go on the ICJ, where the states have used quite a lot. And I can say that there are new developments. New organization has been established. This morning, Anna has already mentioned about the establishment of International Mediation Organization in Hong Kong to resolve the state-to-state dispute by mediation, and we will touch upon that. And by the way, I have become lonely over there, or alone over there, because my colleague from IOMED is not here. So Didi Jung asked me to touch upon that. So Madam Chair, my slides has a little bit extra information on that, but she's very fair. She has not given all the 7 minutes to me, what was allocated to my colleagues from IOMED. We have divided equally among all the panel members. So I will just take a little extra time on that one. So coming on to good offices are nothing. It's a negotiation process, but only involving a office, a good office. Good office means either an institution or a person in an institution helping the disputing parties to come to the room and negotiate, or if the negotiation has broken, then they bring them back in the negotiation. That's what they are thinking about, and that's the approach they have used it. In that case, a good officer doesn't do anything more. It's more like bringing the parties in the room under one roof on the table and let the parties to discuss. Because the idea is that if you do not bring the disputing parties in the room on the table, they will not discuss, they will not work it out. That was the idea, and this is what they wanted to look into it. But sometimes, and we have seen from some of the cases an example, is that what happened is that the person who has acted as a good officer has sometimes got little extra involved in that. And when they got extra involved in that, then basically they are assuming the role of a conciliator or a mediator. So they are trying to bring the parties together. The only problem is that the person always in the big office and the good office has so much of clout that parties have also dependent on that, and they have started using it. So if you look at historically the way it has been run, it was very difficult to clearly bifurcate that when we are doing the good offices, when the good officer has become a mediator, and when the good officer has become a conciliator. There was no clear demarcation. And that's why if you look at that, the process of good offices, conciliation or mediation, these three processes has appeared together in all the treaties wherever it is mentioned. And that's why it goes combination. You never see the one paragraph for good offices, one paragraph for conciliation, one paragraph for mediator. It comes in the same level and the same heading and subheading. That's the reason they do it, because it is very difficult to bifurcate when we are looking at it. So how we come up with the idea of the good offices? This concept was already there quite a long time from the Hague Convention. Those who are know about the public international law, everything starts from the Hague Convention. So Hague Convention of 1899, as well as from the 1907, all these statute or the public international law document have said that if there is a dispute, and particularly they say before you pick up arms, pick up the phone and start talking, start discussing, and start negotiating. And in that case, their idea was to use a friendly power to give the officers, the good officers role, and try to resolve the dispute and help them to resolve the dispute. So the power which, power who are there, like, that was discussed in that one. We are not talking about the middle power, which we have discussed this time, and now we are hearing it. Some power which is different than the disputing party, they can help the countries to come together and resolve the dispute. So those Hague Convention had this idea and this approach. If you look at the case file, in the modern sense, we get in the Sonora case versus exchange. In that one, we got the Justice Marshall. He used the word interchange of good offices. He mentioned this word, and it came in the case file for the first time. Yes, it has come for the second time also. Okay, so this case was the ground of modern day concept of sovereign immunity came from that case, and that was based on the good offices, meaning the good offices of a sovereign, they can act and they cannot be tried in each other's court. That was the idea. They brought it from there. Now, when we come to Hague Convention, and in 1945, when after the World War, when the the United Nations was established, it is surprising that what was a good office process, which was included in the Hague Convention, has never been accepted and not included in United Nations Charter. Article 33 doesn't mention about it. It only says all the ways of resolving the dispute. If you look at that, it says negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, and resort to regional agencies or agreements and other peaceful means. But they didn't say about the good offices. But by the time, some people argue that the use of good offices has become a customary international law because the Secretary General of United Nations, being custodian of peace and other, has acquired that status. Or if UN is that institution, then the Secretary General has become that role, and he has been applying. So far as there, even the interpretation of peaceful means has included the good offices. And then after that, the Secretary General has been very active as a good officer. Almost more than 200, 300 interventions they have made as a good officer, and some good examples to learn. I also want to share you some successful example of good officers, which we know about it. Many others are there, but I will just quote some. From there, we can learn the best practices. And I say best practices because those processes, we have resolved the dispute, which was very volatile. It was very involved of armed conflict and all, but they have resolved it. So there is something in those process that which we can learn. And we have forgotten 1993 Oslo process, which was the first accord between Israel and Palestine. And on that basis, the leaders, they got the Nobel Peace Prize at that time. And that was the Oslo process in that one. Sri Lankan issues has also been resolved through there. We also had the Iceland meeting. If you remember, President Reagan and Gorbachev, they were meeting in Iceland, but their idea was to get away from the glare of press so that they can talk on their own. So the good offices of Iceland was used at that time for their place of negotiation, particularly thought about it. Nepal, Timor-Leste has been the process of the successful case of good offices. And we also have a Switzerland, which has almost like provided a place as a good offices and resolved 30 cases and many more cases. So Norway and Switzerland has provided the whole country as a place for the good offices. Now, the successful use of good offices, these examples definitely tells us one thing, is that we can, if we learn something from there, we can use it in other dispute settlement mechanism also. And this is what we are supposed to do. But coming to a state-to-state dispute in the commercial sense, since the GATT has a history, the WTO has a history of coming from the GATT era to WTO era. In that one, the good offices didn't start right from the beginning. What we see now in Article 5 of the WTO process is the one session that it says that good offices, conciliation, and mediation can be used over there. And the Director General was given the ex officio position to act as a good offices. It was there. But interesting part is there. In 1995, when we had this GATT provision, there was no clarity that if I want to start a good offices mechanism, how I can start, what document I have to fill in, where I have to go, whom I have to contact. There was no rule at all. So assuming in Uruguay round, we had 6 years of discussion and we come up with this proposal and there was no details. And that was also the dispute settlement mechanism. If you remember, it was Professor John Jackson who asked the members that please do not run away. We still have to negotiate the dispute settlement provision. And because of it, professor, I know the professors are always like that. They always come at the last moment and create some problem. So he did that. And because of his insistence, now we have a dispute settlement mechanism. So many countries involved, and yet we did not have the rules on that one. Now, what happened? The impact of this, if you look at that, from 1995 to 2001, we had 242 cases between a state to a state, not a small number. But at that time, they had no idea how to use it, how they should start the good offices, how they can use conciliation or mediation. No process at all. So if you look at that in 2001, why I cut off it? Because in 2001, after 6 years, first time Director General of WTO, who was a Thai former Deputy Prime Minister, Dr. Supachai, he came up with the proposal. He came up with the idea that how the good offices conciliation and mediation process can be used. And he, by notification, he came up with some idea, the rule, some steps, some idea we had, and we started from there. And the first case which went over there, it was a Thai shrimp turtle case. It was discussed over there. And the later on, we used this one for other processes. Now, even in this one, I have to mention one point. These documents, international treaties, they do not mention anything about the definition of good offices or conciliation or mediation. Only in one footnote, footnote number 25, they come up with the 15, they come up with the idea that if the good officer just allow the parties to negotiate, he does not involve, then it's a good officers. If he involves, then it becomes conciliation. And if he proposes any solution, then it becomes mediation. What we know about the mediation in WTO and other treaty, it is other way around. Conciliation is like a mediation and mediation is like a conciliation, what we understand. So the definition came for the first time, process came for the first time, some idea came for the first time. That is what happened over there. And in that one, the mediation was defined in one line, the step by step. Still, there's no clear definition like UNCITRAL at that time, like, they had a process of mediation. They follow the process, not the involvement of the person. So that was the difference on that. Some examples, only 2 cases, one for the mediation and one for the good offices was used. So let's look at the good offices. EC banana case. This is the longest running case in WTO, 18 years that case lasted. Finally, this case was brought to the the good offices. And when the good offices was used, at that time, the Director General's office was used. Like at that time, the Director General of WTO was Pascal Lamy. He was the one who started that. Interesting fact, Pascal Lamy was one of the commissioner in the EU who was litigating the banana case for so many years. And he was the one who was in charge of the legal recourse against other countries who started the case again against the WTO, against the European Union. Now think about the conflict of interest. That was the person who was involved. Now he becomes the good officer, and then he was doing it. Everybody said that this process was successful, but now you look at the people who were involved, they were all saying, and this is my personal encounter with people involved over there, they have themselves said that we have no idea what we were doing. Even Pascal Lamy had no idea that when he is acting as a good officer, when he is acting as a mediator, when he is acting as a conciliator. There was no idea about it. So the process was not clear. Nobody knew what happened over there. So I asked one question to them. If you were trained in mediation or conciliation or how to run the good offices, do you think you would have done better? He says, certainly. If I have to go back and do this, I would do better. So now they know the process. So without knowing, these people were using this process. So we can look at it. Then the question is why there's a lack. Of course, I told you there was no process. Okay, so there was no process. But the one thing you have to remember that whenever we are negotiating this process of dispute settlement, the good offices, mediation and negotiation, from WTO onward, whenever we are signing any FTA, RTAs, you look at that, they are just copying and pasting from WTO. So if WTO went wrong, everybody is going wrong. Never in our negotiation we have presented. And Tawfiq, I can tell you that I was involved in the RCEP negotiation in Melbourne. When I presented the idea that how dispute settlement mechanism can be upgraded, when after 1 hour of presentation, members say that, Professor Sharma, very good presentation, but we have already negotiated our dispute settlement mechanism because it was involved in the rules negotiation, never discussed separately. So we have never seen any improvement on that one. So we never got the details rule in any of this. Now we are seeing some movement of some involvement that the good offices, conciliation and mediation might be implemented a little better on that. Some of the way forwards, I can only say that learn from the best practices. Always, if you are negotiating any RTAs, FTAs, think about that, how you want to implement the good officers, policies and all that. create a guideline, and they have some examples. Our panel member will tell you about the guidelines and how to use it. And we also say that when you are using it, the good offices, we just want little extra positivity, meaning using the case manager, using somebody to coordinate the meeting. That's what we don't want anybody to involve. But we also want a delegated authority if possible. In that case, if a good officer is changed into conciliator or mediator, or if parties they want to change into conciliator and mediator, they don't have to wait. They can just use the same person if they want. Otherwise, they have to stop, they have to terminate and go back to the new process. So they have to start on that one. And we also say that now we need in Asia, particularly on developing countries, we need a list of good officers and mediator in our list and conciliator so that we can use it as and when we need. So we need this kind of a thing. So allow the parties. We are not saying that this process is very good, but now we are in a situation that everybody knows the process. And if we have a good guidelines, then we can implement it better. So for the guidelines, I will say not enough, not too much in detail. We'll leave it here. When the time will come, we will tell you about it, or my colleagues will tell you about it. Okay. Thank you. I had something, but I can come back in.
Oh, sorry about that. Yeah, please go ahead.
Okay, very quickly, just to say that state-to-state mediation, when we were talking about it, Hong Kong has established an international mediation organization, particularly to focus on the state-to-state dispute, also investor-state dispute and commercial dispute. I just ignore the other two. Let's focus on state-to-state. 11 countries agreed to start the process. So they started with that one. 40 countries have already signed. On the date of signature last year in July, only 37 countries, but now 40 countries. Look at the names of the countries over there. From Asia, from Africa, from Latin America, everywhere you can find it. And this is the one thing, at least these countries have thought about that we want to resolve our dispute through mediation. Some of the salient feature of this process is that you can make a joint request to start the mediation. Or even one party can start the mediation, but they have to say that the parties have agreed in an instrument that they want to use mediation. Unlike private institution, where we generally request for mediation, and if other person agrees, then we start the mediation, this scenario or this process does not allow that. If you unilaterally start, then they will stop it, they will not register the case. That's what it happened. Another important feature is the involvement of third country. Third country is a very important factor in a state-to-state dispute. They say that if third country is involved, with their consent, we can start. But if the third country does not give consent, then even the case will not be registered if the third country outcome of the resolution will be affecting the third country. But they created a carve out, a kind of scenario over there, that if the interest of the third country is so important in resolution of dispute, then it will be considered that their deemed consent is there and we can continue.
Thank you, Professor Sharma. We'll definitely cover the third party issue later as well. So yes.
No worries. And that I leave it to my IOMED colleague to deal with it some other time. Okay.
All right. Thank you for that excellent background and diagnosing some of the issues with state to state. Obviously, the rules are still nascent, and but there are developments. I was actually going to start with Anna, but perhaps we could start with the WTO, and then I'll turn to you, Anna, because LACMI is on, just because it's the biggest trading system. But LACMI, maybe you kind of shed light on what is happening at the WTO in this space, and shed further light on the use of ADR, and as Professor Sharma said, ADR isn't just mediation, but good offices and other forms of ADR. So Professor LACMI, if you could just give us some background on in the WTO world.
Yes,
Are you
certainly.
there?
Yes. Can you hear me?
Thanks. Yeah. We can hear
Okay,
you.
fine.
Hello?
First, let me just say a quick thank you to Deputy Dean Byung-Sik Yong, who is very patient and so kind to invite me. to join this session, and I had to negotiate peacefully and online participation because I wasn't able to be there in Tokyo with you all. So apologies for that, and thank you. And thank you, Christina, for moderating this very interesting session. I propose to do the following. I'll just give a few remarks about the WTO and sort of a little bit of what's been happening there. And then I will perhaps share a few observations following Professor Rajesh's very excellent presentation on some of the nuts and bolts issues, on what's missing in some of the economic agreements, and some ideas perhaps that might be useful. By way of the WTO changes, like many international organizations, the WTO has been discussing reform. So it's not a stranger to this, it's not alone in this. And in discussing reform, dispute settlement is also part of that conversation among WTO members. So what might be interesting for those who are here is that sometime in early February 2024, there was actually a sort of a draft set of quotation mark rules floated around for consideration for discussion by WTO members by the then facilitator of the dispute settlement discussion. I believe he was the deputy representative from Guatemala, if I'm not wrong. It's called the Molina draft, and this draft contained a lot of detailed provisions regarding dispute settlement reform, because the current key document in the WTO is really the dispute settlement understanding, which is called the DSU. It's got kind of the procedural rule book or Bible of dispute settlement for WTO trade disputes. So this draft in February 2024 that was floated for discussion contained a lot of interesting provisions which were new, which were being proposed after consulting various WTO members. And part of that draft contained or included a number of provisions on good offices, conciliation, mediation, to try to expand on the provision that was very bare in Article 5 of the DSU, which Professor Rajesh showed in one of his slides just now. So the idea was try to give some meat to the bones and to expand that idea and tell WTO members, well, if you want to use good offices, conciliation, or mediation, here are some of the possible follow-up rules to talk about. Now, unfortunately, sometime in 2024, that facilitator was replaced. So that draft fell by the wayside, and it has not, to my knowledge, been picked up again. But it provides some interesting ideas of conversations that must have taken place in Geneva among the various trade delegations, which people looking at trying to get a sense of state-to-state dispute mechanisms in terms of these non-adversarial methods. What might have been ideas that were floated around. Now, they have not been accepted, of course, but they could represent some discussion points that we might think about. So that's basically what's the state in terms of that provision at the moment. That's still intact. There's no detail, as Professor Rajesh has mentioned. Now, beyond that, maybe what I can do is also to share a little bit of thinking on the idea of state-to-state ADR for economic disputes. What are some of the considerations and some of the challenges potentially? First of all, it occurs to me that we're talking about sovereigns here, because in economic disputes, we're not talking about commercial parties, we're not talking about investor with a state. Both are sovereign states. So there are very special considerations that would apply, and there are sensitivities and different issues that need to be considered. So one of the first things to think about is there even consent for mediation? If we're talking about, for example, mediation to occur for state-to-state economic dispute, whether it's be about a trade barrier like a tariff or a quota or whatever we're talking about. So is consensual, is voluntary? So where is that consent? Now, very often that consent is found in a treaty, like an economic treaty, for example, in an FTA, where the signatories to the FTA might say, yes, if there's a dispute, we agree that we could use good offices, we could use conciliation, or we could even go to mediation. So you might have a consent that is written in some agreement between the signatory states. So that's good. If there's a start, you can proceed. The related concept is suitability if you're talking about the means of ADR. For economic disputes, the question that comes to mind is a dispute always suitable to be submitted to, for example, mediation? Because sometimes sovereigns may want a ruling They may want a clear legal ruling because they need to take it back to their constituents or their population to say, well, we have this ruling and this is what the outcome is. Either we have to comply with it or the other side has to comply with it. This is what is on the record. So there are these considerations. Now, there may, on the other hand, be economic disputes where there might be the possibility that they may not need to have a legal ruling as such, and they can negotiate and they come up with what in trade circles we call a mutually satisfactory solution. That's a magic formula because under the WTO system, that's like the holy grail. You would like the dispute settlement to culminate in a mutually satisfactory or mutually acceptable solution if possible. That's always desired over an adversarial outcome, because it provides the parties with perhaps incentive to perform or implement because both sides are agreeable to it. So it's a little bit of the consideration of the sovereign state of mind and also the mutually agreed solution, which I think goes into this mix of whether or not a dispute is suitable to be submitted to ADR. So on that basis, just to pick up on Professor Rajesh's point on the lack of detail, if you look, for example, even at the ASEAN Protocol to Enhance Dispute Settlement, which is the short form EDSM, I think I got that right. The protocol on EDSM also is very brief. It contains a provision. Similarly, it follows a lot of the provisions in the WTO DSU. It also talks about good offices, conciliation, or mediation, and again, very brief. So in a number of older economic treaties, you find that the provisions are really quite brief, if there is one at all. And if there is one, they don't tell you where to go next, as Professor Rajesh said. Now, the difficulty of that is partly what to do with that, but I think it's also perhaps linked to a mindset that there's a lot more focus on panels and arbitration and so on. So sometimes the mediation provisions look, to me at least, in my opinion, look like the poor cousin. And they look like sometimes an afterthought, okay, we'll have that there, but then we really want to focus on these other provisions. So you can tell by the amount of detail in the other provisions. So it's a bit of a mindset. And one of the issues, maybe in the next part, when we talk about institutionalization or mediation, we can talk about this further, is how do we surmount this idea that it's just a nice to have provision on ADR? Could we mainstream it a little more? Now, just in terms of an example, we look at some of the newer FTAs. For example, EU-Singapore, there is actually a whole chapter on state-to-state mediation, chapter 15, I believe. So there are interesting provisions there that we can learn from. It doesn't mean that everybody has to follow the same set of provisions, but it is out there for us to study and to consider. Are there best practices in there that we can think about? And the other agreement, interestingly, which I found a separate mediation mechanism section is the Digital Economic Partnership Agreement, the DEPA. Digital Economy Partnership Agreement, which is one of the more quotation mark modern agreements. It's not a pure FTA. It sets out digital norms, digital commerce norms, and so on. So that one has a mediation mechanism as well, which also has interesting provisions that we can think about. Now, just in terms of the mediation process, if we want to answer the question of how to take a very brief ADR provision in an economic treaty further, what do we want to include? If, let's say, we were to expand on that, suppose that was what we were trying to do, perhaps for ASEAN or other trade agreements. What I would like to maybe raise is one very critical matter, which relates to the skills, not just of mediation. I mean, obviously, those are very important skills. And by now, we have a lot of training, capacity building in mediation, and a lot of very skilled mediators. But I would like to suggest that we need skilled mediators who have substantive knowledge of economic law. The reason for this is that the mediator plays a role in the conversations between the state parties. So the mediator has to understand what's at stake in terms of not just the law of what is being argued to be violated or not comply with, but also the economic and political context of an economic dispute. So if you have a mediator who does not have the depth of understanding, I think, of economic law, international economic law, there's a bit of a gap there, in my opinion. So it would maybe still be possible to have mediation, but the depth of understanding would, to me, be very helpful, which then leads to the related point that there should be some training for mediators who are skilled in international economic law, because or the other way around, international economic law practitioners to be trained in mediation. Whichever way it goes, I think that the two perhaps should go hand in hand so that the solutions that come out can be compliant with WTO rules. Because unlike investment disputes and unlike commercial arbitrations, for example, or commercial mediation solutions, your solutions in economic disputes may impact other economic rules, such as your obligations under the WTO. So there's someone who should be keeping an eye on whether that outcome that's negotiated is going to be compliant ultimately. So that's another point that I just wanted to raise. Maybe just one more point. The example that we have in ASEAN, there are already some provisions which relate to the ASEAN Charter and its dispute settlement mechanism. Now, the ASEAN Charter is not purely about economic matters, but it does refer to provisions in agreements which specifically deal with economic disputes and so on. And from there, if you have a dispute which is considered what is called an unresolved dispute, which comes under the Charter's language, there is a provision that goes forward into another path. So one of the questions I have would be, how would improving the ADR process in the EDSM be linked to this unresolved disputes process potentially and clarified? So that might be helpful, but perhaps I just leave it at that and we can talk about it if anyone has a question on what I am referring to. Is that okay, Christina?
Yeah, that's perfectly fine. Thanks, Lakni, for that, drawing out the peculiarities. But I also hear a lot of similarities. So maybe this is where I can go to Anna to draw out some parallels on the use of mediation for state-to-state disputes. Thanks.
Thank you, Christina. Yeah, so taking a step back, a point that Professor Sharma raised is, and others have also raised, is that states commonly do use negotiation for a range of contentious and non-contentious issues. So if we understand mediation to be assisted negotiation, which it is fundamentally, in theory, there should be no reason why states are not also willing to use mediation. I came across some interesting research by the late Professor Berkovich, who looked at, in particular, at state-to-state mediation in violent conflict, so not the specific context we're looking at now. But he found, looked at thousands of conflicts over, I think, about 50 years. He found that states were more willing to enter into bilateral negotiations than to bring in a third-party mediator. Now, I appreciate that's a different context, but I wonder whether the same may apply in this context of state-to-state non-violent trade disputes. So that raises the question, if states are more willing to negotiate just between themselves bilaterally, why is it that there is this reluctance to bring in a third party to help them with their negotiations? So a few thoughts, I've popped down 5 thoughts on why. So first, a theme that's emerged early and which we've discussed is there may be this sense that we have very experienced diplomats, very experienced negotiators who have negotiated with very able teams. What is a third party mediator going to bring to what we have already done and invested a significant amount of time and effort into? And that's an understandable reaction. And we have the challenge that we have a lack of data, because a lot of this work, a lot of the mediation remains unknown, the mediations that are being done. Secondly, it may not be politically acceptable for states to be seen to bring in a third party to help them to negotiate. A colleague of mine who works, again, a parallel sort of, she works in state-to-state violent conflicts, trying to help in that context. They work quietly, often behind the scenes, and they don't call it mediation. They call it facilitating dialogue. So I think that recognizes the challenges there about, is it politically acceptable for a state to bring in a third party? And then that links to Professor Lockney's point about then who are you using? Are you using a representative of the state to be the mediators? Are you using an individual? That opens up a whole host of questions, including the sensitivity about nationality when you have state-to-state mediation. Third point, states may be concerned about a disparity of power between the states and the lack of formal power that a mediator has to address that. Fourth point, they may be concerned that proposing mediation, a state proposing mediation, may carry some negative inferences, such as they think they have a weaker position. That's particularly sensitive if there is a disparity of power. So coming back to the point that's been raised by Professor Sharma and Professor Lockney, the importance of having provisions in the relevant treaties and the agreements that send the parties, not only that they can, but that they must try mediation, that sends it. So it's not, the onus is not unilaterally on one party to have to propose the mediation. And then my final point, and picking up on Professor Lockney's point about which mediators to use. So on a practical note, if states want to mediate, where do they go? It's a theme that came in a different context, came out in my research in the commercial context, but these in-house counsel said, okay, if I want to mediate, it's great we've got the EU mediation directive, but on a practical note, where do I go? I want a neutral body in the EU to go to that will tell me these are the mediators to use. We can help set it up. So on that very important practical note, where do they go to arrange the mediation? How do they have confidence in the mediators? Who's going to propose, help them find a mediator? And a point that Professor Lockney raised about the importance of an enhanced skill set in the mediators in those contexts. I found in the cross-border context in the EU, there was definitely an appetite for mediators with a greater skill set in the international context than in the national context. So they wanted a higher skill set. They spoke about the need for not only mediation skills, but also significant knowledge in the particular area. And then obviously when you're working internationally, you're also going to want perhaps cultural skills, language skills. And here we may want to think about co-mediation. So what we're seeing more and more in very complex mediations. I had the great fortune to work as an assistant to Lord Neuberger and Bill Marsh in the mediations arising from a disaster in England, the Grenfell Tower fire. That mediation was about 4 years, 2 very senior mediators and an assistant to help coordinate. And they each brought their unique and complementary skill sets. So what you might start seeing more is in state to state, if you want a deep knowledge of economic law of that context, you may not find similarly that knowledge in a very experienced mediator. You may need to bring a team together and have co-mediation. And that's also another way in which you could perhaps enhance any concerns about neutrality. You can bring a breadth of nationalities together. Those are my thoughts.
Thank you so much for sharing those insights. It's super helpful. I hope people are taking notes because this could obviously feed into making mediation work in a state-to-state context. Perhaps we could turn to Jay. I mean, it was great that Anna basically emphasized that state-to-state mediation is an important area. So we wanted to kind of hear UNCITRAL's views in this space.
So I think the question that was actually originally posed to me was what kind of disputes are amenable to mediations. So from the very beginning, I think as the UNCITRAL arbitration rules has been used to resolve state-to-state arbitration, it is possible that the mediation framework that UNCITRAL has developed could be used for state-to-state. That is the starting point, and that is the optimistic part. But I'm going to be a little bit more realistic based on what Anna has said, in the sense that I think we have to be a little bit realistic about what kind of disputes can be, state-to-state disputes can be solved through mediation. They can be, but as long as the states are willing to mediate those disputes. I think this is the starting point. And you have to understand that these disputes between states are not subject to arbitrations or litigations, and therefore it is not an alternative to something else. It is actually something that they have to resolve. And if they don't mediate, what's the backup plan is probably where we have to start from. As Anna has mentioned, I think the states have shared the same hesitations as businesses when they engage in mediations because it touches upon sovereign issues. It also has a lot to do with confidentiality issues. It's sometimes better to negotiate these things rather than to have a mediator. Also, it involves different issues, not only economic issues, but also political issues. And you need to kind of consider the entire package. And this is definitely not difficult to do in a mediation context. And of course, there's some difficulty in finding the right mediator, not about the authority to have it, but it is actually the credential people that can actually mediate state-to-state disputes. Another legal issue that is actually what Lockney has touched upon is what is the basis of the state-to-state mediation? There has to be some sort of a consent to mediations, but there has to be also a reason for the dispute itself to rise. If you look at it, there has to be some sort of a breach of something, or there has to be some sort of a state obligation. So we're talking about these FTAs and investment agreements. But if you look at even the current treaties, what you see as a state-to-state dispute is actually a dispute about the interpretations of the BITs or the FTAs. It is not a dispute about a breach of an obligations under those treaties, because under those treaties, I think it is when we go to ISDS, I think it's a different story, because the states may be subject to a claim from an investor through an arbitration. But for the state-to-state disputes, they don't really have that arbitration mechanism, and there is no mechanisms to bring another state to a case. So I think having done that, when you talk about an interpretation of an FIT or FTA or BIT, that is probably not amenable to mediation. And this is probably where I think mediation may be lacking, and this is why mediation is not used as often for state-to-state disputes. So I may have been sounding a little bit pessimistic, but I think this is the reality that we're facing.
All right. Well, thanks so much, Jay. Perhaps we could go to Kwang to really give that ASEAN perspective. I guess, like, what type of, trade disputes or concerns, trade concerns are ASEAN members, without naming names, but just generally that they're dealing with? Because I think it sort of like brings it to, the types of disputes that, for example, ASEAN members are, dealing with or grappling with. Thank you.
Thank you very much. I think, first of all, we would like to extend our gratitude to ADBI-ADB and also other international organizations for inviting ASEAN sector to participate. Very, very important and excellent dialogue here. Professor Rajas already mentioned exactly, accurately, that state-to-state dispute here and using the ADR is something very emerging issues. We know very well that for the WTO, we already discussed this matter for many years, and normally we use DSP to resolve state-to-state dispute. But for the ADR, I think this is very, very first time for us to use this mechanism for discussing, resolving the. We don't want to mention here is a dispute, maybe here is a disagreement between our state on this issue regarding the FTA. So we just want to share how as a member state discussing on this issue, want to provide a very accurate context on this matter. And we know that this matter is a different from the investor and state dispute. For other member states, yes, of course, we have the EDSM exactly as already mentioned earlier by Professor Loughney earlier. We have a full mechanism, but so far, member states, we have not yet utilized such mechanism. The reason why member states, we do not want to use such mechanism, because the first thing is we are brother and sister. We don't want to use a very, how to say, critical and not friendly, very unfriendly mechanism to resolve our dispute. And the second thing is also very costly. We remember that previously, 2 member states thinking about the possibility of using the EDSM, but one of the things they have to reconsider on this matter is about the cost. The cost is very high for invoking such a mechanism. So that's why our minister already tasked the official to discuss and find out a mechanism that we can shorten the process of resolving the disagreement among member states, less costly, and also still maintain the friendliness from among other member states. So that's why we come up with the ADR mechanism under the upgraded article here. And the dispute among member states here is just normally about the obligation about commitment under the existing article agreement. And such disagreement, it could be from the TBT, SPF, rules of origin, trade infestation, or custom procedures. And such dispute normally brought by the private sector. For example, we can say one exporter from Thailand, they may want to export some agriculture product like, let's say, durian, or maybe pineapple into Indonesia. And then Indonesia have some SPF measure or TBT measure imposed on such products. And the product could not enter into Indonesian market. Then the two countries invoke such procedure by the private sector, exporter and importer, on this matter, and they bring such case to our sector body we call as the ADBI-ADB to discuss and try to find some very friendly solution to resolve the issue. So in this context, we see that yes, of course, member states they have the full right to bring the case to the EDSM mechanism forum to discuss and find out a solution. But like I mentioned earlier, they so far have not yet used such mechanism. And we also share the view from some our previous speaker already mentioned. ADR, what we mean here is a goods of faith mediation consideration already there in Article 5 of the WTO. It also existed exactly the same language, very similar language under EDSM. But under such mechanism is considered as a legally binding process. So it means that once you already invoke such process, it means that you already participate in the dispute settlement mechanism and become binding, and you have to follow the process. But here in this mechanism, we try to use such mechanism independently, non-binding, and member state can withdraw or agree at any time for such process. And in this case, that's why we need to develop a kind of guideline on this matter later on. I believe that we will further discuss into this matter. So I just want to share here first how the nature of dispute among us in member state. And we look forward to welcoming more comment and input or suggestion on this matter. Thank you.
Thanks, Huang. It's really important to hear the views of states, why they're not unwilling, especially I guess a smaller regional economic, not like the worldwide, but why ASEAN might be unwilling to invoke the formal dispute mechanism, and why ADR could be beneficial in addressing, I guess, non-tariff barrier type of disputes. So we'll go to Ashwata. She's from the Permanent Court of Arbitration, and obviously they have a lot of experience in using ADR in different forms for state-to-state disputes. So Ashwata, maybe you could share a few examples. And then since we're sort of like out of time, I was also wondering if you could also talk about the third-party element and how that comes in. That way we could combine your questions. The floor is yours. Thanks.
Thanks, Christina. I'll try to be as quick as possible. Many thanks to ADB, the ADB Institute, for having me today and for accommodating my remote participation as well. I think ADR mechanisms of dispute settlement in the interstate space, mediation, conciliation, good offices, they're undergoing some sort of renaissance at the moment. But there has been a great focus historically in the PCA's work on these mechanisms of dispute settlement. And so to just go back to Christina's point in her initial comments, ADR is certainly not a strange thing when it comes to the PCA's work in the resolution of interstate disputes. As Dr. Sharma pointed out in his opening remarks, the 1899 and 1907 Hague Conventions, which are the PCA's founding conventions, they do recognize a variety of methods of dispute settlement, which include mediation, good offices, fact-finding commissions of inquiry, and they also provide for PCA administration of these sorts of methods of dispute settlement. Since 1937, conciliation has also been included in the PCA's mandate, so to the extent that there are questions about where to go and who to assist, certainly in the interstate context, some of these questions have been answered over 125 years ago. But just to turn to the case studies, Christina, that the main focus of my intervention, I thought I'd flag 4 examples of interstate conciliations that have been administered by the PCA, which also address, in the broadest sense, economic issues. I don't mean to refer to economic issues in a specialized context, such as the idea of in which trade, is referred to in a more sort of as a subset of international law, but just about disputes to do with money in the broadest sense, just to explain that these sorts of mechanisms of dispute settlement can work for disputes that primarily involve financial obligations. So the first ever interstate conciliation that was administered by the PCA was between Denmark and Lithuania, and it was in fact the request to administer this conciliation that broadened our mandate and allowed us to administer conciliations in the first place. A Danish company had contracted to construct a railway line in Lithuania, and Lithuania was meant to make certain payments in exchange in installments over a period of 8 years. The tricky point was that the sums were to be calculated in Lithuanian litas but paid in US dollars. In 1933, the US dollar was devalued, following which Lithuania paid the installments due but in depreciated dollars. And of course, the Danish company objected to this. So this is, at its core, a financial economic dispute. The Danish government then espoused what was essentially an economic claim and brought this matter before a 5-member conciliation commission, whose task was to determine whether the responsibility for these losses suffered by the Danish company due to the fallen dollar lay with the government. And the commission made a finding on this point and recommended that the Danish company should be indemnified for the loss resulting from the fall in the dollar. So again, a finding on a fairly narrow and specific economic point. The second conciliation that the PC administered was between Switzerland and France. In 1954, Switzerland approached a conciliation commission. It was established not under any sort of specific trade or economic treaty, but under a French-Swiss treaty for the Pacific settlement of international disputes. And there were two questions that were posed, the first of which was very much an economic question. It concerned whether France should have reimbursed Switzerland for the costs of the internment of a Polish division that had been fighting on French soil. The commission looked at the question, they proposed terms of settlement in a report that they authored, and on the basis of that, Switzerland and France were able to settle their differences. A third conciliation that the PC administered was between Greece and Italy, and the dispute arose concerning the destruction of a Greek ship in 1940 by an Italian submarine. Again, it was an economic issue that arose because the Greek government was seeking reparations for what followed from the destruction of that ship. The Conciliation Commission that was tasked with addressing this point submitted its recommendations a few years later in 1956. At the time, the parties had already agreed to an amount in compensation to be paid by the Greek government, but this case is still an example of how the Commission is able to rule on this sort of point. And these three examples take me to the most significant recent example that has also been raised, I think, in prior presentations, which is the Timor Sea conciliation. As many of you will know, in 2016, Timor-Leste initiated compulsory conciliation proceedings under UNCLOS, or the Convention on the Law of the Sea, against Australia. The primary subject of the conciliation was a dispute concerning the maritime boundary between East Timor and Australia. And the process was successful, and evidence of this is the fact that the parties were able to reach what I think Professor Lockney had called a mutually acceptable solution, which is the ideal outcome in these cases. They signed a new maritime boundaries treaty at the UN headquarters in New York in 2018. However, what is critical to note, and this also is a nice segue into the point on third-party participation, is that economic matters were very closely linked to this conciliation, which was primarily about maritime boundaries, because the procedure eventually ended up involving a discussion in respect of a special regime for the joint development, exploitation, and management of what was the largest known gas resource in the Sunrise and Troubadour gas fields. So these lay in the areas, the maritime areas that were disputed, and were called the Greater Sunrise. And so there were a lot of questions about the sharing of the resulting revenue and the need to sort of formalize the parties' agreement in a treaty and some sort of engagement between the parties and a private entity, which was called the Greater Sunrise Joint Venture, which was a joint venture that held the commercial license to essentially exploit and work on the Greater Sunrise area. So these questions, in addition to the maritime boundary, sort of were folded into the conciliation procedure. And just to answer your question, the second question of how third parties could be involved, the Conciliation Commission eventually created mechanisms by which the views of the joint venture could be taken into account in order to resolve the dispute between the parties. At the outset, while the conciliation seemed to largely be over maritime boundaries, the parties eventually did request the Commission to facilitate an agreement on the development concept for Greater Sunrise, as well as for the joint development and management of this resource. There were two prevailing concepts. One largely involves the gas flowing through East Timor, and the other through a plant in Darwin, Australia. And the parties had differing views on which one was the better concept, as did the joint venture. And so in terms of how the joint venture was folded into the process, once the parties agreed that there should be engagement with the joint venture, there was, first of all, an invitation from the Commission for the joint venture to provide the parties and the Commission with an analysis of these two different concepts for the development of Greater Sunrise. And there was engagement with the parties on what information was received. There was then, on the one hand, substantial trilateral contact between the parties and the joint venture. So there was, first off, an exchange of a huge amount of information between East Timor and the joint venture in a virtual data room. So everybody had a good understanding of the technical information that was available. And the parties and the joint venture participated in a number of meetings and conferences to discuss this particular development, the two development concepts that were available. There was also, on the other hand, contact between the joint venture and the Commission. So the Commission that was conciliating the dispute had separate meetings with the joint venture and also invited the joint venture to join the parties and the Commission in their own meetings. What's critical to note is that the joint venture was made aware of the confidentiality of the proceedings, and so any information that was exchanged was on the basis that this could not be shared more widely. While the Commission initially only facilitated first contacts between the parties, it later came to be that the parties wanted greater involvement of the Commission. The Commission engaged a technical expert, as well as got more involved in these discussions. And just quickly to conclude, although there wasn't a full resolution of this point, the Conciliation Commission's report does note that the parties were to continue with the process of seeking an agreement on the development concept for Greater Sunrise. And what ultimately happened was this entire conciliation process did result in a greater understanding of what the underlying issues were and a more substantial exchange of information between the parties. And I would conclude by saying that it's perhaps, the open texture, the flexible nature of conciliation that allowed for this sort of information to be exchanged and for the positions of the parties to be made more clear with the help of sort of a private party who wasn't a party to the conciliation, but had the information, the expertise, and a great stake in the matters that were being conciliated. I think I'll leave it there. Thank you.
Yeah, thanks, Ashiwata. The third party is a big issue, even in the state-to-state context, whether other governments can, participate, and then, of course, the private sector. But, even in state-to-state disputes, private sector, they have a huge concern, and they're the ones actually that are pushing for more, peaceful resolution of trade disputes between states because it impacts upon the private sector. We only have 10 minutes, so I thought maybe we could spend the last 10 minutes basically on the practicalities, like just from each of you, if you could just give like 1 or 2 pointers on how we can make state-to-state, dispute mechanism work. So Kwong, I feel like you're already doing this. This is like on the top of your mind. Maybe you could just bring out some what's happening under the upgraded ATIGA in institutionalizing ADR.
Well, thank you very much. Yes, of course, we are advancing on this issue with the support from Jung here, ADBI, and Madam Christina Park here from ADB, and also other consultant, Professor Rajas, and also other experts. Just want to share why we need to do this matter. For us, and we have almost hundreds cases. I think it's a very huge number. And I think majority of the case has been resolved. And just only about around 6 cases remain. And among the 6 cases remained, we see that some cases already over than 15 years, and some cases more than 10 years, and it's not easy to resolve. And like I mentioned earlier, people, member state, brother and sister, very reluctant to use EDSM
because of some reason I already mentioned earlier, and currently in other member states, we are using the secretary ADB to discuss in every meeting, trying to find some good solution to resolve member state. So all the things we mentioned here about good surface, mediation, conciliation already proposed, already discussed among member states with a very active role from ASEAN Secretariat as well from the chair of the ADB in discussing this matter. But yes, of course, some cases remain. So that's why, Minister, as mentioned earlier, we are already trying to advance on this issue.
Great. So we really look forward to, getting the ADR rules drafted and then showcasing that. So more to come from that. Anna?
And maybe I focus on sort of building and strengthening the institution. So I think it's important to recognize that whilst you need a sort of a structured and comprehensive approach, we also need flexibility. In the state-to-state mediations, you're not going to have the typical sort of 1 or 2 day commercial mediation. These might be very lengthy processes. And a very important part of the process is process design. So when we have complex mediation, so for example, the Grenfell mediation, I can speak about this, what's in the public domain, there was a significant amount of time spent building the process. So investing the resources and having the people around who can help to build those processes, particularly important in the international context where you will inevitably have people who've come to the mediation with different experiences of mediation, perhaps a more evaluative approach, perhaps a more facilitative approach. So building the process with them. In this context as well, confidentiality will be an important point. That generally in mediation, the content is confidential, but you may need to have sort of a carve out if states need to account for certain decisions made. We've talked about the importance of the mediator. So having a team there that are available, perhaps for quite lengthy processes, this idea about co-mediation. And then just briefly, my final point is the importance that those institutions can play in gathering data. Because if we want more use of mediation, then we have to be collecting, to the extent we can, the data to encourage states to put mediation in their dispute resolution clauses in the treaties and agreements. So, but what data are we capturing? So for example, are we going to capture whether they tried negotiation first? And if that didn't work, then mediation did work, so that we can show that value add that mediation can bring. I know we're tight for time, so I'll stop there.
Great. Definitely lots of research opportunities. Anna, maybe you want to take this up in addition to your other research. So Lakshmi, we'll turn to you on any insights on how to really institutionalize state-to-state mediation.
Yeah, thanks. Really interesting points and given me a lot of food for thought as well. Just 2 quick points. I think I want to talk about the process as well as the outcome. In terms of the process, I guess listening to Mr. Kwong, that there's a need to think out of the box if we are brothers and sisters in ASEAN and we're looking for the mutually agreed solution in a very efficient and sort of prompt way. So there are some ideas that are already in ASEAN documents. So for example, we could think about having a working group, panel of experts, or coordinating council, or whatever would work amongst the ASEAN members. So these are just some ideas which already have some familiarity to ASEAN members. It's not an alien concept. And maybe perhaps it is something that can be talked about. On the outcome of the mutually agreed solution, that is the objective of all this discussion. If we want something that is to address the needs of sovereigns, whether in ASEAN or otherwise, we have to, I think beyond perhaps a legal document. I think it's strange for a law academic to talk in those terms, but if we look at some of the newer provisions, as I mentioned in the EU SGFTA or the DIPA, it talks about a factual report after the mediation takes place. It doesn't talk about a panel report. It's a factual report of what's been discussed, what might have been mutually agreed, and what the parties plan to do, for example. So that might be something that is a more palatable outcome to consider. I'm not saying it's the only way, but those are some ideas to allow us to remain brothers and sisters and still have a constructive and useful outcome. So I guess I'll leave it at those 2 points. Christina?
All right, great, Lakshmi. Maybe I could turn to Professor Rajesh. I mean, all these things have been considered. We're looking at all different types of rules. Maybe you could just give a little bit more information on the, drafting the ADR rules under the upgraded ATIGA for the audience. Just a couple minutes.
Okay, just very briefly, we looked at good offices, conciliation, and mediation, these 3 processes, because that's what they want to implement and operationalize. So again, the question come back to say that if I want to use good offices, what I am supposed to do, where I'm supposed to go, which document I would, what I have to say.
There's options in the form of appendixes on the different ADR options.
So what we have done, and you heard about the WTO reform, Molina draft. Actually, in our team, we also have Marco Molina, who has negotiated informally and drafted in WTO. He is with us. We have taken this one as a different opportunity. We have taken it as an opportunity and its challenge is that if we can implement this one in an ASEAN group, then that might set an example for WTO and other regional organizations like Mercosur and other to think about that, how to use it. And these these steps or the processes have not been fully utilized, never thought about it. So this is what we are putting our creative thought and saying that if I have to use it, how I can use it. And we have looked at intra-EU, dispute. We have looked at all these political or any kind of good offices used by different organizations in different institutions. We are trying to learn the best practices, what worked for them, which we can translate it in here. And that was the idea. Making practicality and just giving one simple example, I give it to you, is that if you are requesting for a good office, then I can say it's a good office. I can say what is my complaint a little bit in detail, why I think this is a good, not a good thing, and this is an issue to resolve. Those are the factual things. But at the same time, I can save time. For example, I nominate, and if I'm going for mediation, conciliation, I say I'm nominating from my side these people to act as a mediator or conciliator, or I'm nominating this person to act as a good officer. I can do it. So right from the beginning, I already indicated who do I want. Another thing is that as a solution, I don't have to complain. The problem is a state-to-state dispute. Every time there's a complaint and the other person say, go away, I'm not listening. So we are saying that with complaint, can you also give a proposal, possible solutions? And if you can give possible solution, at least the other side can understand and try to think, okay, there is some solution. Okay, this person or this state can move on this issue. So a kind of negotiation we can start right early.
Yeah, so definitely watch out for this because the ADR rules are being drafted under the upgraded ATIGA. And I think this is something to really watch. And we'll stress test it with Jay to make sure that it's robust. And Jay, just something quick and then we'll wrap up. Thank you.
Yes, I think one of the questions that we get at UNCITRAL is whether the outcome of the state-to-state mediation is also subject to the Singapore Convention. I think this is more of a theoretical question and an academic question, but not in practice, because after state-to-state mediations, they don't usually sign a settlement agreement. They usually sign some sort of an agreement, but not a settlement agreement. And it will be very rare for a state to actually enforce its obligations in a different state. That's also very rare because in most cases, the result of the outcome of the mediation is something that is settled in the sense that they would refer more to a voluntary compliance rather than to an enforcement mechanism. And in the worst case scenario where the non-compliant state is not complying with the obligations in the settlement agreement, the other state has to go to most likely the court of that state to enforce the obligations under the settlement agreement. And there will be refusal grounds for that court to actually refuse the enforcement of the settlement agreement in any case. So in practice, while theoretically, the Singapore Conventions would apply to settlement agreements resulting from state-to-state mediations, but in practice it is very unlikely because of the nature of the mediations and the settlement agreement being more subject to voluntary compliance.
Thank you for that important point. So everyone, I hope you got a really good idea about the peculiarities of state-to-state trade, economic disputes, as well as the opportunities and what's really also happening in this space. Of course, it's not just the states, it's really also the businesses that are being impacted by the trade concerns and the frictions. So they are also advocating for peaceful resolution of trade and economic disputes by the states. So I just want to thank our excellent audience online, Lakni, Ashwita, and in person for their insights and just all the work that they're doing to advance work in this area. So a big round of applause for all of them. Thank you so much.
Thank you. Thank you.
Yes. Thank you very much, Christina, and again to all the panelists. So we will take a 15-minute coffee break in the next room and return here for the final session of the day at 4:20. So see you in 15 minutes. Thank you, everybody, for coming back for the final session of today. So we're going to move from state to state dispute to the prevention of investor-state disputes. So session 4 will be moderated by Professor Rajesh Sharma, who you met in the last session. So again, Dr. Rajesh Sharma is an associate professor of legal and dispute studies at RMIT University in Melbourne. And he's the director of the ADR RMIT Dispute Management Center and adjunct professor at the Academy of International Dispute Resolution and Professional Negotiation, and the program director, graduate certificate in dispute resolution at the university. He's has a lot of experience in giving training and taught courses on arbitration, mediation, negotiation, foreign investment, arbitration, WTO law, international trade, banking law, foreign investment in several countries. So Professor Sharma, oh, there you are. So I'll welcome you onto the stage to lead us for session 4.
Thank you. Thank you very much. You have already seen me, so I don't want to be seen quite like, even for an extra second. So in order to utilize our time, I would like to invite my first presenter to talk about this dispute. This panel is Mr. Kalamita, or Professor Kalamita. First, he's going to talk about that how the investor-state dispute can be prevented. And trust me, he has done lots of research in this area. And he has advised many governments and worked with the international institutions to really give you the details of that. So, Professor Kalamita, floor is yours.
Thank you very much, Professor Sharma, and thank you very much to both ADBI and the ADB for inviting me to be with you here today. If we could put my slides on the screen, I think that'd be a great place to start. While we're doing that, though, I hope that you will have found where at your seat this green book. Please don't dispose of it. It's actually something that I'm going to be referring to during the presentation as one of the tools or kind of tools that states can use with respect to the prevention of disputes under international investment agreements. And let me note at the outset that I've changed the title a bit. I'm going to be talking about dispute prevention and grievance management, so DPGM for short. And what I mean by that is a distinction between a dispute and a grievance. A dispute we can refer to as a formalized legal complaint, something that has been submitted to some kind of binding dispute resolution, adjudication, arbitration, what have you. And on the other hand, a grievance, which represents some kind of friction, disagreement between the investor and the state that has not yet crystallized into a formalized dispute. And that distinction is important when we think about what states can do to both avoid disputes, but also to manage grievances in ways that help them. So negotiating, investment treaties, very basically, obviously pose a great many challenges to states. There's the challenge of deciding whether to negotiate and enter into them. If so, how to draft them. There's then the challenge of managing the obligations that the state has undertaken once the treaty has been adopted. And then there's the challenge of defending the state in the event that a dispute arises? Well, in this presentation, we're going to be focusing on managing investment obligations and particularly dispute prevention and grievance management. It goes without saying that there has been an explosive growth in the number of investment treaty arbitrations over the past 20 years, more than 1,400 by now. I think this slide is 1 year out of date. And that's 1,400 claims that we know of that have been brought against states by investors under international investment treaties. We also know that over the last 10 years in particular, the size of awards rendered in favor of investors when they are successful has grown exponentially. According to data provided by UNCTAD, between 2014 and 2023, the average award when an investor was successful is $256 million US. That's an average, of course. But nevertheless, if you look at that chart, you see how quickly and how much there has been a rise in the size of arbitral awards. We also know that the costs of the state defending itself have risen. And with no due respect, no disrespect to the good firms named on that slide, one of which I used to belong to, on average, the state may spend approximately $5 million US in defending itself in an investment treaty arbitration. And the average duration, which for some reason I've left blank, is approximately 3 to 4 years. And as was said previously, that's 3 to 4 years during which people in government, instead of doing the day-to-day jobs that they have been hired to do, are spending time dealing with a complex, potentially very costly arbitration or dispute with a foreign investor. There are also hidden costs to investment treaty disputes. According to one estimate by Professor Rachel Wellhausen at the University of Texas, approximately 66% of investors who bring a claim end up exiting the market, whether they are successful or not. Moreover, other research has suggested that when the state faces an ISDS claim, an investment arbitration claim, just facing the claim alone has a negative impact on future FDI for at least the next 2 years. And that can be, as was estimated, $55 million US on average. So quite clearly, there is very good reason to avoid disputes. And those are reasons to avoid costs of disputes. But there are also other aspects to adopting procedures that can help states prevent disputes and manage grievances beyond avoiding costly claims and awards. As perhaps Roberto Ochandi may talk about, the World Bank has focused particularly on the value of dispute avoidance on the retention of investment within the country. And I think, as Professor Wellhausen's research indicates, that is borne out if nearly 2/3 of investors who bring claims end up leaving the market. We also benefit from avoiding those negative FDI impacts, but perhaps one other. Processes for dispute prevention and grievance management also tie into investment facilitation. As we will see, many of the measures that states can adopt to prevent disputes and manage grievances are also the same measures that states adopt to facilitate investment. And you can go through the draft WTO Investment Facilitation for Development Agreement and find in there measures that states take for investment facilitation that also serve the purpose of dispute prevention and grievance management. And I'll talk a bit more about that as we come to them. So what is dispute prevention and grievance management all about? A lot of it's been already said. It's about whole of government processes. And those whole of government processes are about coordinating government, coordinating governmental flows of information, coordinating decision-making within government, and coordinating the timely escalation and provision of legal advice within the government regarding a grievance or a potential dispute. How do states do this? There is no one-size-fits-all way. As we will see, different states have taken different approaches. Different states have different risk profiles. Different states have different legal systems. Different states have different levels of capacity. All of that factors into what the state may be able to or willing to do with respect to dispute prevention and grievance management. But it does not detract from the fact that it is essential for states to begin to think about, if they haven't already, preventing disputes and managing grievances with foreign investors. One more perhaps preliminary point, which is when we're thinking about whole of government approaches, who does that really involve? It involves everyone. It involves all organs of government. We know as a matter of international law that the state is treated as a unitary entity. So whatever one official does can be attributed to the state and cause the state potential responsibility and liability. But as a PhD by Zoe Williams indicated, when we go through the investment treaty cases that have been brought, at least up to 2016, what we see is that overwhelmingly, the measures that investors challenge, which lead to investment arbitration, are taken at the administrative level or within the executive branch more broadly. But that isn't to say that the legislature is not involved. 26% appear to be based purely upon legislative measures, primary statutes, primary regulations, and sometimes even the courts can cause the state to become liable or at least subject to a claim. So when thinking about dispute prevention, grievance management, DPGM, I'd like to suggest that there are perhaps, one can think about 3 different types of processes that can come into play in assisting the state in preventing disputes and managing grievances. And those are informational processes, monitoring processes, and remedial processes. And here's what I mean. When we're talking about informational processes, these are processes that in the first place make government officials aware of the state's investment treaty commitments. As has been indicated by other research, particularly by the International Investment Sustainable, the IASD, most investment treaty disputes arise through oversight and incompetence. And part of that is line ministry officials, street level bureaucrats, not having an appreciation of the fact that the state has entered into binding international treaties that, if breached, can lead to substantial liability for the state. So this is about increasing awareness of those officials, training them, providing them with handbooks like the one that you have in front of you. Also creating institutional memory within government. This is slightly different, but this is about ensuring that within government, there is somebody or some department which knows which treaties the states have entered into. It's remarkable the number of states that one can talk to where there can be a lack of certainty as to which investment treaties they have currently in force. Informational processes can also be investor facing. And what I mean by that is making sure that investors are aware of the operational requirements of doing business in the country, of establishing a business. And this is straight out of the investment facilitation playbook. But it's also making sure that they're aware of existing processes for grievance management, grievance resolution. These are just examples. Now, monitoring processes go a bit further. Monitoring processes attempt to keep track of what is happening within government and developing, if you like, data and information that will allow the government to take decisions in a way in the future, or which will assist it in avoiding disputes and managing grievances. There are lots of ways that this can be done. One way is by having ex ante review of legislation, of regulations, to determine whether or not they may raise questions with respect to investment treaty obligations. Most states don't do this. Some states do. Also, key government decisions, granting an important concession or revoking an important concession. Again, ensuring that when that decision is being taken, someone in the room has an idea of the state's investment treaty obligations and is able to offer a view as to whether or not this may raise issues. Another aspect of monitoring, which is different, but no less important, is collecting data and information sharing within government about grievances that have arisen with investors. So those are monitoring processes. They're designed to allow the government to understand what is happening with respect to foreign investment in its country and to monitor its own compliance, or at least ensure that it takes its investment obligations into account. Finally, remedial processes. What happens if, in fact, the government actually takes a measure which amplifies a dispute, amplifies a grievance, and puts it on the verge of dispute? This is about establishing processes to remediate the government's decision, or at least to allow the state to consider whether it should remediate or amend its decision. And this can take place through any number of processes: administrative review processes, investor aftercare services, ombudsman, and so forth. And finally, what happens with in really large grievances? What happens when there's disagreement within government about how to resolve a grievance? Well, this is focused on coordinating decision-making in government and, if need be, escalating resolution of a grievance, or how and whether to resolve the grievance informally to the highest level, sometimes to the presidential or prime ministerial level. So, yeah, this is essentially the overview of what kinds of measures states can take. I finish up just by talking about how we institutionalize this. And it means skipping over many slides that I talked about actually on this slide that I probably didn't need, as it turns out. And the point here is, even though these are mechanisms that can help to prevent disputes, resolve grievances, the question still becomes, Well, how do you institutionalize them? There's no one size fits all. There are different approaches. UNCITRAL, UNCTAD, the World Bank have done fascinatingly useful work describing the different types of approaches, institutional approaches states can take. The important thing to remember, however, is that whatever approach is taken, the key is coordinating responsibility. Who does what? Who is responsible for what? Thank you very much.
Thank you. Thank you. Thank you for excellent presentation. I know that there are so many things to talk about it and so many things to discuss. Maybe we will organize one session only or one program only for that topic. Come and sit with me here. Our next presenter is Roberto Enchandi from World Bank. He's a global trade specialist. He has also done so much work in this area and many other areas, including the World Trade Organizations and all. So please share your views, how we can prevent the dispute.
Thank you very much. While the slides are made, I just would like to thank the ADB and the ADBI for the invitation. It's a pleasure to be here with you. The slide that I have there, it doesn't show well, but it's supposed to be an iceberg. And it's supposed to be an iceberg because just to lend some concepts that already Professor Calamito already mentioned, we started this research program in the World Bank more than 10 years ago. And we wanted to understand, going beyond law, what goes behind, what is the political economy of the investor-state conflict. Why? Because as a developing institution, we work in trying to help countries attract and retain investment for development. And the whole logic of international investment agreements since the very beginning was to reduce the risk premium, to increase the certainty precisely of investors to generate this flow of FDI into developing countries. So we found here, this is, I will go very quickly, there was supposed to be a graphic that already Professor Calamita showed. My point was that we started talking about investment agreements and investment disputes with the increase in ISDS cases. Everybody was traumatized with the increase of these cases. And then we began to find out, when we started the research, we found that MIGA, the Multilateral International Agency for Guarantees of Investment of the World Bank, had done a lot of research a long time ago on what do investors care about? Why do they invest? What kind of risks they take into account? It's a very long, I mean, there's a big research that later at the end of the presentation, I will give you the book. I will just cut the chase because I don't have time to go in detail. The key point is that the reason why I put an iceberg in that cover is that it turned out to be that ISDS is just the tip of the iceberg. As you know, the majority of the volume of an iceberg is underwater, okay? Well, let me tell you the dimensions of that iceberg. We know the increase of investor-state disputes and the numbers and the costs, but what we found is that there is a huge cost arising from FDI relationships broken due to irregular government conduct. What I would call irregular government conduct is conduct of governments that, according to their own loosened regulations, are not supposed to happen, okay? Let's avoid illegal or not, let's say irregular. And the data is that based on all this work that MIGA had done, and later in the investment policy and promotion team we followed, around 25% of all FDI projects per year going into developing countries stops expanding or is totally withdrawn because of problems of government conduct. That's 1/4 of all the investment. So after all the work that a lot of governments here do on investment incentives, on investment promotional, I mean, trying to attract investment, after the investors go, around 1 to 1/4 of all investors leave. And why do they leave? Well, because, I will show you later, because of all these reasons, basically because of what we call irregular government conduct. The graphic shows you here, in red, the percentage of investment projects that are canceled in orange, the percentage of investment projects that are postponed. Sorry, the expansion is canceled. That one is withdrawn. The orange is canceled. The other ones are significantly delayed. The other considered leaving, and the green is that nothing happens. If you add this, around 25% of FDI then is lost every year. That is equivalent to 1,000 FDI projects per year, equivalent to $100 billion that is lost. And no one is talking about it. That's why we call it the blind side of the investment discussion, because the whole point of IIAs was to promote investment. And countries attract them, but are losing it. And so in other words, there's a hemorrhage of development happening, okay? Then this graphic, we can later drill on it. The key point that I wanted to make here is that later we want to see whether the conduct that generates investors to leave, usually quietly, without ISDS, because as it turns out, around less than 10% of the investors that leave go to ISDS. The overmajority leaves very quietly. It's what we call quiet divorces, right? You can have divorces with lawyers, or you can have quiet ones. And I call it divorce because the the investment relationship is a marriage. To take a decision of investor to go to your country and sink billions of dollars, it's a decision that takes time. And as in real life, a lot of when you marry, you not only marry your husband or wife, you marry your in-laws. And guess what? The point that Professor Calamita was doing, which is totally correct. We know that actually our data is a little higher, is 65, 70% of all the investment that is lost is generated by conduct of either sectoral government agencies or subnational agencies, okay? Particularly in services, we have all this data. Now, the key point here is that we notice that the main causes of divorces or investment lost is the same causes that later investors go to ISDS. So the key point that we wanted to prove is that there is a continuum in the investor-state relationship. If you see, we have been talking a lot about dispute resolution stage, and I fully agree, and I thank Professor Calamita for the introduction, distinguishing between dispute, which is adjudication, right? Already, the parties call someone else to solve a problem that they couldn't solve, okay? And this is already when a problem or a grievance has escalated in legal terms. Why this is important for the ISDS? Because remember, when you have the whole purposes of ISDS is to compensate for damages. It's about writing checks, and you have taxpayers' money. And it's very difficult then for states, once you have liability in financial, of a financial nature, to settle, because all the reasons that we saw in the previous panel. But the important point here is what happens before. And here you see what we call the conflict management stage. A conflict is unavoidable in any human relationship. We have conflicts. I have conflicts with my wife, with my kids all the time. The only difference is how you solve them or how easily it escalates. A conflict is just a disagreement. If I don't solve the conflict or the problem, it becomes a grievance. And if I don't solve that, it may escalate into an investor-state dispute. The importance of that graphic is that we notice that the investors take a decision to withdraw or to cancel projects just before they call the lawyers that we saw in the previous panel. By the time the CEO or the legal counsel gets involved, there was already you have a dispute in crystallization. The investor decided to leave, and now they're beginning to see how they minimize the damages or how they compensate. It's not clear cut. Of course, there are exceptions. I don't want to say this is black and white. Sometimes you do have negotiations in the dispute settlement stage because we did resort. But the key point is then that from a development perspective, the investment law should be about retaining investment, not about paying damages. If the whole point of investment agreements is to generate investment, the lack of, when you have an ISDS case, is a pathology. It's telling you that the IIA is not serving its purpose. The investment left. So what's going on? And that's why we started on the importance of catching the problem before the investor leaves And that's why we begin to talk about conflict management, how to manage conflicts in a way that leverages international investment agreements, what we call rule-oriented negotiation, to happen. But the problem, so here, the problem is, this is where we began to think on what would be steps that governments could take or kind of in order to precisely manage a conflict before it is too late. Usually, by the time the governments, the people that know about IAAs learn about a dispute is when they receive the notice of intent. By the notice of intent, you already have the bomb there. The conflict is already a dispute, the investor decides to leave, and then you're trying to pick up the pieces. If you went before that, hopefully, there's no litigation involved, there's no lawyers being yet into the picture, there's no check being demanded because there's no damage yet. There's a problem that has to be solved. Now, the key problem is how to differentiate a conflict that makes an investment be at risk of leaving from a normal grievances that is aftercare. And the key point is that we decided then to do these mechanisms to identify that very quickly. Now, before going to describe these mechanisms, let me tell you what is the challenge. We lawyers, we tend to think that states are monolithic. They are not. States is a fiction created by lawyers of accumulation of agencies and people and decision makers. So the problem is that when we negotiate IAAs, the state is accountable, but in reality, that state exists in paper. In reality, we have sometimes in some countries more than 300 different institutions. And the majority of the problems are generated by those lower institutions, sometimes from national government. So there's usually three key problems: lack of capacity to engage in quick problem solving, not even to mention to know about the IAA, because if I am, for example, a municipality in a little provincial government, why I will know about what is an IAA between a country? I won't. Second, even less I will understand what are the contents of the obligations. And third, there's all these people, it's like a disorganized band. When you have a band, each institution, imagine, is playing its own instrument, right? And they do their own thing. The in-laws in a marriage, they're not against the marriage necessarily, but their main job is not to make the marriage work. The ministries or the municipalities or the centralized, specialized authorities on regulation of finance or tax or whatever, their job is not to keep the investment going. They should, but they don't ever think about it. They go into their own silos doing their own mandates. So the key point is how you have a director in the orchestra to avoid all these little agencies doing its own script and doing their own thing, that because of this lack of articulation, you do not generate music, you generate noise. And that's actually the main problem. So how we do that? Okay, I will go very quickly because how many minutes I have? Like 2? Or okay. So this is kind of, later we can discuss on the mechanisms. Let me just finish with this point because it's very useful. How do we make then, we set up kind of a protocol to be able to be customized for the idiosyncrasy of every government, because each country is different. But the whole point was, how can we make political agencies, governmental agencies and politicians to do their job? How we empower a lead agency to discipline the other agency generating the problem. And we thought that measuring the investment lost or the investment at risk and the jobs that are at stake is a key political economic consideration, because every government in the world today has to show that they are generating jobs. That's the main demand. So all the system is designed to identify issues, filtering, some are aftercare, some are very minor, they're not. Then we identify the investment at risk by measuring and talking with investors themselves. And then once we identify the investment at risk, we see, okay, how many jobs are at stake, how much investment is at risk of leaving. And then on that, the lead agency then engages with the problem agency generating the trouble, negotiates on the shadow of the law. The key point that I want to make is that in this area where we call problem solving is where we see that there is a huge area for mediation that no one is paying attention here. Why? Because the mediation happens actually, or the negotiation happens not with the investor and the agency, but with the lead agency and the other agency causing the problem. And what we have found, we have different examples, and I can show you later. These are examples of all these: Bosnia, Georgia, Mongolia, Jordan, Rwanda, Ethiopia. We have other examples too. We have 10 in general. But the key point was that the capacity, or to have people ready to solve problems and negotiate and facilitate negotiation among agencies on a technical level, is scarce. We have managed to set up lead agencies and they do it, etc. Yes, you need locals to do that, but to negotiate in the shadow of the law, you have to know about the IIAs and what would happen. You have to translate the obligations. You have to take this notebook that Professor Calamita distributed, but you have to internalize it and talk on what would happen. And that is difficult. So we find that there is a big opportunity, but no one is talking about it because everybody thinks about mediation only between the investor and the state. And here, the investor usually is not that it's out of the picture, but the main dynamic happens between the lead agency of the mechanism and the troublemaker. And the lead agency has to have access to the higher power, to the president, to the prime minister, but that's not enough because you have to maintain the relationship between them. So you need the mediation amicable means to solve this, to address the issue. And if it's not solved, fair enough, it escalates, and then it may end in a dispute, fine. But then the state then takes that decision knowingly, and knowing that this is what is the policy choice that has happened. So in conclusion, we learn ISDS is just the tip of the iceberg. The real problem is the investment loss, or this continuum that no one is paying attention to. Rather than in the investor-state interaction, mediation services also will be, in addition, highly impactful in the interstage, problem-solving stage. These mediation services, and this is something, cannot be seen as a typical wage earning for lawyers because it has to be low cost, fast, easy to access, confidential, but there's certainly a need for external agencies, agents, external people, experts, facilitating the problem solving about that stage. And each for investment experts to complement the existing investor-state conflict management mechanisms. I'll finishing now, just to you to know, there's a big research done on data, on the pilots, on everything that I told you has numbers behind it. And you can find one of these publications in this. There are other two that later, if you are interested, I can share with you later. Thank you very much.
Thank you. Thank you. Please join us here. Now, I would like to invite our panelists here directly on the stage. Would you like? Anwar Tokibro, Chief Specialist Business Environment Development Department, Ministry of Investment, Uzbekistan. Followed by Boyers Zan Yarli, Chairman, Investor Rights Protection Committee, General Prosecutor's Office, Kazakhstan. Then Tanan Choinaran, Senior Specialist, Investment Policy Department, Ministry of Economy and Development, Mongolia. Aranda Yaseniye, Associate Legal Drafter, Legal Bureau, Ministry of Investment and Downstream Industry, BPKM, Indonesia. Somebody else is joining? What? Please. So what we should do? Say what we should do.
So
Hello, everyone. That was the announcement from the Kasumigaseki Building Management. There was an announcement that there has been an earthquake that happened, and it is affecting the greater Kanto area. Kasumigaseki Building has been a little bit affected. You can probably feel the building sway a little bit. The announcement just now was just to inform that the elevator will not be able to be used for a little while, and will be continue operating, won't be able to operate until further notice. That's all. Thank you.
So we can continue?
Yeah, it means you're stuck in the 8th floor. Let's discuss. Let's continue to discuss.
Okay. We were preventing a dispute. Now we have to prevent earthquake also, like, you know. Then our next participant is Tilini Kasuyala Ratnasurya, Secretary Mediation Boards Commission, Sri Lanka. And Shah Nusrat Jahan, Deputy Secretary, Bangladesh Investment Development Authority, Bangladesh. Please. Okay, ladies and gentlemen. That's it. You have just heard two of our experts talking about that how a state can resolve or prevent dispute. But you are representing your government. You are the state. So we are here to listen from you. In your country, how you are avoiding these disputes. What are the mechanisms you are doing it? And it will be very important to listen to you, because what they have said is their research. But what you are going to say is that what you feel. And as we say, where your shoes hurts, you only know about it. So tell us your pressing point, so that the experts can help you later on. Okay, so I will go in the same order, the way we are listed here. So I will first invite Anwar Tokirov from Uzbekistan to share your experience in your country, that how you are avoiding dispute. 5 minutes, okay?
Thank you, Professor. First of all, I want to express my gratitude to ADB and ADBI for organizing, inviting, and having a chance to contribute. So since 2017, Uzbekistan undergone a fundamental transformation on investment activity management. So in 2018, Uzbekistan FDI was $2.9 billion, but now it's reached to $38.4 billion in 2025. But at the same time, Uzbekistan, the government has faced about 20 international investment disputes. So, and the numbers are about $5-7 billion. So it's really fundamental, like I can say, that driver for building a comprehensive system of dispute prevention and resolution at every level of investment management. So we have like 3 pillars. I want to start with legislative base. I think it's one of the most crucial to prevent investment disputes. So I want to say that according to the law on investment and investment activity, a dispute must go first through negotiations, followed by mediation, then through national courts, and after that, all these stages are exhausted, it might be submitted to international arbitration, provided a valid arbitration clause exists. And it should be mentioned that this kind of multi-tiered mechanism ensures that disputes pass through several filters of amicable resolution before reaching formal processings. Also, we have law on mediation and law on international commercial arbitration. I wouldn't go into details because my colleague from Ministry of Justice in previous sessions already mentioned about that. And I can say also that we are now finalizing our investment code, which consolidating all investment norms into a single codified document with OECD, UNCTAD, ECG standards, and also with international arbitration like exceed UNCITRAL as a recognized mechanism for dispute resolution. However, the normative framework alone is insufficient without an institutional mechanism which help to implement this legislation into practice. So pursuant to the presidential decree, the Ministry of Investment accompany special investors, investment managers to all investors, starting from obtaining land plots, connecting to infrastructure, through to the launch of the project. Even aftercare services also are included. So I think this personalized end-to-end support system addresses operational grievances at the earliest possible stage. Moreover, the ministry has a lot of several digital platforms, but about investment, we have two important digital platforms. First of all, I want to mention about our platform, which is project management and monitoring platform. We call it PMI. It helps us monitor in real time all investment projects. Today we have about 3,000 investment projects over $3 billion. So this platform helps monitor automatically all process across agencies, milestone tracking, and escalation of bottlenecks to the level of deputy minister. In turn, a systematic dialogue between the state and business is ensured by the Foreign Investor Council. So under this council, we have now 11 working groups in vital areas like taxation, energy, labor, custom, construction. Now we also have working groups on responsible business conduct, artificial intelligence, creative economy, and circular economy as well. Each working group includes a representative from ministries, agencies, investors, experts, consultants. And the main idea of these working groups is to identify systematic problems, develop concrete proposals, and submit draft regulatory acts to the president, to the country's leadership. And in addition, since 2017, we have also business ombudsman under president, which also receiving investor complaints, analyzing legislation, and engaging with government bodies to restore violated rights. As many of you know, we also have Tashkent International Arbitration Center. So ministry closely operates with TIAC, and we are now developing
Hello, everyone. So that was the Kasumi Gaseki building management announcement. They just announced that they confirmed that the situation is safe and the elevators are working as normal again. That's all. Thank you.
Wow, what a relief. We are certainly having a rocking panel. Yes, you may continue.
Thank you. So we are ministry working closely with TIAC, and we are now developing the dispute avoidance protocol that is deemed to address the concern that investment disputes shall be addressed early and effective mechanism should be in place to prevent them. The protocol enables relevant stakeholders to respond promptly to early indications of a dispute and to obtain a neutral legal opinion by those who were experts that usually sit in exceed cases as arbitrators during the cooling off period. And also this protocol is activated when either an investor or a government authority identifies a potential disagreement that may give rise to a dispute and refers the disagreements to TIAC. And now also we, under new cabinet resolution, is being developed to establish a coordinating council under the Deputy Prime Minister with the Minister of Investment as its working body. The council mandates include systematic analysis of PIT's investment agreements and to formulation of a unified state position, coordinating of amicable settlement processes, and development of proposals for improving legislation. Resolution also provides for capacity building, so sending talented legal specialists to leading international institutions and law firms for training in international arbitration and introducing specialized courses on international dispute resolution in law faculties. So I can say that's one of the parts what we are doing. We also have one single window platform where investor can find every business procedures in one platform. Now we are integrating with over 15 ministries and agencies to cover everything, licensing, getting a land, and in the future, I believe in this year we connect every authority, so investor can write his problems and relevant ministry or agencies will answer, I think, in one day and solve all their problems. Thank you.
Thank you. Thank you very much. Yeah, we are pressing time. Now I feel what Christina was feeling before. May I invite Mr. Yarley?
Mr. Yarley is the chairman of the Investor Protection Rights Committee. Before he starts, we need a remote controller just for presentations.
Okay.
Hello, everyone. Thank you for inviting. Dear participants, speaking on behalf of the Republic of Kazakhstan, I want to assure you that my country is committed to the rule of law and the fair business principles. Today, we are developing a system of legal guarantees for investors. On December 70, 2025, by the decree of the President of the Republic of Kazakhstan, the Prosecutor General was given the power of the Investment Ombudsman. The Investor Rights Protection Committee was created. It is important to note that in international practice, investment ombudsmen are usually limited to making recommendations. The main part of our committee is having supervisor's powers. We have the right to review the legal actions of government bodies and issue orders that must follow it. The committee's main task is to provide legal support for investment projects at all stages. Prosecutors help with the approval process and the licenses. This system has already shown results. For example, we helped a Swiss company get land for an agricultural project in 7 regions. Also, we solved entry issues for specialists from other countries. This all allowed them to start a factory. Given today's topic, we want to inform you that the committee now acts as a mediator. The Commission for Pretrial Dispute Resolution is being launched. This will be a place for dialogue between the government and the investor. For example, an investor from Japan who distributes Komatsu equipment in Kazakhstan contacted us about building a repair shop for mining machinery. The investor had a problem getting approval for construction near a water protection zone. Using the committee's mediation tools, a meeting between the local government, experimental experts, and the investor was organized. The parties agreed on a solution that does not harm the environment. Our goal is to keep investors out of long court proceedings. In this work, it is important for us to study the international experience shared at this meeting. We are open to dialogue and are ready to collaborate on any topics you wish to address. To conclude, I hope our dialogue today is highly productive, and I also want to thank the Asian Development Bank and the Asian Development Institute for organizing this event. Thank you so much.
Thank you, Chairman. Yeah, so nice.
I would like to add something toward this. That assignment of dedicated prosecutors to the investment project and his proactive efforts since the beginning of the year have made it possible to protect the rights of 600 investors whose total investment round to more than $13 billion US. So coordination is carried out through the binding nature of the investment ombudsman decisions. Now, any of their instructions are mandatory for execution by all government and bodies. So
thank you. No, it's good information. Something extra. Well, I mean, this is important that we should know that what is happening in your country. So thank you very much for informing us. Next, Tanan. Tell us about Mongolia.
I will. First of all, thank you for ADBI for this opportunity, and thank you for the great presentations. Because in Mongolia, we don't have a formal developed dispute prevention system, but we are actively trying to build one on legal level and on practical level. And for the practical level, in 2023, I'm from Ministry of Economy and Development, and our ministry established the investment promotion agency called Investment and Trade Agency for the agency to be the bridge between the government and the investors. But as you mentioned in your presentation, different approaches for different states. For example, in Korea, their investment promotion agency handles all the grievances. But for us, the investment and trade agency only handles the promotion activities and facilitation, because we noticed that investors seek help and try to be in a direct communication with the ministry itself, not the promotion agency. So therefore, our ministry handles and receives all the grievances. And after analyzing the most common problem, whether it's in a common sector problem or more the common problems, we take it to a government level. And during the cabinet meetings, we try to address the the most concerning problems, and we give formal tasks to the relevant ministries to take action on those problems. And beginning of this year, our ministry established the Investment Protection Center. This is not a separate agency, but within the ministry. And ever since the beginning of this year, this protection center has been very successful because our sole purpose is to be open and be in a very direct engagement with our investors, very directly. For example, and the key feature of the center is to be in a direct communication with our investors, decision-making senior level officials between the investors. We make meetings, even our minister himself gets involved in these meetings. And as we speak, our team is revising making the draft of the revised investment law. So while we don't have a formal or developed dispute prevention system, we are trying to shift into the early prevention system. So yeah, that's it for Mongolia.
Thank you. I mean, your work is commencing over there or going on, so that's a good to know. Next, Amanda, about Indonesia, tell us.
Thank you, Professor. And I also want to thank you, ADBI, for inviting me to this stage. It's such an honor. And I agree to Roberto's presentation that ISDS is just the tip of an iceberg and just a symptom of broader problem. And hearing presentation from other countries, I think we try not to be Titanic, which got sunk by the iceberg, or as a country that got sunk because of ISDS and its awards. Many investor-state disputes stem not from substantive legal breaches, but from administrative failures, including delays in licensing, inconsistent regulatory implementations, and lack of coordination between central and regional authorities. I work in the Ministry of Investment and Downstream Industry, or BKPM. Its task is to coordinating policies related to investment and providing services related to investment licensing. So to address the delaying issues, we put effective positive approval, whereby license applications that have met all requirements and receive no response from the relevant authority within the stipulated service level agreement, or SLA period, are deemed legally approved. This policy promotes efficiency, transparency, and legal certainty in the business licensing process. Properly designed, we hope that and also with the safeguards for public interest and high-risk sectors, we hope that such mechanisms can enhance legal certainty, discipline administrative timelines, and reduce grounds for disputes. And with regard to the types of process for DPGM, as Professor Kalamita mentions, in Indonesia, investor concerns are captured through the one-stop service at the ministry, and also through the SPAN Lapor by Ministry of State Apparatus and Bureaucratic Reform. It's a platform that serves as a centralized system for receiving public complaints nationwide, focusing on enhancing openness and transparency. In addition, when disputes involve multiple ministries or central regional tensions, or about the strategic sectors, energy, infrastructures, mining, there would be coordinating Ministry of Economic Affairs and ad hoc task force to coordinate and to make decision-making in high level. We also already have the Ombudsman to ensure administrative accountability. That's all from me. Thank you.
Thank you very much. In a short time, you told us so many things. And I remember Australia was so scared. Australia was like, say that we don't want any dispute with Indonesia. So they took out the whole dispute settlement provision from their FTAs, like, you know, or in investment. So they said no investment, like we don't want to sue our friendly country.
Yeah, we're trying to prevent it and we try to minimize the problems.
Thank you. Thank you very much. Next, Tilini, tell us about Sri Lankan experience.
Thank you. I would also like to thank ADBI for inviting Sri Lanka to share its insights in this timely and very valuable policy dialogue. as the representative of the Ministry of Justice Sri Lanka, let me start with the legislative reforms related to mediation. Sri Lanka has a deep-rooted history of using amicable means to solve disputes. Actually, in 1990, the community mediation boards were established, and now we have a very strong community mediation system in Sri Lanka. Now we have expanded it to special categories of disputes, such as land and small financial disputes. Even though Sri Lanka had no comprehensive framework to address recognize internationally settled dispute until recent efforts to become a party to the Singapore Convention on 2019. And accordingly, Sri Lanka had enacted the recognition and enforcement of international settlement agreements resulting from mediation, Act number 5 of 2024 in January 2024. And the convention is now forced for Sri Lanka from August 2024. And also we have taken steps to introduce the Mediation, Civil and Commercial Disputes Bill, which is now tabled before the Parliament. And this upcoming legislation will allow multiple mediation service providers to administrate mediation instead of a single mediation center, which was had by the 2000 Act of Commercial Mediation Center of Sri Lanka. That act will repeal, and multiple mediation service providers will have the opportunity. With this enactment of domestic legislation, we believe that Sri Lanka will be seen by investors and trading partners as a country that can be relied on determining dispute resolution challenges in compliance with the universally recognized principles. When it comes to the investor state dispute management, Sri Lanka has several proactive monitoring and early warning mechanisms designed to identify and address investor concerns before they escalate into major disputes. These systems are primarily managed by the Board of Investment and the Securities and Exchange Commission and the Colombo Stock Exchange. Among these institutions, Board of Investment Sri Lanka acts as the central facilitator for foreign and domestic investors using specific departments to monitor the project health, such as Project Monitoring Department. That department will conduct regular reviews to track the progress of approved projects, identifying potential operational burdens or regulatory bottlenecks. And also the Investor Service Department serves as the direct interface for existing investors to report day-to-day issues regarding imports, exports, and administrative procedures, preventing them from turning into grievances. And also sector-specific officers are there. Dedicated directors are assigned to key industries such as pharmaceuticals, IT, apparels, to provide specialized support and early intervention for sector-specific challenges. Actually, I think this will give you an overall picture of the facilities provided by One-Stop Service Center of Board of Investment. When the dispute is not settled by the Board of Investment only, the investors will reach the professional mediators. And also, I would like to share a few more details about the interagency coordination provided by the Investor Facilitation Center of the BOI. As the BOI is geared towards promote ease of doing business and facilitating investors' touch points, BOI makes every effort to ensure that the investors engage in business in a friendly and favorable environment. Actually, the BOI's investment guide issued in 2025 is very useful for investors as well as the government institutions. As the Sri Lanka is in the journey of becoming the Asia's most preferred investment destinations, we strongly believe it is very important to pay attention and make arrangements to prevent investor-state disputes. Thank you.
Thank you. We believe it too, in that one. and welcome to the Singapore Convention family, as Mr. Tajuka will say. Like, very good to hear, and congratulations for that. Okay. Next, we will hear from Nusrat Jahan for Bangladesh situation.
Thank you very much. Like many of our speakers, I also want to thank ADB and ADBI for arranging such an effective seminar and for inviting Bangladesh. And thank you very much. Bangladesh was a developing country and recently escalated from the LDCs, it is development country. So we always consider FDI is a very important for our economic growth, job creation, and for some social phenomena. Bangladesh considers dispute prevention is a critical pillar for sustaining investor confidence and supporting long-term economic growth. While our system is still evolving, we have developed a pragmatic approach, combined legal safeguard, institutional facilitation, and continuous engagement with investors. From a legal perspective, Bangladesh provides a strong foundation for investment protection. The Foreign Private Investment Promotion and Protection Act. It ensures the key guarantee, including the protection against expropriation and the fair and equitable treatment. And we have an Arbitration Act, that is Arbitration Act 2001, established the framework for both domestic and the international arbitration. And beside this, which I want to mention that Bangladesh already signed more than 30 BITs, bilateral investment treaties. And recently in this January 2026, Bangladesh signed its first economic partnership agreement with Japan. These treaties and agreements includes the provision on investor protection and structured the dispute resolution mechanism, particularly the arbitration. In addition, major investment and joint venture agreements typically incorporate the arbitration clauses, ensuring clarity and predictability from the outset. And in institutional level, Bangladesh established Bangladesh International Arbitration Center, which provides a structured mechanism for arbitration and mediation under its 2019 rules. In parallel, business chambers like the Federation of Chambers and Commerce Industries in Bangladesh, we have some other business chambers like BGMEA, BKMEA, contribute by facilitating dialogue and in some cases offering informal dispute resolution channels at an early stage, which actually works better. However, the core strength of Bangladesh approach lies in the proactive engagement, I think, which actually our in the last presentation, our professor mentions about the proactive matters, the aftercare and some, they said Bangladesh Investment Development Authority or BIDA serves as the interface between the government and the investors. Investor may engage directly to the BIDA, or sometimes they come to BIDA through their national organization like JICA or ZETRO or the Eurocham or Chamber of Commerce in China. Sometimes they come through them. BIDA is able to identify their concern early and intervene before they escalate. When issues arise, BIDA plays a facilitative role or a proactive role, engaging relevant ministries, and they convenes interministerial meeting to ensure the coordinated and consistent decision making. This is a particularly important in a system where multiple agencies are involved in investment-related matters. And in practice, this coordination and consultation process function as a most important and effective informal dispute prevention mechanism. At the same time, Bangladesh recognized that we have some challenges, definitely, including the absence of a fully institutionalized early warning system, capacity constraint, and the complexity of multi-agency coordination. Addressing these gaps remains our today's priority. The government is actively working to strengthen coordination, enhance the digital platform, and to move towards a structured grievance monitoring and prevention system. In conclusion, I want to say the Bangladesh approach is rapidly evolving from a reactive model towards a proactive and a preventive framework, anchored in a legal protection, institutional coordination, and continuous dialogue with investors. Thank you very much.
Thank you. Thank you very much. So quite a lot of work going on over there. You know, from this discussion, it's very clear that you two are doing good research, you know, and you can always help them, like, you know. But I have one question from Anwar, like, you know, if you can tell us that you have a dispute avoidance system. Have you used it yet? Working on that. Okay. So still we have a system to learn. We have exactly 10 minutes. So two experts, I give you 2 minutes each to wrap up on that. Any suggestion you want to give them? Because they have said exactly what you were talking about. So if you have to give them any guidance who are setting up the system, Mongolia is still thinking about it, Bangladesh is going. So any key point, if you have to give it in 2 minutes, what you will tell them?
Well, I'm not going to give advice to government officials, but I would make the observation that it's an amazing and fascinating array of different kinds of approaches that you all are taking, crossing from investment facilitation to grievance management to dispute prevention. And I think what it represents is what one sees broadly, I think, across countries, which is that the mindset of the relationship between the investor and the state is changing. It's becoming a mindset where the investor and the state are partners. And the goal is to find win-win solutions when grievances arise. Because ultimately, investors are not in the business of arbitration. Investors are not in the business of lawsuits. They're in the business of business. And the last thing in the world they want to do is to get to arbitration. So providing them with off-ramps, if you like, where they can avoid that nuclear option is key. And I just say that what I do here as well, though, with all of these different developments, is that once again, coordination is key. And that's the key challenge. How do you coordinate all of these different initiatives? Because one person, or better put, a lead agency, needs to have the big picture. Somebody who can see what's happening across the investment landscape and be able to coordinate response, coordinate decisions, and escalate those kinds of grievances which seem unlikely to be resolved and may require political input or political decision making. Thank you very much for all of your insights.
Thank you very much too. I really was very impressed by your contributions. 2 concrete points. Just to emphasize, I don't know if you've realized how important what we're trying to do is. I think it's more than what you think. Why? Because investment retention is important not only to prevent ISDS. It's important because if you see the data, the reinvestment of investors already in the country is becoming the main source of investment every year in many countries, as high as 75%. So all your efforts that you do to improve the investor and state relationship goes into that point. The second reflection is the importance of evidence-based policy making. A lot of developing countries, we have a problem. We didn't have time, but there's a lot of data on the perception that investors have of our countries, on political risk and what kind of political risk we have. So we're starting not from zero. Usually, a lot of countries will start from minus, right? Because of historical developments. Fair or not, those are perceptions. So the key question is, okay, how do we use evidence, not only to show that the investment conflict management mechanisms are working, but also because it becomes a main tool for credibility for investment promotion. So for example, how much investment are you retaining? In which sectors? In which provinces? How many jobs? Which province is being more active, or which part of the country is being more active? In one of the pilots that we did, we even, one country even suggested to have a competitiveness index by province. And they inserted in one of the items the investment retention to see which province was most, how to say, competitive or efficient in generating investment, more investments every year, but of the investors that were already there, okay? So it was a relative thing. So my point is, what gets measured gets done, right? We can plan a lot of things, but evidence-based policy making is really important also for you to understand. Because remember that the main point of everything that we're talking here is development. It's how to make our people live better. And how are we going to make our people live better? And I say our, because I come from a developing country too. If we don't make the potential of FDI for development a reality. So it's about improving the relationship in the long term.
Sir, may I have just share my experience after evidence-based policy. Last year, we hold a summit, and in that summit, we consulted directly. We consult with more than 200 investors, foreign investors, and the local investors. And after hearing from that, we found out what is really our problem, what the problem they really faces. And we categorize them, and we find out 32 steps to resolve these. And some of them we already did the short term what to do, and some of there are long term do. So this really works. This really works, evidence based and information based policy. And one just for example, or just sharing my experience, our investor said that there is they face a problem that as investor is a cross-cutting matter, they need to go to many ministries, the central bank, and anywhere. So it is a hassle for them. The Bangladesh is new to them. They know in many things, and Bangladesh is not like so developed like a developed country. So what we do, we co-locate the key ministries and the central bank in one office. So when an investor comes under one umbrella, he can access all the key ministries and the central bank. And this is their process. And they suggest us, they had the main problem with our like VAT and tax issues. What's the problem? They said you don't have any continuation in your VAT tax issues. So we can't make any long-term business plan. Within a fiscal year, somehow you change your. Now, BIDA suggests the government, so please no arbitrary change during a fiscal year. And we develop a heat map, which is our main sector to invest. And in these main sectors, we suggest government that we will take a long-term policy that which helps an investor to make a long-term business plan. Thank you. Just to share my experience.
No,
Thank
it's
you.
very good. Your 32 steps we will learn later on. How do you do that and why 32? You know, can it be done? You remember something to say?
Actually, it really follows on what you're saying. And I just want to bring back this connection between the kinds of things we're talking about, dispute preventions, grievance management, and investment facilitation. And in the WTO Investment Facilitation for Development Agreement, there is a provision for developing and least developed states to conduct what's called the self-assessment. And I've done a couple of these for countries. And what this is really going through all of the regulations that the state has to see where are the inefficiencies, where are the blockages, what can be improved. And that's helpful for investors to make investments and operate investments, but it can also be an indicator of what's not working in the administration of the state that may ultimately lead to grievances as well. So information-based policy making, gathering that kind of information is critical. And so for those states thinking of joining the IFDA, I would encourage you to take advantage of the international donor support that exists to conduct these self-assessments. I think they're invaluable.
Thank you very much. Thank you. It was so fascinating. And as we can say, you may be thinking that you are still doing it, not reached yet, still thinking about it, but whatever you are doing now, you are doing for the future. And the future generation will look back and thank you. So please continue with that. Okay. And of course, you need anything, we are there for you. So thank you very much, please. Thank you. we had a very rocking session, but we finished in time. Now our coordinators will have another like 2 minutes to like wrap it up. So I hand over to Derek.
Thank you, Professor Rajesh, and to all the panelists again and speakers. So this is bringing us toward the end of the first day of this second policy dialogue on alternative dispute resolution. So to quickly recap, in the beginning, we had a keynote address from UNCITRAL's secretary, Anna Joubin-Bret, who really set the scene for the whole day, talking about the importance of mediation. And that was also highlighted by Jae-Sung Lee from UNCITRAL and Natalie Sharma. And we heard, country updates, progress that different countries have made over the last year since the last policy dialogue. And I think we also saw the importance of inter-ministerial coordination as we witnessed, Kyrgyz Republic actually has ratified, submitted their documents to ratify the Singapore Convention, whereas our representative was, a little bit of misunderstanding. So it really highlights the importance of this coordination between government ministries. And then we moved to practical measures to promote mediation. We heard from, we had a presentation from Professor Howard and also Songwon Lee talking about the in-house counsel and the different reservations or barriers different in-house counsel are experiencing, and also from the external perspective as well. We heard from arbitration and mediation centers across the region. And then in session 3, we moved to state-to-state mediation and talking about the importance of mediation integrated, for example, into ATIGA and the importance of that. And then finally, in the last session, we moved to prevention of investor-state disputes, which will help the scene, set the scene for tomorrow's session, session 5, which will be very important as well. So we will have from 6 to 6:30, we will have a short informal country sharing session to share best practices on ISDS ISDS best practices. So this is optional for those of you who would like to stay with us for this. And if not, tomorrow, this is just a reminder that we will start at 9 a.m. sharp with a keynote speech from Martina Polasek, the Secretary General of ICSID. So because we're in Japan, we like to keep things on time. So we will start at 9 a.m. tomorrow so that you can leave on time as well. So please be mindful of that. Yes. Okay. So we will actually move right into the country sharing session. So first, I'd like to welcome the Ministry of Justice from Korea, the Republic of Korea. So we have Public Prosecutor Yang, who will be presenting some cases. Okay. So after Korea, we will have a presentation from Armenia. So again, if you'd like to stay for this session, please be seated. And if not, please leave quietly.
Thank you. Thank you. To move forward. Okay. So, good evening. Good evening, distinguished delegates and colleagues. Thank you for joining us today. I am Junior Alex Yang, a public prosecutor who is currently serving as the team leader of the International Dispute Settlement Division at the Ministry of Justice of Korea. And it is a great pleasure to welcome you to our session today. It's a brief session and it's not formal. Just enjoy, please enjoy this session. And in my current role, I bear the responsibility of architecting Korea's defense against multi-billion-dollar investor claims. Currently, our ISDS division at KMOJ, Director Ms. Ara Cho over there, and our case team, including Mr. Kwon over there, and I manage a portfolio exceeding approximately $8 billion in ISDS cases. Today's presentation will focus on practical question, how a state can organize itself to effectively respond to ISDS claims, and how can it institutionalize this capacity. I will cover 4 areas. Number 1, Korea's 3-level institutional response framework. Number 2, 4 recent ISDS cases, each illustrating a different dimension of effective defense. Number 3, Korea's legislative initiative, the Bill on Prevention and Response to International Investment Disputes. Number 4, a brief note on the role of mediation in ISDS, drawing on my personal recent academic articles work. And before we dive into the entire session, I'd like to briefly introduce the actual engine behind Korea's ISDS defense system. On the left side, you can see our entire KMOJ ISDS division, our director Ara Cho, and 3 prosecutors, including me, and our brilliant government lawyers. This group photo actually made the cover of the ministry's English journal, and I must admit, we clean up pretty well when we temporarily step away from our mountains of documents. And on the right is us at a press briefing after our recent complete victory in the Schindler ISDS case. Yeah, we might look like a highly expensive boutique arbitration firm here, but I assure you we are proudly 100% in-house government officers, public servants. Now, let me show you how our ISDS system and ISDS team at KMOJ achieved those results. Let us begin with the reality of ISDS proceedings. ISDS proceedings involve complex legal, financial, and policy considerations. Defending a state requires us to operate flawlessly within an international legal framework, yet the underlying facts, decisions, and evidence are typically dispersed across numerous domestic ministries and agencies. This creates profound challenges. How do we consolidate fact without bureaucratic friction? How do we ensure consistent legal positions? How do we secure public international law expertise within the government? And crucially, how do we make timely, accountable decisions when billions of dollars of public funds are at stake? To overcome these hurdles, the Republic of Korea fundamentally overhauled its approach, establishing a whole-of-government, 3-tiered defense system. As you can see at the top level, An interministerial committee at the vice ministerial level provides strategic direction. Given that ISDS disputes concern the state as a whole and may involve significant financial and regulatory implications, key decisions on overall strategy and policy alignment are taken at this level. And next, at the second level, we operate an ISDS response task force composed of senior officials from all relevant agencies. This task force breaks down institutional silos and translates overarching strategies into actionable, coordinated positions. And next, working level is the final level. At the working level, our ISDS team, a dedicated International Dispute Settlement Division, a so-called ISDS division, at the Ministry of Justice, functions effectively as the state's in-house law firm. Staffed by dual qualified prosecutors and specialized international lawyers, we manage the day-to-day arbitration, meticulously control costs, direct and instruct external counsels, and maintain a permanent institutional memory of all legal and evidentiary records. Together, this three-level structure enables high-level strategic control, interagency coordination, and specialized legal execution within a single framework. Let me demonstrate how this system has successfully defended our national treasury and national sovereignty in our four most recent ISDS cases. Number one case, the first case I'd like to highlight is the Chinese investor Min case, because this is the earliest case in our victory history. In August 2020, a Chinese national filed an ISDS claim against Korea under the Korea-China bilateral investment treaty. The initial claim was $1.4 billion US, roughly 2 trillion Korean won, later reduced to $191.5 million US at the final stage. The claimant alleged that enforcement of security rights by a Korean bank, together with Korean court judgments and criminal investigations, constituted unlawful expropriation and a violation of fair and equitable treatment under the BIT. As the team leader directing this defense, I guided our KMOG's in-house lawyers and external counsel in a relentless factual investigation. We successfully proved that the claimant's investment was fundamentally unlawful. On May 2024, the tribunal issued its award, a complete victory for Korea, the first ISDS case in which Korea has prevailed entirely after full merits proceedings. The tribunal accepted Korea's core argument. The claimant's investment was unlawful. The claimant has established a Korean special purpose vehicle to obtain project finance from a Korean bank, but had done so through bribery of bank officials, resulting in criminal conviction in Korean Supreme Court. Under the BIT, only investment made in accordance with the host state laws receives treaty protection. An investment premised on criminal conduct does not qualify the protected investment. Accordingly, the tribunal found it lacked jurisdiction and dismissed all claims of claimant. It also ordered the claimant to reimburse Korea $3.4 million US in cost plus interest. This outcome was made possible by Korea's ability to construct and sustain a coherent legal theory across 4 years of arbitration proceedings, requiring close coordination between the Ministry of Justice and financial regulatory authorities. It also affirms a principle important to the integrity of the ISC system. Unlawful investments should not receive treaty protection. The next case is the Lone Star case, which is Korea's milestone case, because this is the largest claim ever brought against Korea. Also, this is my another case which I took the lead. In 2012, Lone Star, a US Texas-based private equity fund, brought a claim of $4.68 billion US arising from financial, regulatory, and tax measures related to its exit from a Korean exchange bank investment. The claimant argued that delays in financial approval and the imposition of tax liabilities reduced the value it was able to realize from the sale of the bank. The 2022 award rejected most claims but ordered Korea to pay $216 million plus interest. On 2023, both Lone Star and Korea initiated exit annulment proceedings. Statistically, as you know, the chance of fully annulling an exit award is roughly only 1.6%. However, my team and I identified a fatal procedural flaw. We relentlessly argued that the original tribunal seriously violated the fundamental principle of due process by relying on a separate ICC commercial arbitration award without giving Korea, which is a non-party to that arbitration, the opportunity to contest the evidence. On November 2025, the Exit Committee annulled the award, retroactively extinguished Korea's whole liability. The Exit Committee found that the tribunal had relied on findings from a separate ICC commercial arbitration to which Korea was not a party, without giving Korea a proper opportunity to respond, a serious departure from fundamental procedure rules. But we did not stop there. Leveraging our institutional agility, we executed a highly proactive enforcement strategy, issuing a demand letter that resulted in the full recovery of our $5 million legal cost in just 29 days from the annulment decision on December 2025, which is the fastest recovery in Korean ISDS history. And third is the Elliott case. Elliott, another US private equity fund, brought a claim exceeding $1 billion, alleging that the Korean National Pension Service voting right exercised in a corporate merger between Samsung C&T and Cheo Industries harmed the value of its shareholding in Samsung C&T. The 2023 tribunal award partially ruled against Korea and awarded damages. In 2023, Korea challenged the award before English courts. After an initial dismissal, it appealed successfully and ultimately prevailed at the limited English High Court hearing. On February 2026, the court accepted that the National Pension Service does not constitute a state organ for attribution purposes under IOC draft articles, extinguishing Korea's liability, and the case was remitted to the original arbitral tribunal. The decision to continue proceedings through multiple adverse outcomes was taken within the interministerial committee, which I've mentioned earlier, that is a level senior enough to be accountable for decisions involving significant public funds and to sustain a consistent legal position across stages. And finally, the Schindler case. This is another case I took the lead. Schindler, a Swiss-based global elevator company and a minority shareholder in a Korean company, Hyundai Elevator, brought a claim of $216.9 million, alleging that Korean regulators failed to adequately protect its investment. The claimant alleged that Korean financial regulatory authorities and the Fair Trade Commission failed to properly exercise their supervisory and enforcement powers in relation to transactions involving Hyundai Elevator. The claimant argued that these authorities failed to prevent or adequately address transactions that benefit the controlling shareholder group at the expense of minority shareholders, thereby causing a decline in the value of its investment. This case involved highly complex financial issues regarding derivatives and corporate governance. In my capacity as team leader, we even faced a critical moment when our key witness fell ill right before the Hague hearing. However, utilizing our experience, we swiftly secured permission from tribunal for a video examination, ensuring our defense remained rock solid. Through flawless coordination between the Ministry of Justice and other related financial and fair trade authorities, we provided indisputable evidence that our regulatory actions were legitimate, non-discriminatory, and not taken in bad faith. Just last month, in March 2026, the PCA tribunal unanimously dismissed all claims on the merits, finding that the authorities' measures were legitimate regulatory actions, neither arbitrary, discriminatory, nor taken in bad faith, and firmly protecting our state's right to regulate. We also secured an order for Schindler to reimburse our cost of $6.5 million and succeeded to secure the full amount of payment from Schindler just a few days ago. The result was supported by coordinated institutional effort. The Ministry of Justice led the evidentiary strategy, while relevant regulatory agencies provided detailed factual records and technical explanations in enabling a coherent, well-structured defense across institutions. The whole of government defense approach can effectively support the defense of legitimate regulatory action under international law. And Korea's accumulated experience has also highlighted legal gaps in our existing framework, and we are now moving to address them through legislation. While these victories are historic, our Korea system currently operates based on administrative presidential directives. To build a truly unshakable foundation, Korea is advancing legislative reform. Just weeks ago, in March 2026, a new bill on the prevention and response to international investment disputes was proposed in our National Assembly. This landmark bill addresses key institutional gaps. First, budget accountability, requiring the triggering authority, the agency whose measures triggered the dispute, to bear legal and arbitration costs and damages, directly linking accountability with financial consequences. Second, expanding institutional coverage, extending the framework from the executive branch to all branches of the whole state, including the legislature and judiciary. Third, enhancing data collection authority, establishing a statutory basis for requesting and collecting information from all relevant agencies. Fourth, 5-year strategic planning, requiring the Minister of Justice to formulate and implement a basic plan for ISDS prevention and response. And fifth, professional capacity building, establishing a legal basis for designating specialist ISDS training institutions and providing governmental support to build a sustained pipeline of qualified ISDS professionals. We believe this legal codification is the ultimate blueprint for sustainable ISDS management. Before concluding, I would like to offer a brief personal perspective on mediation, drawing from my recent academic research named New Horizons in ISDS, a study on measures to promote mediation. This does not necessarily represent the official view of the Korean government. I want to step back briefly from the case-by-case perspective and reflect on a structural challenge that Korea and many respondent states face. Why does mediation remain so underused in ISDS? And what can we do about it? The intuitive answer is that settlement agreements are hard to enforce internationally, but I would argue that that misses the real barrier. The deeper problem is political and institutional. Government officials face genuine risks, post-audit scrutiny, potential criminal liability, and political criticism when they consider settling rather than pursuing arbitration. These pressures create a structural bias toward arbitration, even when mediation might serve the national interest better. Think about it. Arbitration offers officials a kind of cover. If Korea wins, it's a victory. If Korea loses, it was the tribunal's decision. But a settlement that requires an officer to stand behind the compromise, and that is a much harder position to defend domestically. This suggests that if we want to revitalize the ISDS mediation, the priority should be institutional design that gives officers the political cover they need to settle rationally. Two concrete measures stand out. First, incorporating mandatory mediation clauses in IIAs, the investment treaties, as a precondition to arbitration, making mediation a default step rather than an optional one. And second, making greater use of evaluative mediation, where a professional mediator assesses the objective probability of success and the reasonableness of a settlement, drawing on the authority now available under Rule 21.4 of the 2022 Exceed Mediation Rules. A credible expert assessment gives officials substantive grounds to defend a settlement decision against domestic criticism. The international community is moving in this direction, as we've already discussed today's sessions, through the UNCITRAL guidelines and model provisions and the 2022 exceed mediation rules. In Korea, the legislative framework I described in the previous slides by establishing clear legal authority and budgetary grounds for mediation is expected to address the political cover problem. And in this slide, that is my article's abstract. And to be clear, mediation is not a replacement for arbitration. It is an essential complement. Revitalizing mediation alongside a strong arbitration response capacity is how the IAC system becomes more cost-effective and future-oriented for respondent states and investors alike. Conclusion. The Republic of Korea's recent consecutive ISDS victories proves that successful ISDS defense requires more than just hiring top-tier international law firms. It demands strong, dedicated internal leadership, rigorous interagency coordination, and deep in-house expertise. There are three key takeaways. First, institutional architecture matters. The three-level structure enables strategic control and operational continuity. And second, in-house legal expertise is indispensable. It is what allows effective direction of external counsel. And third, legislation provides the foundation. Statutory frameworks deliver clearer accountability, broader coverage, and I'm going to keep. Okay. Sorry. Okay. Yeah, that was my number three. Legislation provides the foundation that can give broader coverage and stronger tools than administrative directives alone. And as I reflected in the mediation section, mediation is not a replacement for arbitration, but an essential complement. And institutionalizing mediation requires the same kind of deliberate legal and structural reform that Korea is now pursuing. We welcome your questions and comments. And thank you so much. We are looking forward to exchanging views with all over the colleagues from across the region, and my contact information and LinkedIn are on the screen, and I encourage you to reach out every time, whenever you want. So thank you for your time today. Thank you.
One question.
I must congratulate you. It's a very impressive approach. We always hear that the countries are not doing something, but what you have done is remarkable.
Thank you.
My country lost one case and they withdraw all the BITs. But you have won all four, 100% strike rate. I just have one question on your first case.
Mm-hmm.
In that one, you said that Korea recovered the money from the investor. So in that case, did you file counterclaim and therefore you recovered, or was there any other thing?
That's a very great question, because you mean the first case is the Chinese investor main case, right?
Yes.
Actually, in that case, the Chinese investor refused to reimburse the cost and commenced the exit annulment proceedings. So now, in that case, the exit annulment proceeding is ongoing. And then the investor didn't pay the legal cost of Korea yet, but we are doing our enforcement measures in the China, in the Chinese court. But as you know, it's the first case in China, which is the exit award is on the enforcement issue. So there is a bit of hard procedure in the Chinese court, but we are do our best to collect that payment from Chinese investor. Yeah.
Thank you very much, because I knew something was going on in China.
Yeah.
Your recovery process. So I was a little confused that you have already recovered the money or something else. So was it a counterclaim?
Yeah, we didn't raise a counterclaim, but I'm really interested in the counterclaim because that's my other thesis theme. So yeah, if you have anything you want to discuss about the counterclaim, I welcome you.
No, we want to learn from you.
Thank you. Yeah.
Okay. Let me ask one more question. It's really amazing and quite impressive because when I was a government officer, I was also engaged in these the claims. At the time, it was a kind of beginning stage. We didn't know about how to deal with these cases. But finally, I got a very successful cases recently. It's a really great achievement. From a developing countries' perspective, I think Korea's law is really miracle. Remarkable. So I think the Korea case should be shared with the developing countries. For that purpose, I have one question. How long does it take for Korea in-house, actually inside the lawyers to familiarize your capacity with these cases? And then finally, and what time you are ready to standing alone without relying on the external counsel like domestic countries' law firms? Please explain how long does it take? What kind of process did you take to be nicely now deal with these important cases with your own capacity, please?
Okay, thank you. That was a great question too. And as for our KMOJC Now's lawyers, they are already the experts of international law because they almost has their own degree of international law. But as you mentioned, the ISDS cases are very unique because that's not common compared to the international arbitration cases. So I think it normally takes around 1 year to be familiarized with the specific ISDS cases. Just for your information, for example, in the Lone Star case, it took around 13 years to be concluded, including annulment procedure. And just imagine how many records will be there in the Lone Star case. It is amounting to 2 terabytes of USB files and folders. And there are too many records to read and study. So I think it is approximately needs at least 1 year to catch up those kinds of records. And also regarding the dependence on external counsel, actually, and realistically, it would be very hard to do that because we have a very limited resource of personnel and also budget. So we only have around 10 attorneys in our KMOJ's ISS division. But if our attorneys, we can recruit more attorneys, maybe hundreds of attorneys, then I think we can replace the external counsel. But now we have a lot of ISIS cases, not only those 4 cases, but we are still other pending cases. So it is very hard to handle all the cases at the same time with those limited resources and limited personnel. So I think the governmental funding and governmental support will be crucial and necessary to our division. Yeah.
Are you concerned that your robust challenge to claims will itself deter some investment?
Yeah, I personally hope so. Yeah, that's a good point. Yeah,
that you might put some investors off investing because they know that you would challenge any claim so robustly. Is that a concern?
Concern for investors because it can detract the investment in the FDI in Korea, right? But actually, that's I think that's similar to double-edged sword because we are vigorously challenged the award, as you know, and we've succeeded on those annulment and set-aside proceedings in the legal context. But as you've mentioned, I'm not sure if it is good to cause more FDI in Korea, but we are going to consider it about the relevant agency and ministry, about that concern. Thank you.
But on that question, is that a kind of investment that you would like to attract in Korea anyway? I mean, the investors who might be, how do you say, a doubt about investing in Korea because of your activism, maybe investors that may be troubled, troublesome to have anyway, right? Because I could claim that your defense shows that you are a country that has obeyed by international obligation. I mean, that the result of the fine of the most ISDS cases have been in your favor.
Right? But actually, we love investment. We love FDI, and as you know, the BIT and IIA is to promote the investment each other's. But I think just we've challenged the award, or if we have won the ISS cases consecutively, I think that will not hinder the FDI investment in Korea, because as you know, Korea is very pro-investor and pro-investment country, and also our Korean nationals and Korean companies also invested a lot in other foreign countries. So it is very important to have a mutuality between all other countries, and I think our recent ISS victories is a bit of distinct from that FDI issue, because I think it will not hinder, or it will not decrease the FDI, and I really hope so.
Okay, let me jump in because we have a time limitation. Actually, I expected that kind of reaction from audience. Tomorrow we have a special session, ISDS. Therefore, please utilize that opportunity for further questions. Let me invite Armenia for your presentation. But actually, I'm sorry, there is a time limitation. Please.
Okay. Yeah, thank you.
Let's wait for the presentation to be on the screen. Anyways, I would like to use this opportunity that the presentation still is not on the screen and ask the announcement guy, please don't interrupt me. Well, just to quickly introduce myself, my name is David. I'm from the Center for Legislation Development, which acts as a think tank for the Ministry of Justice. And one of our main responsibilities is to carry the policy development and policy reforms when it comes to the alternative dispute resolution mechanism in our country. And I would say this is my beloved part of the job that I do, because ADR is something that's here and here. So I would like today to give you a very quick review or overview of the development of mediation in Armenia. And later I would like to welcome your remarks and also your positions of what we have done right or what we have done wrong, so that we can also learn from our own mistakes and develop the mediation further in Armenia. In order to do so, let's quickly just go through the historical overview. So the mediation, legally saying, we didn't have legal framework for the mediation until 2015, and only in 2015 we have got loan mediation and also provided some incentives in the civil procedure code for the mediation procedures to take place. Mainly we said that there can be a court established mediation, which should be 4 hours and which should be free. So mediators were working free of charge without receiving any remuneration for their work. And you know what happened? After 1 year, no mediator started to work because it was free. And out of around 50 mediators who were accredited back then, only 15 stayed in place and continued their operations. Therefore, we started to think what to do. And then in 2019, we have came with our new strategy on judicial and legal reforms. And there we have envisaged some actions that we need to carry out regarding the mediation as well. And it didn't work back then in 2019 because some things happened in Armenia. A new government was elected with an extraordinary procedure. And with the new government, again, we established in the strategy for the 2022-2026 that we need still to continue on the reforms with the mediation. And here, when everything has started, because at that year in 2022, we have drafted the new law on mediation, where we have also provided that the mediation should not be free of charge anymore. This was very important. And most importantly, we have provided numerous important things, including the mandatory mediation for the family disputes. Certain family disputes are now need to be undergo mandatory mediation processes in Armenia before going to court. And it was really helpful. I will show later in the numbers. The next stage that we have done was the 2023, the year of 2023, because that year we have established the Arbitration and Mediation Center of Armenia. As I mentioned, in